Good morning, Ms. Jaji.
Good morning, DCJ.
How are you?
As well as can be. Under the circumstances.
Yes, no, just relax. You will be fine.
Thank you, DCJ.
You hold 2 law degrees, a BProc and an LLB from the University of the West. Then what is UNIPO called now?
University of the Northwest, DCJ.
Of the Northwest, yes.
Yes.
UniWest is the acronym.
Yes.
Okay. You started your career at the sidebar. You were an attorney for how many years?
After admission, I practiced for about 2 years with the firm of attorneys, and then I went to the law clinic as supervising attorney for a year. Yes, so it was about 3 years, DCJ.
All right. And then you chose to go the route of the bench. You became a magistrate.
Yes, in fact, when I was in the law clinic, one of the students that was doing the course I was supervising was a magistrate. And he then said to me one day, you know, the way you are presenting the class and dealing with the disputes, you might be fit for the bench. And I thought about it, and I applied, and the rest is history.
All right. You were appointed as a magistrate in 2001, held that stint until 2004, and then became a regional magistrate in 2004 still.
Yes, this is
which is where you still are. I'm sorry. We had a grueling week last week, and the weekend was no better for me, so you'll forgive me if my head is everywhere.
Okay,
You were a regional magistrate until 2016.
yes, DCJ.
And then you were appointed as a judge in 2017.
Yes.
Okay. You have acted in this position which you seek now, the position of Deputy Judge President in the Northwest Division was it for a term in 2019?
Yes, I acted in 2019 for a term, DCJ, but subsequent to that, when the JP assumed office in August, his first order of business was to appoint me as the acting DJP for the division. So I'm currently the acting DJP of the Northwest Division, yes.
How have you found that experience? Or what has it taught you? What has it shown you?
It has shown me that I do have the required skills to lead and to manage and to guide as well, as I have experienced from practice and from the time I was a magistrate. Because when I was in the law clinic as the supervising attorney, I had the responsibility to oversee the day-to-day running of the law clinic. And I had to make sure that files are kept properly. In addition to supervising the students as well, I had to compile the statistics for the cases that we were dealing with in the law clinic, on top of supervising the students as well. At that time, the post was a funded position, so I had to report to the funders about what was happening in the law clinic. So I had to compile reports as well in relation to that. So that's where I first started to test my skills, whether I could lead and manage. And then as a regional magistrate, I was in what we call a one-man station in the regional court, where I was the only regional magistrate sitting in a court, and that was in Lichtenburg. I managed the court, I chaired the case flow management meetings, interacting with the relevant stakeholders to see to the day-to-day smooth running of the court. And now acting in this position as well, it has also taught me humility as well, and to be open-minded when dealing with people, because in that position, at times you even have to be a leader to people who are more senior to you, and you have to have the proper temperament to be able to deal with those people. And basically, that's what I've learned in this position, DCJ.
Well, you are borne out by your colleagues in the division who've done something unusual and nominated you.
Yes.
Did not just nominate you, wrote a glowing testimonial for you. So it does appear that you're doing something right there.
We are a family, DCJ, in that division. You know, if you want a true definition of brothers and sisters, you should come to the Northwest.
That is the sense one gets. Well, that's very good. I hope the other divisions can replicate that collegiality which the Judicial Code of Conduct requires of us.
Yes, DCJ.
I saw something quite interesting in your CV. You attended a Stephen Covey leadership workshop. I mean, he is the doyen of leadership etiquette. Where was this?
Yes, this was a workshop that was arranged by the former CJ, Mogoeng. He was the JP then in the Northwest. He arranged a workshop for judges at that time, and he invited the regional magistrates to attend that workshop. It was on the 7 habits of leadership.
Yes.
Yes, very interesting workshop.
I
But
can
it's some time
imagine.
ago, yes, DCJ.
You are one of the network judges on the Hague Convention on the Rights of the Child. Do you still hold that position now?
Yes, I still do DCJ.
Okay. What is the gender and race composition of your division?
We are a composition of 7 judges, but currently DCJ, we only have 4 permanent judges in the Northwest Division. And of the 4 permanent judges, we've got 2 women and 2 males. I'm the only black female in the division, and we've got a white female, and then we've got 2 colored males. And we have 2 acting judges currently, and it's 2 black females that are acting in the division.
So you are on a rebuilding mission, as it were.
Yes, DCJ.
Okay. There are 3 complaints that were lodged against you with the Judicial Conduct Committee.
Yes, DCJ.
I am not going to ask you about 2 because I know that rulings have been made there and they will be issued probably today even, and you were absolved. Those are the matters of complaint lodged by Mr. Mbembe against you and the retired Judge Lieu in connection with a case you had.
Okay.
And the other one was lodged by Mr. Molanto against a full court matter in which you sat with acting Judge Peterson and again the retired Judge Lieu. The one that remains outstanding is one lodged by Mr. Patekile against you.
Yes,
And Judge Lieu again, and I mean,
Yes.
these are complaints that were lodged by convicted parties who were aggrieved with the result of their cases for one reason or the other. All 3 serving
Sentence.
terms of imprisonment, yes, somewhere. Do you recall the one launched by Mr. Patekile, and can you just tell us briefly what it was about and at which stage it is, if you know?
Okay. Yes, the one of Mr. Patekile, he was an accused before me in 2016. When I was sitting on circuit in Mokwasi, I convicted him and his co-accused and sentenced him. This year in August, I was made aware of a complaint by him against me. The first complaint was that I refused the prosecutor to call certain witnesses in the matter. And the second complaint was that I colluded with the police and the state to have him convicted. And thirdly was that I was refusing to have the record of the proceedings transcribed and reconstructed so that he could get the full record of proceedings. So when the complaint was brought to my attention, I then called for the file because the first two I know that I could not really do anything about. The fact that he's accusing me of having colluded with the state and the police. I dealt with that matter. I gave judgment in it. If he was not happy, he could have brought an application for leave to appeal, which was never brought to my attention. But the one that I was concerned about was the fact that he was accusing me of refusing to give him the record of proceedings. I then requested the registrar of our division to bring the file to me. And immediately when I asked for the record of proceedings, it was there in the file, complete. And I replied to the complaint that the record of proceedings is in the file and it's complete and it's available for Mr. Particular to access it. And that is as far as I could take it. I could not give him advice on what he could do once he's got the record because he was represented during the trial. He was also at the time when he wrote the complaint. No, the complaint was just an affidavit. But I just highlighted the fact that the record is there and it's available for him to access it and take whatever necessary steps that he can take.
Well,
and I have replied and I'm still awaiting the outcome.
All right.
Yes.
Well, a record of court proceedings is never for the judge, the presiding judge to give anyway. That's something to be
Yes.
dealt with the registrar of the court.
Yes,
Yeah.
that's why I'm saying it was not even brought to my attention that he was looking for a record and whether the record was not complete or not complete. If there was a reconstruction that was required, it was not. The only time I heard that Mr. Particular had a problem was when the complaint was brought to my attention.
Do you have any reported written judgments?
Yes, in my application, DCJ, I've stated the S versus Mataba case. That is a reported judgment that deals with DNA evidence.
Is it the only one?
Yes, that's the only one so far, DCJ.
But have you written other judgments that have not been reported?
Yes, a lot, DCJ, a lot of judgments.
Okay. Do you have any reserved judgments?
Currently, yes, I have 3 reserve judgments, but I'm still within the norms.
All right.
Yes, it's recent judgments that I've reserved, DCJ.
Okay. Well, I'm asking particularly about the ones that are listed in your application form, some
Okay.
which were had in May.
No, those ones have been handed down, DCJ.
All right.
All of them, yes.
Okay. What is your record in terms of producing judgments? Do you generally deliver them promptly or do you delay them?
Generally, I deliver promptly, DCJ, yes. If I would say I have a delayed judgment, it would be about 3 months and a couple of days or a couple of weeks, 1 week or 2 weeks. But I've never gone beyond 4 months, DCJ.
Well, perhaps to round off and not to be a Scrooge, I should mention that the law bodies who have commented on your suitability for this position all laud you for various things, including the role you play in mentoring everybody who happens to be around you, from from those aspiring to join the professions to your colleagues.
Yes,
So
DCJ,
keep
I'm very
that up.
passionate. I'm very passionate about that, yes.
All right. Thank you so much, Judge Jaje. I'll hand over to the floor to question you, starting with your JP, Judge Hendricks. Judge Hendricks, are you ready?
Yes, thank you very much, DCJ. Good morning, Judge Jaje. How are you?
I'm fine, JP, thank you.
Thank you.
How are you?
I'm fine, thank you. Thanks for
Okay.
asking.
Thank you.
You mentioned that you acted previously in the position of as Deputy Judge President. That is April to June 2019.
Yes,
And
JP.
you are also currently the acting Deputy Judge President.
Yes, JP.
Yes. Now, how do you see your role as Deputy Judge President in our division? In other words, what does it entail and what is your vision?
Okay. As the Deputy Judge President in the division, my role is to support you as the JP, to understand your vision as the JP, and to align myself with your vision. And I do understand what your vision is, JP, in the division. And ever since I've been acting, especially now after appointment in August, I have strived to align myself and support you as the JP of the division. And in terms of the Act, the role of the JP, in terms of the Superior Courts Act, the role of the DJP is to perform functions and duties that are assigned to the DJP by the JP. And also, in the absence of the JP, to lead the division. And that's what I intend doing if I'm appointed in this position, JP.
Yes. As recently as last week, I was out on circuit in Garankuwa, and you were in charge of the division.
That's correct.
You had to allocate cases and to manage and report back to me.
That's correct, JP. I
Yes.
did that.
Now, we do have challenges at the main seat in our court. And we also have challenges in the lower courts.
Yes.
Now, I have visited Mokwasi, Tlabani, and Rustenburg, and I also reported on that. And you visited Ganyesa.
Yes, I did visit Ganyesa,
Yes.
JP, and I did find that there are challenges in that court. I've discussed them with you. I don't know if you want me to go into those challenges that there are.
No, I don't think
It's
it's
not
necessary.
Okay, all right.
But even Potchefstroom, we face with challenges there, and you are aware of it.
Yes, I am aware, JP. As recent as last week, I spoke to the head of the office of Potchefstroom to find out how the courts are performing and how they are dealing with those structural challenges.
And we need to visit all the lower courts in the province.
We are in the process of doing that, JP, and we will be visiting all those courts.
Yeah. Now back to our main seat, the challenges there. Did you visit downstairs at the records office?
Yes, I did,
And what are
JP.
the challenges?
The challenges that we have in the records office, it's filing space. We have a lot of files and we do not have enough space. However, through your initiative, JP, there are measures that are put in place now to create more space. We've got what we call consulting rooms, robing rooms for counsel in each court, and those rooms can be utilized to create more space for filing. There was also a challenge of the capturing of files when they come back from the typist, because the ladies who are doing the capturing were only using one computer. And I remember on a day that myself and you were taking a tour downstairs, we immediately called the IT official to come and address that problem, and he attended to it. He made sure that a second computer was installed so that the capturing process goes faster.
Thank you. And there are also backlogs, and we are in the process of dealing with them through pre-trials and case flow management. Can you please elaborate on that?
Yes, JP, we indeed do have backlogs, and one way of us dealing with those backlogs is through case management. As acting DJP, I have that responsibility of doing the pre-trials in the division from Monday to Wednesday. And as and when I go through the pre-trials and find those backlog cases, I bring them to your attention so that they can be case managed. Some of them I have case managed to make sure that they are brought to finality. We are definitely dealing with the backlog. We also have a backlog as far as the criminal trials are concerned, and that is why you even had to go on circuit for the past 2 weeks. And we have a meeting that we need to discuss how to also deal with those backlog criminal cases on circuit.
Yes. Thank you very much, DCJ.
Thank you, Judge President. Premier, Let me first take this opportunity to welcome you to the proceedings. I'm sorry I did not acknowledge you previously. I did not see you. Go ahead.
Good morning, DCJ. Good morning, ladies and gentlemen. Good morning, Judge.
Good morning, Premier. How are you?
It rhymes nicely, Judge.
Thank you, Premier.
But firstly, out there in the Northwest, there's a perception that law enforcement agencies and the judiciary are slow in dealing with corruption cases. What do you think the judiciary should do to dispel and disprove this perception?
Thank you, Premier. It is a concern and a valid concern indeed. As soon from the judiciary side, we can only be involved once the cases have been brought to the court. And once the cases come to the court, as I was alluding to before, we've got a pre-trial process. And we pre-trial cases because we want to see how ready the matters are. And we ensure that there is compliance so that matters can start promptly and be finalized immediately. Not at the same time, but we can strive to ensure that matters start and they are tried before court and are finalized as soon as possible so that we can instill that confidence by members of the community in the judiciary. Because once we lose the trust of the community, then we might as well pack up and go. So from our side, what we can ensure is efficiency of the courts in finalizing those type of matters.
Thank you.
Thank you, Premier.
We will be introducing the traditional courts soon in the Northwest.
Yes.
What do you think should be the relationship between the judiciary and the traditional courts?
Thank you, Premier. Yes, I am aware of that process, and the traditional courts, I know that their appeals are dealt with in the magistrates' court. And the relationship that can be created is that of coordination and working together. And if there is a need for training as well, there should be training of the presiding officers in the traditional courts. This done so that as they would be courts dealing with disputes, we need to have communities having confidence that their disputes will be resolved. And for you to have confidence that your dispute will be resolved, you need to believe in the capability and competence of an institution. And we can do that by also introducing some kind of training for the presiding officers in those courts as well.
Very much. Last question from my side. I think your appointment will greatly improve gender representation in the division. But I think much must still be done to broaden that gender representation. And what do you think is going to be your contribution towards that objective?
You are right, Premier. Definitely, we still need to do much. For the fact that I'm the only black female in the division is concerning. And to invite acting judges, it's the prerogative of the judge president. But as a deputy judge president, because I have seen that he's an inclusive leader, he does discuss with me, and I can advise and discuss and suggest to him how we can approach this. In fact, what I can say to you, Premier, that as we speak now, what the Judge President has said and has done, I know for sure that he has done that. He has written to various law bodies to give him a list of people that can come and act in the division, especially black women. And that is why I'm saying that we currently have 2 black females that are acting in the division. So we are moving in that direction, and soon the picture will be different.
Very much, Judge. day.
Thank you, Premier.
Thank you, Premier.
Commissioner Dodovu?
Thank you very much, DCJ. Good morning, Justice Jaji.
Good morning, Commissioner Dodovu.
Thank you. I'm going to ask you two questions, and these questions, I asked them to your predecessor, Judge Hendricks, in 2019,
Okay,
when he applied for the same position
okay.
that you are applying for. The first one, to become a DJP is a senior position, a leadership position within the division. And there are systematic issues that are facing the judiciary, like, for example, the backlogs, the delay in issuing judgments, the language that the judges are using, the modernization of the judiciary itself. If you can be placed in that position of DJP, what do you think would be the improvements and innovations that you can bring forward to address those areas?
Okay, thank you, Commissioner. Firstly, you mentioned the issue of judgments, delayed judgments, and the language that is used. Judges speak through their judgments, and if you cannot write a judgment, then it's a challenge. We do have training by the South African Judicial Education Institute that does from time to time hold training on judgment writing. However, as a DJP, the other role that I would play is that of mentoring and guiding acting judges and other judges as well. And from time to time, we need to hold discussions, even if they are just informal, just concerning judgment writing, and share skills that can enable us to deal with judgment writing. And that would also include not interfering with the style of writing, because a person's style it's a style and you cannot interfere with that, but the manner in which the judgment is written, because at the end of the day, it becomes the judgment of the division and not an individual's judgment. So sharing skills and tips on how to deal with that will be one of the priorities that I will be doing. In fact, currently what we do is that we always say 4 eyes are better than 2. So once a colleague has written a judgment, they would bring it to either me or the JP and would ask for my comment on that particular judgment. And in that way, one is able to make inputs and suggestions on how to approach certain issues. So it is happening, it's ongoing, and I would continue doing that as well. As far as modernization, you mentioned that, Commissioner, we have all, as I said, we've got 4 permanent judges in the province. All of us, we've attended the case line training by JP Mulambo, and all that we're waiting for is the rollout. I believe that we are all capacitated to deal with matters on the virtual platform. In fact, we do from time to time have matters that we hear on the virtual platform. And if that can be rolled out, case line can be rolled out in a division, it will also assist with the filing space that we need so much, because we have files all over. It will really assist. But we are ready, and if it can be rolled out tomorrow, we will hit the ground running.
Thank you. Second question. There's been a talk to have a second court in the area of Klerksdorp, Potchefstroom, an area which is infested by gangsterism and lately zamazamas. And in my respective view, I think that is needed. What could be the impediments to the establishment of the second court, or is it still in the pipeline to ensure that it is there in an area that is having so many criminal activities taking place?
Okay. Thank you, Commissioner. Currently, there is a circuit court that is sitting in Klerksdorp. I think maybe what we need in Klerksdorp is a local division. Yes, and...
I meant the local division.
Oh, local division, oh
Not
yes.
the second court,
no.
per se, yeah,
Oh, okay.
local division.
I agree with you. Klerksdorp is a very busy place, Commissioner Dodovu, as far as criminal cases and civil cases are concerned. I am aware that the JP has, as recent as around the 25th of September, compiled a report on the, should I proceed? Okay, all right, thank you. Yes, the JP has compiled a report on the rationalization of courts in the province. And in that report, he has proposed that there should be a local division in Klerksdorp with additional judges appointed so that they can deal with the workload in Klerksdorp. In the meantime, we have a circuit court that sits in Klerksdorp from time to time. The JP as well has also shared his vision that he would like to have some of the unopposed motions heard in Klerksdorp because there is a lot of work that comes from that area, Klerksdorp and Potchefstroom, Commissioner.
Thank you, DCJ.
Thank you, Commissioner. Commissioner Moimang?
Thank you, DCJ. Good morning, Judge Kaja.
Good morning, Commissioner Moimang.
Just 2 questions from my side, but both of them are based on the judgment that you gave in the matter between Piedmont Global, the chairperson of the Northwest Gambling Board.
Yes, Commissioner.
The interdict that was granted by the court on the 20th of March 2018, following the objection that was lodged by the applicant to the gambling board on the I think it was in 2016. Don't you think that sometimes courts needs to be more cautious in terms of granting interim interdicts? The second one relates to the reasons that you advance for dismissing Piedmont's application. I think my understanding is that you were a bit cautious in terms of interfering with the process set out by the decision maker, in this instance, the board, and also you were cautious in terms of interfering with the work of the executive. In a nutshell, you exercise judicial restraint and deference. What is your understanding of judicial restraint and judicial activism? Thank you.
Thank you, Commissioner. On the first question of courts being cautious when granting interim interdicts, what I know, Commissioner, is that we have requirements of an interim interdict, and that is what the court dealing with such a matter should be looking at, whether the applicant has satisfied those requirements. And once the court is satisfied that the requirements are satisfied, then the decision has to be made. And that is as far as I can take it. In the Piedmont matter, I understand your question to be, what I understand to be judicial difference?
Yes, because you dismissed the
Yes.
application
Okay, all
by
right.
Piedmont to challenge the decision to award the casino licenses.
Okay. Firstly, as judges, Commissioner, we deal with matters according to the facts that are before us. And maybe, in fact, I should also state that the DCJ sat on appeal in that matter, so she was one of the judges forming the panel in the Supreme Court. But what we do as judges when we sit with matters, Commissioner, we consider the facts and the circumstances that are before us. And we decide the matter based on what we see. And in that matter, it was a review application to review the decision of the board. And I could not find any reasons that the board was wrong in its decision. And that is how I decided the case and dismissed the application of Piedmont. I don't preside in matters with fear, Commissioner. I hold the oath of office dear and close to my heart. And whenever there is a need to find that a decision by the executive was not proper, I will definitely deal with that aspect properly, Commissioner.
Thank you, Judge. Thank you, DCJ.
Thank you, Commissioner. Just on the merits of the Piedmont trilogy, because it was actually 3 massive matters that you had dealt with there.
Yes,
I can confirm that the SCA confirmed your thinking and conclusion resoundingly. Well, one does not know what the Constitutional Court will say if the matter goes there, but the SCA endorsed your good thinking.
And in not just the SCA, DCJ, senior judges of the SCA,
Yes.
DCJ. So it was a boost of confidence. And for me, having sat alone in that matter for 3 days,
Yes.
and the SCA, 5 judges sitting for 2 days. So it was really a boost of confidence.
Well deserved.
Thank you, DCJ.
Commissioner Makwanesh?
No, thank you very much, DCJ. Good morning, Judge Ali.
Good morning, Commissioner Mangwanisha.
Yes, according to you, what are the 4 strategic challenges facing the judiciary in the 21st century?
Firstly, it's, I would say, confidence in the judiciary, competency, if the judiciary is competent to deal with matters, modernization of the courts in the current times, and I would also state structural challenges that we face in our courts, Commissioner.
No, thank you very much. Have you ever been in a situation where there was a strategic misalignment between the leader and the other colleagues? And if yes, how did you intervene and what were the results?
I would say in the High Court, not really, Commissioner, but if I think back to the Magistrate Court, there was an incident where there was a dispute between a colleague and the Regional Court President at that time. May her soul rest in peace, she's passed on. And what I did, I spoke to the colleague first to hear what the issue was, and discussed with the colleague on how to approach the issue, because confronting the leader was not the appropriate way to go about it, because once a person is your leader, you must show some kind of respect to that particular person. And what I did with the colleague, I requested him to show some kind of respect and calm down, because the other thing is, if emotions are running high, one is not able to control the way you would deal with an issue. And I then requested that colleague that if you are humble and you are calmed down, you are able to approach and reason your complaint well with the president. And fortunately, that is what happened. The colleague did listen. Even though I was young in the regional court, but I did command some kind of respect from my colleagues. When I joined the regional court, I was 30 years old. And I had colleagues who were much senior and much older. And this particular colleague was much older than me. But he did listen and approach the matter the way I suggested.
Thank you very much, DCJ. Thank you, Judge.
Thank you, Commissioner.
President Petse?
Thank you, DCJ. Good morning, Judge.
Good morning, AP.
One of the challenges currently plaguing the judiciary is partly heard cases that seem to drift on and on and on without proper management, something which has the potential to bring the administration of justice into disrepute.
Yes, AP.
Could you please enlighten this commission as to the current status of the partly heard matters you have listed in the questionnaire under paragraph 17?
Okay.
I see three of them.
Yes, I had listed 3 partly head matters, AP. One of the matters has been finalized. The other 2 matters are very long matters. The one of Malonga, if I'm not wrong, it's a matter that's got 32 counts, ranging from murder, robbery, attempted murder, possession of firearms. And the other matter, it's the Mpembe matter, which is the Marikana matter, where the police have been charged. Those are very long cases. The challenges that we have in those matters, in the Mpembe matter, it's because the counsel representing the accused are all private counsel, they're not from legal aid. It becomes a challenge to arrange dates with them. But as a presiding officer, at times I have to put my foot down to have them agree to dates that we can proceed with the matter. The challenge that we had lately was that one of the accused was not well and we could not proceed with the matter. However, in our division, a small division as ours, it becomes difficult for one to sit for a long period in a criminal trial. Because if you only have 5 or 6 judges in a division and you sit in the criminal court for over 3 weeks, it means you are removed from doing other matters in the court and your colleagues become overstretched with work. So the few judges that we have also, it creates a problem for one to finalize. However, there are measures that I do from time to time try and adopt to have matters finalized, and that is that I would set matters down during recess to push those matters. However, there are just some issues that come up that are beyond my control, and no matter how hard I would put my foot down, I'm not able to succeed.
But shouldn't the proper plans be put in place to ensure that once a trial has been commenced, then it is brought to a conclusion within a reasonable time and as expeditiously as possible?
Yes. AP, I can confidently say to you, we really strive to have matters finalized as expeditiously as possible in the division. In fact, if we look at the cases, the part-head matters that are not being finalized, those would be your very long and complicated matters. But if we could, really, if we could, we would have a judge sitting in a criminal trial for more than 2 or 3 weeks to have that matter finalized, especially these long matters with a lot of counts. However, with the shortage that we have, it is not possible. But I agree with you, AP, if measures can be put in place, we have more judges in the division, then I have no doubt we will definitely achieve that.
Thank you, Judge Jajai.
Thank you, AP.
DCJ.
Thank you, President. Minister?
Good morning, Judge.
Good morning, Minister. How are you?
I'm very well. I only have one question. With the pilot project on the digitization and modernization, it was chosen for Gauteng and the Northwest.
Yes, Minister.
What will be your role to ensure that this project in the Northwest does reach its intended objectives? It does come to fruition, we see it. What do you see as your role in helping the JP and the division as a whole?
Thank you, Minister. I have indicated, Minister, that all the judges in the division have been trained, have attended the training by JP Mulambo on case line, and all that I would then do is to have a refresher course, because the last time we attended that was in 2020, if I'm not wrong, JP Mulambo will remind me. And, okay, I see Minister is, okay, yes. I would support and assist the JP to have a refresher course for those judges who have attended the training so that we don't have any challenges and we can hit the ground running. We've got a Wi-Fi running, working perfectly in the division, and we've got devices that are working. We just need to have scanners where files would be scanned so that they can be digitized and be available on the system, but we are ready, Minister. It would just take a question of just to refresh ourselves and we can start.
Thank you, DCJ.
Thank you, Minister. May I just ask the cameraman, it's difficult to, to have to compete with the click of the camera while one is trying to listen to the candidate. So try to be, invisible as much as possible. Thank you. Commissioner Matolo-Dlebu.
Thank you, Deputy Chief Justice. Good morning, Judge.
Good morning, Commissioner Matolo-Dlebu.
How are you?
I'm fine, and you, ma'am?
I'm fine, thanks.
Thank you.
Mine is just, I just want to find out from you. Northwest is such a vast province, and the issues of gender-based violence and racism, they're very rife. From where you're sitting, as in the high echelon of the judiciary, what do you think can be done, maybe working together with the university to run workshops for communities and, making them understand the role of,
Thank you, Commissioner. Definitely, I do agree with you. The Northwest is vast and it's plagued by this type of cases. In fact, before I get to answering your question, recently I was dealing with a matter. It was a gender-based violence matter, and it happened in the deep rural areas of the Northwest. So serious was that matter that I was concerned that no one knew about it. No one was aware what was happening in that area, but it was shocking because from the response I saw in the court from the members of the community, it was saying to me that they are shocked by what happened. I agree with you that we can work with the university to conscientize our communities as far as these matters are concerned. Firstly, to have them reported and know that they should not just agree to withdraw such matters because they are very serious. In fact, you find in the rural areas that people tend to believe that we can get together and resolve this in the family. And it doesn't stop. It perpetuates. It continues because the aggressor feels that I can continue doing it. This person is not educated. They don't know what their rights are. They don't know what they can do. And I am involved with the University of the Northwest a lot. From time to time, they do ask me to come and address the students. And I knew those days there used to be a unit in the university called street law. I don't know what happened to street law. Street law was one program where you would have even students and some of the lecturers going out to communities and talking to different communities about issues like GBVs and maintenance and alerting them of their rights and what the courts can do for them and what is out there. If the university could revive that program, it would also be a tool to be used for communities to be made aware of these kind of matters and to know their rights and what is it that they can do when they are faced with such challenges.
Thank you, Deputy Chief Justice.
Thank you, Commissioner. Commissioner Marumachai.
Thank you very much, DCJ. Good morning, Judge.
Le kae re Marumafai?
No, ke a leboga, ke teng, maitso.
Ke teng.
I had occasion to read one of your judgments, which is part of the package. It is Names versus Herod. Do you remember that? That dealt with impeachable dispositions.
Yes, the section 29 of the Insolvency Act, yes, yes, I remember.
I'm not sure if you do
Commissioner.
have the copy of the judgment with you, or maybe we can just talk about it, if you do remember it.
I don't have it with me,
And
but I
perhaps maybe
remember,
even the-
I remember a little bit, yes.
Yes, perhaps even the facts you don't remember. Okay, we'll talk about it generally.
Okay, okay.
This case dealt with voidable dispositions.
Yes.
Section 29.
Yes,
And I was quite interested in paragraph 20 and paragraph 21 of this judgment. In 20, you say that obviously liquidators must prove and allege.
Yes.
And you state the things that they need to prove and allege, and correctly so. On the following paragraph, paragraph 21, then you say that the people who benefited from the dispositions, they also have to prove something. And for me, that's where perhaps maybe I kind of like lost you a little bit. I'm not sure if, because I'm not sure who proves what at what stage, and whether the other one is by law entitled to prove, or does it follow from whether the first one who brought the case to the court to set aside, if he fails to prove, then that's the end of the matter. Or even if they fail to prove, those who benefited from the disposition, they also have to prove. Like I was just kind of like confused with that, because my reading of section 29 is you have what the liquidators or trustees must prove, then you have a proviso, or rather the defenses. In other words, if these people are successful, then this must be proved. I'm not sure. Can you just clarify that for me?
okay. Thank you, Commissioner. Yes, what I meant was that in terms of section 29, the liquidators have to prove that there are dispositions that have been made. What the people who have benefit should prove as well is that the dispositions that were made during the ordinary course of business and were made not with the intention to prefer. And that's where I then said that they also have to prove that the dispositions were not made with the intention to prefer, and they were made during the ordinary course of business.
But that's where my confusion is. Like, who bears the onus of proof? Or are they both going to court to go and prove those things? Or one proves, and if one is unsuccessful in proving, then that's the end of the matter. Or if one proves and they are unsuccessful, this one should also come and prove their defenses. That's where my confusion is.
Oh, okay. You are right. It's a defense that is raised by the ones who are benefited, yes. And in their defense, they need to show. And possibly it might be a question of the word prove and showing, but in raising your defense, you need to prove to the court, because they are saying you made dispositions knowing that you are being liquidated. And you must then, in your defense, show that. But these dispositions that you have proven have been made, because they have to be proven. These dispositions that you have proven have been made were not made with an intention to prefer, and they were made during the ordinary conduct of business.
No, I do understand.
Yes.
Then my follow-up question, and this is my last one. It is in relation to, when we look at the voidable disposition,
Yes.
in relation to what the other trustees or the liquidators must prove, the issue of intention doesn't arise. But of course, somehow the legislature included intention in relation to the defenses,
Yes.
which kind of like makes the whole scheme not that understandable,
Yes.
which is different from undue preferences in section 30,
Yes.
where part of what the liquidators must prove when proving this undue preference is actually intention. Do you think that these sections, when you are dealing with impeachable dispositions, the way in which they've been set out from section 26 to 31 of the Insolvency Act, they are fit for purpose?
Well, when I dealt with that matter, in fact, I had to also deal with that issue of intention, as you are saying, because one has to see that, in fact, there was an intention as well. And it was a question of me deciding, how do I determine now, when I get to this one, how do I determine this issue of the intention? And when dealing with that matter, the only thing that I could look at was from the facts of the case and the conduct of the parties. and how they conducted themselves, because that's how the act is, and that's what it requires us to do. And in following it, I could only look at the conduct of the parties. And I'm sure when you read the judgment, I referred to the conduct of the
No,
parties in determining the intention.
No, definitely. Thank you very much, DCJ. Just to correct one thing, because the universities are very sensitive as to how they are called. We don't have the University of Northwest. It's Northwest University.
Oh. Sorry, Professor.
Thank you for bringing that to our attention, Professor.
Yes, and you are right, it's NWU. Yes, I'm so sorry. How can I forget?
Well, there's only one university in the Northwest, so one will know which institution they refer to.
Thank you, Professor.
JP Mlambo.
Thank you very much, DCJ. Good morning, Judge.
Good morning, JP Mlambo.
Good. Just one small question from me. You were a regional court magistrate, am I correct?
Yes, JP.
And as DJP, if you are appointed, you will be assisting your JP regarding access to justice in the division.
Yes,
Not just in the High Court, but the whole division, am I correct?
you are right, JP.
Yeah. There are two issues I just want to raise, and I need your comment on them. One is, I think your JP will confirm this, although the Northwest does not have this problem that much, is we always have regional court trials running for long periods. And you find regional court magistrates having more than 10, sometimes 15 part-head matters under their belt. Do you confirm that?
I do, JP.
Now, what is your vision? How will you assist the JP in attending to this? Because it continues to be a problem.
Thank you, JP. Yes, you are right. It is a problem and it's concerning. I do know that at the PEEC meetings, the regional court president, although it's acting regional court president currently, attends those meetings, and that's where the challenges are discussed. And I would then support the JP in making those inquiries and trying to come up with the solutions to those problems. I know that from my experience now in the regional court, there are matters where regional magistrates would just agree to postpone without inquiring and stating really why a matter should be postponed. And that is concerning because they just easily grant postponements when postponements are not just there for the taking. A party must satisfy the court. And I would support and assist the judge president in that regard, especially with my experience of challenges that some magistrate would claim to be existing when they are really not there. I will say one example, JP, that you would find matters where in the morning when the court starts, the court is informed that the accused has not been brought from prison. And the magistrate would then agree to roll a matter over to the next day or to a next date without inquiring, calling the investigating officer, calling the prison authorities, why is the accused not brought to court? Is it a problem of transport? Be more involved in the proceedings so that you can get progress in matters and having them finalized. But I will definitely, from my experience, assist the JP in that regard.
Thank you. One last question from me. I heard you mention that you were in charge of the division when the JP was on circuit. Was it in Garankuwa?
Yes, JP, he was on circuit in Garankuwa.
You would be aware of the Northwest Gauteng dynamic in terms of access to justice. In fact, as I sit here as JP of Gauteng, I know of a lot of Northwest residents who live on the borders of Gauteng, who use Gauteng addresses to litigate in Gauteng.
Yes.
Do you have a view about how you can assist the JP attend to this? Because you've got a number of these areas that are northwest areas, but that are closer to Gauteng.
Yes.
About how to deal with this. Is it through the second sitting of the court or what? I don't know. I just wanted to hear you, since you want to be one of the leaders of the division.
Okay. What I know currently, JP, is that we do have circuit courts that are sitting in Garankuwa and Temba. And Garankuwa and Temba, those are the boundaries of Gauteng. Those are areas that fall in the municipal boundaries of Gauteng, but they are serviced by the Northwest. And we do have circuit courts that sit regularly in Garankuwa and Temba, and we are servicing those people. And we continue with that, still waiting to see what will happen. And I must say that the work has increased as well tremendously in those areas. In fact, that is why JP had to go there for 2 weeks. And he had matters that were long matters running for those days. So we are servicing those people through the circuit courts, and that's how we can alleviate the challenge of having those people trying to go to Gauteng.
Okay.
We are there, we are servicing them, JP.
Thank you very much. In fact, we hope the Musenek committee will assist us, because they've raised those issues with us in Gauteng.
Yes.
I'm sure they would have also have raised them with your JP in the Northwest. Thank you very much,
They
DCJ.
have, yes.
Thank you, Judge President. Commissioner Notjes?
Thank you, DCJ. Good morning, Judge.
Good morning, Commissioner Nokesi.
My question apparently is triggered by your discussion with JP Mlam. You indicated that in that division, you have a complement, the full complement of judges is 7.
Yes, Commissioner.
And currently, you only have 4 judges. that is
Permanent
judges, meaning that there are 3 vacancies. There are 3
Yes,
vacancies.
yes, Commissioner.
And as a result of that, you will have 2 acting judges. Why,
Yes.
why is not 3? What is happening to the 3rd judge? Because in my view, you are supposed at each given time to have 7 judges, meaning that if you have 4 acting judges, there must be 3 acting judges that you get, because that's what you have.
Okay.
Yes.
Yes. You are right, Commissioner. I did say we are a complement of 7, and we should have 3 acting judges. But that the 3rd acting position, the JP is in the process of working on it, so that we can have the full complement.
Yeah.
We did have, in fact, we've just started term now. We did have 3 acting judges. In fact, one of the acting judges that started last week started acting in a position of a retired judge who retired last week. Okay. Yes. Oh. Now, the 3rd one, the JP is working on it. So we will have an acting judge soon.
Okay.
The 3rd one, yes.
Okay, no, I was just concerned about this. You can't complain about backlog when you have posted and then you don't.
Oh, okay. No, we are working on it.
The last question I just want to get is, what is your view on something that keeps on troubling, for instance, regarding, in particular, the acting of magistrate, regional magistrate and district magistrate? Those magistrates will go and act when they have a huge list of battle-head matters in their division. That's one area. Also, that would extend even to judges who want to go and act maybe in the higher courts when they have battle-head matters in their division. Is that not disrupting the efficient functioning of courts, and how that should be responded to by the leadership of the judiciary? Thank you. That's my last question.
Thank you, Commissioner. You are right. It would disrupt a court if you take a magistrate out of a court when they have a lot of part-head matters. What I would discuss with the JP, because it's the prerogative of the JP to get acting judges, but I would suggest a solution that when calling a magistrate to come and act, there should be an inquiry into the type of matters that they're dealing with and their part-heads. Look at their role. In fact, talking from experience, when I was called and invited to act, I first had to make sure that when I go and leave my court, because it was a one-man station, I had to make sure that when I leave my court, I leave it with no part-heads, so that the parties should not suffer. And I believe that it should be done by all the JPs. When inviting acting judges from the magistracy, they should do the same.
Thank you.
Thank you, Commissioner Nikis. Are there any questions from the virtual platform?
DCJ?
Is that Mr. Klaba?
Yes, DCJ. Commissioner Klaba, I have no question. Thank you so much.
Oh, thank you, Commissioner. I suppose you just had to greet us. Well, we appreciate it.
Thanks, DCJ.
I have questions, Commissioner Barnard.
Yes, Commissioner Bernard.
Thank you. Good morning, Acting DCJ. Acting JP. All right, there's so many titles. All right.
Good morning, Commissioner Bernard.
Good morning. No disrespect intended.
No, I don't think DCJ would find that disrespectful.
Not at all.
All right. If I can just ask you, you mentioned, from the questions posed earlier, I think it was the JP, you mentioned that court visits are used to address challenges, and specifically mentioned that you and the JP needed to visit the magistrates' courts. But I've been listening to the sort of busy, the fact that there are these matters that are part heard and things are dragged out, which means that you face challenges in that regard as well. So my question is, and one accepts that physical visits are sometimes necessary, but considering the workload, etc., to what extent might the virtual platforms assist in liaising with magistrates, for example?
Yes, thank you, Commissioner. You are right that it would cause some kind of a disruption. But as much as you say it's necessary, it has to be done. And I believe it's all about time management. In fact, how we've been doing it is that when we go on circuit, one would use the time to visit the courts that would be in the area that you are in. And as you drive from circuit on your way to the main city, you would then stop along the way and visit the offices that you need to visit. Or we also schedule it for during recess. When one is not busy with your judgments, then you make time to visit those offices. I do agree the virtual platform can also assist, but at times one needs to be physically there to see those challenges. And as I mentioned when the JP was asking me about the visit, I drove to Ganyesa. It would have been easy to call the head of office or have a virtual meeting with him and discuss over the phone. But when one is physically there in that station, you are able to see firsthand the type of challenges that they have. And you get a sense and experience exactly what they are going through. So virtual, yes, it can help at a certain extent, but the physical visits are just as important, Commissioner.
Thank you. And my last question is just, there's good feedback about your diligence and excellent track record, etc. But there are these matters that were mentioned, these 3 complaints, and I was just wondering, on page 14, paragraph 20 of your application, there's, asking whether you've got anything to declare or bring to the Commission's attention. They're not mentioned there, and I was just wondering about that.
Okay. Thank you, Commissioner. These are complaints that I received after I had completed my application. I received them in August, Commissioner.
Thank you very much. Thank you, DCJ.
Thank you, Mr. Bernard. Any further questions, colleagues? None. Unless there's something you want to say to us, Judge.
No, DCJ, unless I'm going to invite more questions. But I just want to thank the commissioners for the opportunity that I was given to come and present my case. Thank you very much. I appreciate it.
Well, we thank you too for throwing your hat in the ring for this important position and representing the women. You're excused.
Thank you, DCJ. Thank you, commissioners.
Good morning, Justice Maya. I'm well, thanks, and you?
Okay. You obtained two degrees, law degrees from Vista University in 1997 and 2001.
Correct, Justice Maya?
A BU recent and a LLB.
Correct, Justice Maya?
And then you would have obtained the LLB while you were already on the job market.
The LLB, yes, correct, Justice Maya,
All
yes.
right. Your background is in prosecution,
Yes, my background.
largely.
Correct, Justice Maya. I've been with the National Prosecuting Authority until I resigned and joined the bar of the Johannesburg
That is
Bar
from
Council.
1999 until 2012, when
20
you had
Correct, Justice Maya.
clambered all the way up the ranks to become a senior state advocate.
Correct, Justice Maya.
You were with the Assets Forfeiture Unit.
I started off as a prosecutor in the district court, and then regional court, and then thereafter appointed as, after being admitted as an advocate in the High Court, I was appointed in the Asset Forfeiture Unit as a state advocate, and then thereafter the senior state advocate. And on several occasions, I was also appointed to act as a deputy director.
And then you decided to join the bar.
I joined the bar, yes, in 2012, after I've resigned from NPA.
Joburg Bar, Polokwane Society of Advocates,
Yes, I
and
did.
the Northwest.
Correct, Justice Maya. I did pupillate with the Johannesburg Bar Council. And then thereafter, I think 2014 or 15, I joined the Polokwane Society of Advocates after it was formed. And then thereafter, the Northwest Bar in 2021, I think, yes.
Okay. What kind of work did you do in your practice?
In my practice,
What do you do, sorry?
in my practice, Justice Maya?
Yes.
Yes, Justice Maya, in prosecution, it was mostly criminal. So after I joined the bar, I got much interest in civil litigation and motion. Most of my work was in civil litigation, even though I still did some criminal matters, but 90% of my work was civil.
All right.
Yes.
What kind of cases exactly?
The civil.
Yes.
It was medical negligence, unlawful arrests, and some applications that I would do.
All right. When did you start acting at the
It was,
Northwest Division? Your first stint was in July 2020.
correct, Justice Maya, it was July 2020.
And how many acting stints have you had with them since?
Last week, Justice Maya, I managed to get hold of my court books and I calculated. All in all, it's 73 weeks. Yes. Because I'm still acting now until the end of October.
Oh, I see.
Yes.
And you have you've sat in both civil and criminal matters?
Yes, Justice Maya, in the Northwest Division, we do everything. I did opposed, unopposed, civil trials, criminal trials, appeals. We do everything, Justice Maya.
Right. And have you been able to produce written judgments?
I was able, correct, Justice Maya, I was able to produce written judgments. I was also counting them, and I stopped at 90. When I started to act, my DJP by then encouraged me that as part of training, I must try to pen as much judgment as I can. The more I pen them, the more experience I will get, and the more easier they will be for me.
Indeed.
Yes.
Any of them reported?
Not in the Juta or LexisNexis, only on SAFRI, Justice Maya.
All right. Do you have any old reserve judgments that
No, Justice Maya, I don't have any reserve judgment.
In your application form, you mentioned 3 parthead matters. What is their status now?
Justice Maya, if you may see on those in the parthead matters that I've written down. There are more than one accused. One is 11 accused, one is 5 accused. And they are still pending in those partly head matters. I put them, they were set down during recess of June, but they could not be finalized. The reason being, June we had a challenge of load shedding, and sometimes on some days the accused is sick, some days is the legal representative. So there are many challenges when one is dealing with partly head matters, especially of more than one accused and more than one legal representative.
Something caught my eye. In I think 2 of the comments that have been submitted by the professional bodies, there's mention that you have resigned your membership of the bar in pursuit of your acting stint. Can you explain that?
Correct, Justice Maya. If I may go back a bit, the reason why I joined the bar, I've always wanted to be a presiding officer, either a judge or a magistrate. So when I arrived at the bar, I contacted the office of JP in Gauteng, and I was told that I can only be able to act after 12 years experience. And then I noticed that, oh, okay.
12 years experience
At the bar. That's what I was told. I'm not sure whether it was correct or not. For me, the practical experience at the bar. So now, and then one of my senior colleagues at the bar were aware that I'm there for me to be a judge or to be a magistrate. And then the opportunity came from Mafikeng, and then I grabbed it. And after grabbing it, I acted the first stint in July, the second one, the first term of 2020. And then thereafter, I started to pack my practice bit by bit so that I can be able to focus on acting. And then I resigned from the bar because being the member of the bar also, it goes with costs that were going to be heavy for me whilst I'm acting and also being the member of those bars. So that's the reason why I resigned, to pursue my acting stint.
Oh, I see. So if you are not recommended for appointment, you will go back and start again?
I will go back and start again, Justice Maya. Yes.
Okay. The General Council of the Bar says some of its members have expressed some misgivings about your experience with civil work. They say you have limited knowledge of civil law, to quote them verbatim. What would you say to that charge?
Justice Maya, I don't think that comment is correct. I gave myself 10 years to be at the bar and also 12 years to be with NPA. And also at NPA, we had some portion of, AFU has some portion of civil law. So in my practice, as I've said, 90% of my trials that I was running were civil, were of the civil matters. I was in court frequently I was in court. I'm a court person, so even in practice, I'm in court frequently. I'm not afraid of running trials. I'm there in court, and if I may add, Justice Maya, is that most of the pupils that will come to me, I always told them that, when you appear in court, you are going to deliver a matter. The judges won't bite you. The judges won't give you a hiding. Just go there and present and be yourself. So that is what I was doing also with myself personally. I therefore don't believe that I don't have enough experience. I have enough experience. And also most of the judgments that I penned in my PK are the civil judgments.
Well, they make more troubling observations that some members have complained about your short temper, that you are confrontational in your engagement with counsel, and that you are not punctual in starting court proceedings. Would you like to comment?
Thank you, Justice Maya. I took note of that comment, and Justice Maya, I accept that as judges we should be criticized, but the criticism should be constructive and fair and in good faith. Unfortunately, that comment, Justice Meyer, doesn't state at what stage did I show my temper. If I want to blow my own horn, Justice Meyer, I'm a very kind-hearted person, I'm a polite person. I make sure that everybody that appears in my court becomes comfortable. I've never shown any signs of short temper. And if indeed, Justice Meyer, I had temper and all those things that they mentioned, they could have complained to the JP maybe, in writing or physically. I've never received any complaint from anyone, or I've never, even in my court, have any interaction with any of the litigants. If I may add, Justice Meyer, it's, according to the experience that I have, the period that I've spent in acting, I've noticed that as judges, we do make unpopular decisions, and the losing party will always complain. So I should think that maybe the person who thinks that I'm short-tempered is the losing party, but I know myself personally. I'm a very kind person. I don't have any short temper. And regarding punctuality in court, Justice Meyer, I'm always present. I'm always on time in court. I'm sure my JP could have called me to order if indeed I'm not punctual in my court. Unfortunately, as I've said earlier, the person that complained about that did not clarify under what circumstances did I not become punctual. We have our own challenges of load shedding. Sometimes, maybe there was a challenge on that day, but I'm a very punctual person, Justice Meyer. And regarding confrontational, Justice Meyer, when I go to court, I prepare my file. When I started to prosecute many years ago, we were trained thoroughly that you do not go to court without knowing your docket. And then in practice, when I did pupillage, we were trained that know your file or your brief as much as you know yourself. The same is happening. It's the same style that I apply also as a judge. I prepare myself thoroughly. I do my own research. I go through the heads of arguments of both parties if it's an application. And when I arrive in court, I do not intend to be, I can never be confrontational. In fact, in my court, I leave the litigants to present their case as much as they want. Maybe by being confrontational, they mean when I try to clarify the issues that they've raised before me. But that's, I can never be confrontational, Justice Meyer. As I said, I'm a very kind person. I know myself.
Yes. Well, the allegations are indeed bare ones. There's just no details. One that does not know what you did to whom when. You are a chairperson of the tax board?
I was Justice Meyer, yes.
Mm-hmm. For how long?
It was for 5 years. I think it was 2016 until 2020. As a chairperson of the tax board, Justice Meyer, you are supposed to be briefed by the commissioner. And unfortunately, as for these 5 years, I only received 3 briefs, and all of them were settled at the door.
So you did not get to do much?
Yes, I did not get to do much, yes, Justice Meyer.
All right. You have mentioned that you mentor pupils and offer all kinds of support to young people. Do you want to tell us a bit about that?
Yes, Justice Meyer, when I did pupillage, my challenging courses was motion and legal drafting. And I've noticed that most of the pupils, we need a practical training, especially of legal drafting. So I took it upon myself. Since I've passed pupillage, since I've started practicing from 2014, I've been having groups of pupils that I'll be training, those especially that I'll approach one, and that one person will come with his own people. But what I used to do in Polokwane, I will request the class, and then I'll go there during the weekend. Friday, Saturday, Sunday, I'll be with them, wherein I give them a topic, and then they draft, and then I personally show them how to draft a particular document, because I think that is what I needed during pupillage. As a prosecutor, it was the first time that during pupillage that I saw the particulars of claim and some documents. So I've noticed that some of our pupils are failing pupillage because they do not get enough training. And regarding young girls, I try my best, Justice Meyer, especially in the rural areas, wherein the girls need to know and have confidence in themselves, need to know that it's not by miracle to be where you want to be. irrespective, we know that we have the teenage pregnancy problem in South Africa. So those that have kids in the young age, I encourage their parents that support your children, let them go to school and pursue whatever they want to do. Unfortunately, I've been trying to encourage them to do law. They are not interested in the law, they took other fields.
I don't blame them. And you have assisted some financially, actually, by paying their way through school?
Yes.
Or through university?
Yes, correct, JP. I make myself available. By assisting them, I don't mean that I pay school fees. You know, in the rural areas, the kids, some of them were not even aware that there's NFSAS. They will struggle to have money to go to the university after being accepted, to go and register. So those things, those fields, we will appoint a girl, and then that girl that you see potential in that particular person, you mentor that girl. And then thereafter, let him register and mentor him through the school. But Justice Maya, I would like to mention that I'm of a view that I'm not only supposed to mentor girls. I'm of a view that we are leaving the boys out.
Yes.
So if there is a boy, also because I have a boy child, I saw that if we always say girls, 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 what about the boys that we are raising? Are they not going to be the same problem that their fathers are now? Because we are not giving them those opportunities. So if there's a boy also that I see potential in that boy, I try to hold the hand of that boy and educate. Not by, I don't have money, I don't have money, Justice Maya, to pay school fees, but at least assist them. That there's NFSAS, tell the parents, because you need to, in the rurals, you need to talk to the parents before you talk to the child. Tell the parent that there's this and this and this, your child can indeed be successful, and indeed they do graduate and get some work wherever. Even at church, I do that at church. Whoever that needs my assistance, they come to me and I make myself available. And regarding pupils, most of the pupils in Polokwane are in the rurals, and especially in 2020 during COVID, they had to run classes through virtual. Most of them will call me and tell me that we don't even have money for data. Some pupils don't even have money to go and attend classes. I don't have money, but I will try and source money from some of our colleagues and be able to fund those pupils. After I've done my own research, because I hate to be taken for granted, and I know that for sure this pupil needs assistance. Some will be taken by the different bus, but they don't have money to register for them to can be able to proceed with pupillage. I will fund them, and then after they register, and some that are staying in Polokwane or around Johannesburg, they don't have money, they rent rooms to can be able to stay and do their pupillage. I do fund some such people, Justice Maya, but I want to insist that I don't have money, I don't fund them from my pocket, I do some means for them to be able to get those fundings.
Yeah. No, thank you, Ms. Mahlangu. JP Hendricks?
Thank you, DCJ. Good morning.
Good morning,
Judge
JP.
Mahlangu. How are you?
I'm fine, and you, JP?
Fine, thank you. You have been acting in our division for a considerable period of time.
Correct, JP.
You have been called by my predecessor.
Correct, JP.
Yeah, and your acting stint is now extended until the end of this month.
Correct, JP.
Yeah. You also stated that you penned something like 90 judgments.
Correct, JP.
Yeah. So, how do you experience it, acting in the Northwest Division?
JP, acting on itself is a very daunting experience. You know, I was a prosecutor, and then from me being an advocate, I had to shift my mind, and especially when representing the accused person, to stand on the other side of the bench. Now, being acting as a judge, it was something very, very different from what I was experienced to do. But due to the help and the cordiality of the other judges in the Northwest Division, it became easier. I remember when I first got there and to act, and I signed the certificate of oath, the DJP by then told me that, you know what, you are a judge. You must be responsible and accountable for what we are going to do in your court. Acting is something else, but be responsible. So acting in the Northwest, it became easier for me because of the support that I got from other judges. It's easier to just go knock at the door and ask for assistance. And the other thing that I've said earlier is preparing. made my acting in the Northwest easier. And the other thing, JP, that made my acting in the Northwest easier, I think because I can speak Setswana easily, it became easy for me to blend in with the people of the Northwest. Thank you, JP.
You are referring to the DJP by then. Are you referring to me?
I'm referring to you, just JP.
Yes.
Yes. You
Yes.
gave me the very good support, and I thank you for that.
Yeah. One concern that I also picked up, but you were asked by the DCJ already about it, is the GCB's comment about your temper, you are not being punctual at starting court and confrontational in your engagement with counsel. Now, for the record, no complaints was brought to my attention.
Thank you, JP.
Yeah. And also, you were nominated by Advocate T. Masike.
Correct, JP?
And from the nomination letter, the following appears, and I quote, I submit that acting Judge Matlangu is appropriately qualified, has the necessary experience and temperament to be appointed as a judge, unquote. Do you have any comment on that?
Correct, JP. Yeah, Advocate Masike is correct. He's one of the advocates that normally appears in my court, especially in the unopposed role. I've never shown any temper, and I'm not a temper. I don't have a short temper. Like I said, I know myself.
Yeah. Do you have any long trials that you are currently doing, civil or criminal?
I have 3, JP. In fact, there are 4 now. Yes, I have 3 criminal trials that are running, that are very long. The first one with more than 11 accused, the charges there are 21, 21 charges, and there are 7 legal representatives. And the second one, I think it's 4 or 5 accused persons, and each accused person has his own legal representative. The charges there are 11. And then the civil one is 19 plaintiffs, if I'm correct, JP. And even though they are represented by 1 legal representative, but the charges, the claim against the defendant in that are plus minus 10. So they are very, very long trials. Thank you, JP.
And how do you find the workload in the Northwest?
JP, I've only acted in the Northwest, and I've always had the people from Johannesburg saying the workload. The Northwest workload is too much. There's too much work. Like, I'm in court every day. I don't know if maybe because of the shortage of judges or what, JP, but there's a lot of work. I'm in court running trials. Thursdays is opposed applications, and Fridays, but there's no day that I've since acted and I was never in court in the Northwest. The workload is too much, JP. Even when I go to circuit, like I was in circuit court last week, there were 3 trials that were set down. So the workload is too much in the Northwest, where both criminal and civil.
Yeah. During the July recess, my predecessor, Judge Leo, called me and Judge Peterson and Judge Jaje to come and assist during the recess, and you were doing recess duty. Were you overwhelmed by the work, the amount of work? Was it too much for you to do? Or what was the situation?
JP, what happened is I was on a recess duty during the first week of recess, and the second 2 weeks, it was one of our sisters that got ill. So the JP requested me to step in as I was already in court. And then the reason why I was there, I had this part-head matter of 5 accused persons that I was supposed to be, that was set down for that 2 weeks. So now I had to step in and be on recess duty. And when we are on recess duty, you are doing the unopposed, the opposed, all the work is coming to you as a judge. So during the last week of when I was on recess duty, this trial was still proceeding, the witnesses were coming in court, and on Wednesday, I received the unopposed motion roll, which consisted of 120 matters, and then I already have 5 urgent applications, and there were 2 return days applications that were also supposed to be heard on Thursday. I thereafter called the JP because he said to me, you are going to be on recess duty to step in the shoes of our sister that is not well, but should you have any challenges, please let me know. I've already talked to other brothers of ours to come and assist. And then I talked to JP Leo, and then he called the other judges that were available to come and assist. And indeed, on Thursday, the other judges came. The reason why I went to her, I didn't want to postpone any of these matters because the litigants were there and the clients will suffer because the litigants will be paid for the day on which that they booked. So what I did, and also my trials, the witnesses were in court, and I normally run my opposed until 1. My aim was to start with my trial at 2, and on top of that, we had agents. And agent applications are agents. You cannot stand them down on any other day. You need to deal with them. But JP, what I can say now is that I am indeed managing to deal with the overloaded role. It's just that on this day, I was on research duty, and I had other matters already that were on the roll.
Yes. I also see that you have some business interest.
Yes, JP, correct.
Yeah. You are, is it a director of a company or a shareholder?
A shareholder in one company.
And?
Yes, and an executive director in one company.
Yeah.
Yes.
And what will happen to this should you be recommended for appointment?
I intend to resign in one of them. It's one company that I'm a shareholder. And the second company, JP, we started it in 2019, and unfortunately, because of COVID, it did not pick up. But I intend also to resign from it.
Yeah. You have resigned from the bar. Now, did you resign in anticipation that you may be recommended for permanent appointment?
JP, I've been acting since May until end of October. So I just sat and realized that to pursue my acting appointment, let me resign, because being a member of the bar, it comes with own costs.
Mm.
So should I not be appointed at JP, I will go back.
How many reserve judgments do you have?
I do
currently?
not have, I'm sorry, JP, I do not have any reserve judgments.
Yes. Thank you, DCJ.
Mic is off, sorry. I was asking if you have questions for the candidate.
No, not.
All right, no, that's fine.
Thank you very much, DCJ. Good morning, Judge.
Good morning, Professor Marumo.
Marumo
Oh,
Akhai.
Marumo Akhai. Yes, good morning. Yeah. Yeah.
I see that in your bundle of documents, there's one matter where you had occasion to deal with the Companies Act, Centurion Academy and Quaver Training. Do you remember that matter?
Yes, I remember it.
I'm not sure if it would be fair for me to deal with the facts of it. Do you still remember them, or should I just ask generally?
I think you should just ask general.
Oh,
I think I still know
okay.
the facts.
All right. I just want to understand. In this case, you dealt with sections 344 and 345 of the old Companies Act of 1973, and correctly so, because while that legislation has been repealed, chapter 14 of it, it is still in force in relation to insolvent companies. I just want to get your view, because I really wanted to deal with the case itself, but nonetheless, I just want to get your view, because currently we are having the Companies Act of 2008 that deals with solvent companies and to some extent a business rescue. What I want to understand to you, this parallel regulation of insolvencies in South Africa, is it sound? Is it something that should continue, Or should the legislature approach the question of insolvency differently and perhaps have one legislation that regulates both insolvent and solvent companies? The liquidation of solvent and insolvent companies, that is.
Professor Marumo Achai, I just want to place it here that this matter has been appealed and I granted leave to appeal. So I don't want to state things, the facts, and be as
Yes.
if I'm defending my
No, it's
judgment.
fine.
But
We don't have to deal with the facts of it.
Yes.
Let's just deal with law generally.
I'm of a view that the law relating to insolvencies should continue as it is.
With parallel regulation.
Yes,
Oh, okay.
thank you.
Thank you very much, Deputy Chief Justice.
Thank you, Commissioner. Commissioner Nyambi?
Thank you, TCJ. Morning, ma'am.
Good morning, Commissioner Nyambi.
Besides the negative comment by the GCP, if you can share with us your good attributes that will make you to stand out, as you know that you have others that are for the same position that we must seriously consider as a commission.
Thank you, Commissioner Nyambi. Commissioner Nyambi, I have passion for justice. I'm a very, like I said, I'm a very kind person and willing to listen. I'm a good listener to the litigants. I'm a hard worker. That is why I don't have reserved judgments. I deliver my judgments, the latest in 6 weeks, and most of them I deliver them. I work through them in the weekend, so the earliest is 1 day or 2 days. I'm always prepared. I have the good relationship with everybody that I'm working with. I'm a very brave and confident person. When I go to court, I make sure, I know that whatever judgment that I'm going to grant one of the parties might not be happy, irrespective of whether I've worked with that particular litigant or not, and irrespective of whether that particular litigant has 30 years experience as a senior counsel or 1 year experience, I treat them equally in my court. And when I realize that the litigant is not getting or is not getting through the law that he or she has presented on paper, I nicely guide them. I therefore, Commissioner Nambi, if I may say, I'm a very strict person, if I may put it that way, that does her work with diligence.
My last question. In South Africa these days, the buzzword is the independent judiciary. So, in your own words, can you please describe your understanding of an independent judiciary?
Commissioner Nyambi, in my words, I would say the independence of the judiciary, personally, I would say not to be easily influenced by any, whether it's the media, by any other means that will try to influence my judgment on how I deal with the matters in court, and to make sure that each and every matter that comes before me, I deal with it fairly and in terms of the law that applies to it, and after listening to the litigants. Therefore, by so doing, I think I'll be independent without being told by any other person on how to deal with a particular matter.
I was not specifically referring to yourself. I was just asking about an independent judiciary.
Okay, I'm sorry about that, Commissioner Nambi. Yes, the independent judiciary, the judiciary that is not easily influenced by any other means, and ensures that each and every matter that appears in court is treated fairly and in terms of the law of the country.
Is it possible to influence judiciary?
It's not possible. As far, according to my experience as acting, it's not possible, Commissioner Nyambi, to influence the judiciary. But the judicial independence goes there, that the judicial independence must be, as a judge, I must do whatever I think, give the decision in terms of the law and in terms of the papers that are appearing before me.
Thanks, Ms. Mahlangu.
Thank you.
Thank you, DCJ.
Thank you, Commissioner. Commissioner Matolo-Dlepo?
Mr. Chair, can I just make one follow-up?
Follow-up, all right.
Yes. When you say the judiciary is not easily influenced, what do you mean?
I was answering Commissioner Nyambi's question that, like I said, the judiciary, the independence of the judiciary is not to be influenced by any other means, Commissioner Jesse. It's because we watch the news, we are on social media, everything. The matter that is going to appear in front of me might have been on the news. So it's by being influenced is that I should think that is the meaning of being influenced, that I must apply my independent mind.
Yeah, my problem is you say the judiciary must not be easily influenced. Does that mean it can be influenced, but that must not be easy to do?
No, it can be influenced, Commissioner Jesse.
Thank you, Commissioner.
DCJ, can I just follow up on this question again?
Yes.
Ms. Mahlangu, lately in South Africa, they talk about state judicial capture. Do you know that? And if so, what do you understand it to be?
Commissioner, I've heard about the judicial capture, but I don't think that that's a fair criticism to the judges. It's not possible to capture the state. You know, the way our courts are busy, when I receive the file and I'm supposed to pray, I normally work through the night for the files that I'm going to deal with them in the morning. So I cannot see any of our judges being captured.
You say you heard about it.
I've heard.
Yes, when you heard about it, what do they say it is? What is this thing when you hear about it?
I've heard about it from the news and from that there's this judicial capture. Judicial capture.
It is. What they say it is. They say it is judicial capture, as we heard about it, when what is happening.
I think judicial capture, it's judicial influence. It's to be influenced as a judge.
Okay, thank you very much. Thanks.
Commissioner Matolo-Dlepo?
Thank you, Deputy Chief Justice. Good morning, Mr. Mahlangu.
Good morning, Commissioner Matolo-Dlepo.
Okay. I know that you said you always wanted to be on the bench or a magistrate, but what I wanted to find out from, when you were an advocate, did you get enough briefs to sustain you? And if so, who were getting briefs from? Because I'm quite concerned about that.
Oh, yes, Commissioner Dlepo, I was one of the privileged that was getting briefs. I've never struggled as much of the people are struggling. If I may say out of context, is that people are struggling at the bar with briefs, but I'm one of the privileged. I think it's because of my experience and because people knew that I was at court. Because as an attorney, Mr. Matolo-Dlepo, I'm sure you want to brief a person that has confidence of appearing in court. So some of my briefs were coming from the state attorney and some of my briefs from the private attorneys.
Secondly, I hear that you are assisting pupils. Are you aware that the Legal Practice Council is actually assisting pupils to go through pupillage through SACITA?
Yes, I'm aware, Commissioner Patology. I'm very aware, yes.
I urge you to encourage them to apply through that. Okay.
For pupillage?
Yeah, assistant through SACITA.
Come again, Commissioner?
I'm saying I'm urging you to advise them to apply through the Legal Practice Council, you know.
Yes, Commissioner Dlepo, I'll advise them to do that.
Thanks.
Thank you.
Commissioner Pillay?
Thank you, DCJ. Good morning, Ms. Mahlangu.
Good morning, Commissioner Pillay.
Ms. Mahlangu, I'm going to put an overriding concern that I have. I've been through your judgments and I find that a bit of the reasoning gets a bit muddled. in your judgments. And I don't have time to take you through all your judgments, but perhaps I can just reference one. Can I ask you to open up the Mojalefa judgment? It's on page 84 of your bundle. Do you have the judgment?
Yes, I'm just about there.
Now, can I ask you, when you selected your judgments which you wanted to showcase for the commission, why is it that you chose this judgment?
Let me check.
It's on page 84.
Commissioner, which one, please? Oh, okay. If you can look at this judgment, I penned it in 2020, so it was few months after I started my acting stint. I placed this judgment here. If you can look at my judgment, I made them deliberate that the earlier judgment that I penned to the recent one to see the improvement that I had in my judgments.
Okay, now I understand
Yes,
that. So this judgment deals with amendments and it deals with exceptions. Are you saying to us that you put it in to show how you developed over time?
Yes, to develop over time, yes.
Okay.
Yes.
And you accept that your findings in relation to, let's deal with the amendment, for example, that your handling of the amendment was not ideal at that stage?
Not necessarily Commissioner Pillay. Yes, when I was dealing with this matter, I thought the amendment was ideal.
Your handling of the amendment?
My handling, yes, my handling of amendment, yes.
All right, let's just look at that. In this case, the amendment application, the notice of intention to amend was brought in December 2019.
Mm-hmm.
And the amendment there was no objection to the amendment.
Mm-hmm.
And ordinarily what would happen then is the applicant for amendment would file amended pages. That's the simple working of Rule 28.
Mm-hmm.
You agree with that?
Yes, yes.
But the amended pages were not filed in time.
Yes.
And so what the defendant did is it raised a point in the exception that the amendment was not properly effected because it had lapsed, and that by the time the plaintiff had filed the amended pages, it was actually just too late to do so. You recall that?
Yes.
What I noted from your reasoning was that you didn't approach the matter on the same vein as the defendant argued it. Mm-hmm. In other words, non-compliance with Rule 28.7. You approached it on the basis of the application of Rule 28.4, which is dealt with something else completely. So 28.4 deals with where you can bring an application for leave to amend once there is an objection to your amendment.
Mm-hmm. Yes, I understand you.
So I just wanted to get a sense of why it is that you approached, because amendments are really, it's like a basic procedural issue that judges have to deal with. How it is that you dealt with the amendment before you. Just looking at your judgment, there doesn't seem to be just a kind of a coherent approach to the argument before you and the basis for your decision eventually to dismiss the complaint raised by the defendant.
Commissioner Pillay, yes, I understand your question, and that the reasoning that I followed was not in terms of what the defendant has pleaded. Is that your question?
It wasn't what was raised in argument before you.
Oh, yes. Yes.
And you see, it had a further implication because the exception, when it was argued before you, you considered, when you considered the exception, you took into account both the amended pages as well as the unamended pleadings. So in other words, because you had in a sense, mishandled the amendment. It bled into your handling of the exception. Because when you considered the exception, you considered it based on the amended pleadings.
Yeah. No, I understand your concern. When I dealt with this matter, I was of a view that because the amended, the notice to amend was not objected, the plaintiff was to file the amendment at any stage.
Yes.
Yes.
And not that in terms of 28(7), it was peremptory, he had to file it within a particular period of time.
I note your concern. Thank you.
Thank you, DCJ.
Commissioner Baloyi?
Thank you, DCJ. Good morning, Ms. Mahlangu.
Good morning, Commissioner Baloyi, SC.
Ms. Mahlangu, it's in similar vein about judgments, and I think the proposition that I want to put to you, or why I'm raising this with you, it's about whether you are ready or have gained sufficient experience in both practice and your acting stints, that you've gained sufficient experience that you are ready to be recommended. Now, if you look, and I'm looking just at two judgments, only to try and illustrate where my concern and anxiety comes from. You've given us the judgment of Mutladi Le versus Minister of Police, and you find that at page 116 of your bundle. Now, this was an application for leave to appeal. No, this is a civil claim. Someone was arrested by the police, right? You remember that?
Yes,
that
yes,
case,
I remember, Commissioner.
Now, this person was detained for 4 days, and
Yes.
you awarded 60,000 rands for that, at 15,000 rands per day. You remember that?
Yes, yes, I remember.
Now, what I've struggled with, and maybe let me, in fairness to you, try and take you to what it is that I'm looking at. But as I do that, let me just explain my difficulty. It's what you've done in this judgment, I thought, firstly is, it doesn't seem that you have considered the value of the freedom of the person, the liberty of the person. This particular plaintiff, as I understand from your judgment, is he went to the police station, he provided them his contact details, he somehow was arrested, and after 4 days he was released without an appearance at court. And what you did is you did this analysis of comparing past awards, but it's not clear how, you don't say how those awards in the end factor and influence your awarding the 60,000 rands. And from this judgment, it doesn't look like you had regard to the circumstances, firstly, of his arrest, the values of the Constitution about his right to be presented before court within 48 hours after 48 hours of his arrest, the right to freedom of person, dignity, and it doesn't seem, nothing in the judgment indicates that you alerted yourself to the implicated provisions of the Bill of Rights. You don't speak to that. And you'll see at page 119, paragraph 4, where you quote what it is, the grounds that he relied upon. I don't see in the judgment that you deal with those and address them at all. Now, it's quite possible that it is oversight, and that's me thinking that perhaps it's just complete oversight on your part to deal with these things. But then, if it is oversight, then it seems it has implications for your attentiveness and alertness to principles of law that get implicated in what looks like straightforward cases, but maybe they are not. So that's the Mutladi, and I'll ask you to, I'll give you the chance to comment to that if you want to. The next one is the case of Mafilika versus the state. And this was an application for leave to appeal against conviction. Now, in this one you find at page, I think it starts at page 133. Mafili,
Yes,
are-
I'm there,
Are you
Commissioner.
there? Yes. Now, if you go to 138 of that judgment, there's listed grounds. The appellant lodged this application for leave, and the following were the grounds. And he lists the grounds, the appellant. And there's a total of 6. And in fact, it's 5 effectively. But one of them is that you did not, the magistrate did not, consider properly that this person was, the witness rather, was a minor. In fact, let me raise 2 with you. Was a minor, but there's also that he was also implicated in the crime itself. He was an accomplice, that is said. But then you then, in your analysis of this, you deal with this, you don't address the issue of him being an accomplice, or the allegation that he's an accomplice. You deal only with the fact that he's a minor, and that's all you address, and you find this at paragraph 20, at the end of paragraph 20, and at paragraph 21. That's all that you deal with. You don't deal with the other grounds that have been raised, and then, of course, you dismiss the appeal. But you've dealt only with one ground of appeal. And again, it's either it's oversight on your part, which is serious. And I note that you wrote the judgment with Judge Jaje. I note that. But you were the scribe, so I'm raising this with you. That you either completely had, overlooked the other grounds for appeal, which is quite serious, because maybe if you had paid attention to them, this appeal may well have succeeded, and I'm not discussing that for now. Or you didn't consider them to be important grounds to be addressed, and I'm not sure which. But both of these raise concerns for me about whether you are ready, one can be confident that you are ready to be appointed and the public is safe in your hands. What do you say about that?
Okay, thank you, Commissioner Baloyi. I think I've gained enough experience. I have, if I calculate, I have more than 23 years experience in the legal field, wherein I've been through all the spectrum of my legal profession. But what I can say with the first case of, is it Mafilika? Yes, the first case of the unlawful arrest that you mentioned, we are guided by the SCA relating to this matter. There's this recent SCA judgment that came out that guided me in coming to this conclusion of granting the plaintiff 15,000 rand per day. And the other thing, Commissioner, is both matters, for me not to deal with the constitutional rights of the plaintiff in this judgment. I admit that it was my oversight, but I'll take note of that, because in some of my matters I do deal with the constitutional issues, constitutional rights of the plaintiff, especially if they were raised. But if they were not raised in this, like in this matter, it is an oversight that I did not deal with it. And relating to this other matter, Commissioner, where in a minor, the issue was that the minor was has not properly taken an oath. In my view, that was the main issue in this matter. That is why I dealt with it alone. Then I did not deal with other issues. But I also note that for me not to deal with it was not an oversight on this one. I just took it that for this matter to proceed, the main issue was that the minor's oath was not taken into consideration.
Thank you, Ms. Mahlangu. Thank you, TCJ.
Thank you, Commissioner Baloyi.
Chair, I would like to also pursue a similar line, if I may.
Yes.
Good morning, Advocate Mahlangu.
Good morning, Commissioner Ngugaitobi SC.
Yes, can I just ask you about the judgment of Ketleng Refir?
Okay, Commissioner, before you go there, Ketleng was also appealed, and the appeal was heard on Friday, if I'm not wrong. And the JP was one of the of the judges that sat on that appeal. So you may ask me questions, but I will request that you don't ask me questions that will be like I'm defending my judgment.
Yes, you will tell me if it's uncomfortable, then I won't pursue it any further. But
Thank you.
It somewhat unsettles me because basically the facts in that case is that there was sewage that is spilled into Costa River.
There were 3 cases, Commissioner.
Yes, let's
If you
take
can-
case 1.
Sorry?
Case 1, which involved Ketling Refier. You've quoted this at page 48 of your application. But let me just pursue this one line. I mean, let's take the one case where there is sewage that's spilled into a river. An application is then brought to compel the municipal manager of Ketling Refier, firstly to stop the sewage because it's contaminated water, it's dangerous water. That application then succeeds by way of a rule nisi. The municipal manager is told in the rule nisi that they need to bring a report to court to detail what steps they have taken to stop the contamination. You remember those facts?
I remember, Commissioner Ndugaitobi, like I've said earlier, those were one of the reasons why this matter was upheld.
Yes, now I understand. I'm not going to ask you about those particular facts. I just wanted to make sure that you remember what I'm talking about. The municipal manager doesn't comply. You remember that?
On what page is it, if maybe you can just take me to it?
Yes, I'll take you now, but again, this is just by way of background. A contempt application is brought before you for non-compliance with the terms of the rule nisi. You then dismiss the contempt. Correct?
Yes, I think so.
You say you've dismissed it because by the time the application came before you, the rule nisi had lapsed. But you totally ignore the fact that for the duration of the rule nisi, during that period that it had not lapsed, he was in contempt. Now, that's what I'm trying to understand in your reasoning, because the reason I'm worried about this is because if there is spillage of contaminated water to a community in a township, that implicates environmental rights under Section 24 of the Constitution. And when there is a contempt application to compel the municipality to do its job to clean the water, and it comes before a judge, I would expect a judge to be specially alert in cases of water contamination and in cases where the municipality fails to discharge its obligations and not easily to dismiss an application such as this on such, I would say, tenuous grounds. And that is why I'm worried whether or not you have, in fact, the requisite technical ability at this stage. Do you want to comment on that?
Commissioner, I thank you for the question. I do have the technicalities to deal with the matters that appear before me. But as I've said earlier, that is one of the issues that were raised in the appeal, and I don't feel comfortable in answering it.
Thank you.
We all understand. I just want to reassure you, Ms. Mahlangu. We all understand the principle of sub judice, but I think it would be entirely, open to you to discuss your judgment and what led you to deciding in a certain manner, because you played your part. Your functus officio is out of your hands.
Oh, okay.
What the senior court does is something else.
Thank you,
Please just-
Justice Maya, thank you very much.
All right.
I'm asking for a follow-up just on this, just one quick.
Yes, Commissioner.
Look, I mean, on this question that Commissioner Ndugaitobi is asking, really it has nothing to do with that. The question is, at the time when the municipal manager did not act. The order was valid, it was there. But the question is, did you understand that? And how on earth would you dismiss it simply because at the time of hearing the matter, then the rule has lapsed? Can you balance this?
Yeah, thank you for the question, Commissioner Nochese. The reason why I dismissed it by then, in my view, was that there was no longer a rule NISA in front of me. It has lapsed. The one in which it was said the particular municipal manager had contempted on. That's the reason why I dismissed this application. Thank you. And I'm waiting for the judgment on the appeal one so that I can learn more and have a more open on what has happened in the appeal. Thank you, Commissioner.
Thank you, Ms. Mahlangu. Do we have questions from the Commissioner Steinberg?
Good morning.
Good morning, Commissioner Steinberg.
One of the cases you cite as being one that you regard as the most significant, on page 7 of your application, it's Nkomo Marco versus the DPP.
I'm there, thank you, Commissioner.
You say it was significant because there were unique facts and unprecedented question of law, but you don't say what the unprecedented question of law was. Could you tell us what it was?
The application that was brought by the, in this, they were no more accused, they were applicants. They wanted the proceeding, the prosecutorial proceedings against them, against him, specifically to be stayed.
Yeah.
Yes, so for me, it was, as an ex-prosecutor, we used to have such applications. For me to deal with them on the other side of the law, it was very interesting for me. And especially because Mr. Nkomo took this matter as far as to the Constitutional Court. Unfortunately, the Constitutional Court, it was only decided on paper.
But what was unprecedented? Are you saying unprecedented for you or unprecedented in our law?
For me.
Oh, I see.
Yes.
Are you aware that there's a leading SCA judgment?
By then, it's a 2019 case, I think.
Yeah, there's a 2012 leading judgment on the question of what constitutes unreasonable delay on the part.
Oh, I was not aware about that, Commissioner.
Okay.
Thank you.
Thank you, Judge.
Commissioners on the virtual platform, do you have questions for this candidate?
I do.
Go ahead, Commissioner Bernard.
Thank you. Ms. Mahlangu, we have that one complaint, or the complaint raised, or not complaint, the comment that, there might be issues with judicial temperament. And in your discussion with Commissioner Nyambe of the good attribute, you raised the fact that you quote in your words, a very strict person. What did you mean by that?
Good morning, Commissioner Bernard.
Good morning.
By saying I'm strict, I always regard myself as a perfectionist. I prepare and I want my court to be run in a specific way, and so that we can be able to finalize our matters. By being very strict, it does not mean that I do not allow the litigants to present their cases as they want, but by being strict, I mean also my time management as a judge. Otherwise, in the Northwest Division, where you have more than 100 unopposed, and you have the opposed, the urgent application, if I'm not strict and be able to manage my time correctly in court, I will not be able to finalize my matters before 7 in the evening.
So, with those pressures, and also maybe pressures that could be raised by being perfectionist in that way, is that not some, when the members express the views that the candidate is short-tempered, is that not perhaps what they could have maybe read into the type of strictness in dealing with the court?
I don't think so, Commissioner. I think a short-tempered person that I know is the person that will harass or shout or do all the, I'm not that kind of a person. Like I say, no matter how strict, no matter how I'm a perfectionist, no matter how much I can manage my time, but each and every legal practitioner that appears before me has enough time to present their cases.
Thank you.
Thank
If you could work on any aspect of your own judicial skills and training, which aspect would you like to focus on improving?
I've attended the most important one that I wanted, which is the judgment writing. I think that is the most aspect that I wanted. Because Commissioner Barnett, as a prosecutor at NPA, they invest a lot in training, so I've attended enough trainings on different fields. So I think the aspect that I would like as a judge is to attend the intense judgment writing, but I did attend one that was arranged by Judge Modiba.
Thank you. DCJ, if I might just have one more question. It's just a question about the companies that the candidate was involved in. I know I've already asked 2 questions.
No, you may ask.
Thank you. Mr. Slange, one of the companies, I seem to see the name was a taxi company or something like that. Would you be able to adjudicate disputes where taxi companies are involved impartially?
No, Commissioner Barnett, thanks for the question. The reason why we wanted to start that company, we realized of the high cost of petrol in South Africa. So the reason why we said taxi, we wanted to encourage taxis and taxis generally, not owners. We wanted to introduce the gas stations specifically for taxis at the taxi ranks. That's the reason why I wanted to start that company. Not that I'm interested in taxis, I don't even know how they operate, but we wanted to form the company wherein we can be able to establish gas stations next to the taxi ranks or on the routes that are normally used by taxis. But unfortunately, as I've said, that company did not take off because we started it in 2019 and then COVID came.
Yes, I know, but I think the question is as to impartiality. Just obviously you struck up a relationship with people in that industry, and the question is if that does not in some or other way impact on impartiality.
We did, thank you, Commissioner. We did not engage with the taxi owners or drivers or anyone else. Like I said, we call it taxi what company because we wanted to establish the gas stations next to the taxi. Not that we were going to engage with the taxi owners. We were going to engage with the Department of Energy that will give us a license to establish those gas stations. And encourage taxi owners and drivers to install the gas pumps or whatever into the taxis, but we were not going to be involved in that.
Thank you, DCJ.
Thank you.
Follow up, DCJ?
Yes.
Thank you very much. I just want to follow up on the issue. I mean, initially when the issue of complaints about temper and all those things came, I was convinced that this is one of those allegations that people will raise, particularly the litigants themselves. But after saying that you are strict, it made me think that perhaps maybe there are certain things that you need to look into. Because I'm just thinking that especially in criminal trials, and we know how cross-examinations can go, right? Where people just ask irrelevant questions and all those things. And it might be that perhaps maybe you get in and stuff. So the point that I'm trying to make is, have you considered perhaps that when the right to fair trial, the right to liberty are implicated, and the manner in which perhaps you may have conducted some of the trials may have induced a perception that perhaps you are not patient, perhaps maybe you are rushing a litigant or their representatives on the verge of being strict? I'm not sure. Is there something that perhaps maybe it's something that you should look into rather than just dismiss it?
Are we not speculating though?
Yeah.
Commissioner.
No, I accept that, DCJ. I
In
do
any
accept that.
event, I didn't know that strict was a swear word. I would like for judges
I,
to be strict.
I accept that, DCJ. I do. But it's just that just a thought that came to my mind.
Well, let's have an answer for what it may be worth.
Thank you, Commissioner Marumahai. As I've said earlier, that unfortunately this comment it's not clarified, it's not clear, and it's not, if maybe they could have told me where did I show any signs of short-temperedness. And then in criminal cases, Commissioner Marumahai, I become, you let it go, you let the legal representative do their work, the cross-examination and everything. You cannot interfere in the criminal trials or civil trials. That's why I say, if it was clarified, this comment, I was going to be in the best position to say what happened on that specific day.
I accept that. Thank you very much, DCJ.
Thank you.
Thank you, Commissioner. Anyone else on the virtual platform? No. Well, it does appear that we've come to the end of your interview, Ms. Mahlangu. Thank you very much for making yourself available for the vacancy. You're excused.
Thank you very much to you, Justice Maya, and to the commissioners for the opportunity of sitting on this chair. Thank you.
Thank you, ma'am. You're excused. Commissioners, should we not take the tea agenda?
Good morning.
How are you today,
I'm fine, and are you, Chief
Deputy?
Justice Maya?
Yes. No, I'm fine, thanks. This body interviewed you a mere 3 days ago, and for was it the Gauteng, a vacancy in the Gauteng division? So there is no need, in my view, to elicit any further information from you, unless there is something that you want to say to the commissioners that you think is compelling and will weigh in your favor. I will hand over to the JP to put questions to you, but you are free to make any submission now before I do that, if you wish.
And at this stage, unless I've been asked a question, because I do not know where did I fail, but with you, that any questions or any comments, I will perhaps during when I'm asked questions, I will try to explain it further.
All right, and perhaps I can give you an opportunity at the end of the questioning.
Thank you, Justice Maya.
All right. JP, do you have any questions for the candidate?
Yes, thank you very much, DCJ. Good morning. Oh, no, it's afternoon. Good afternoon, Mr. Matsitsi.
Good afternoon, JP.
Yeah, we know each other.
We know each other.
From long ago. And I wondered what happened to you, but I see that after the new dispensation, you exchange the Northwest for Gauteng.
That's correct, JP.
Yes. If my memory serves me well, and I need to declare this, that as counsel, I moved your application, was it for conveyancing?
It was for notary.
Notary.
Yes,
Yeah,
JP.
public, yes. Just a few questions from my side, Mr. Matsitse. First of all, you never acted in the Northwest.
That's correct, JP.
Yeah, and for the past 19 years or more that I'm on the bench, you were not a practicing attorney, you know, appearing in front of me, or the Northwest High Court, for that matter.
I've never practiced there, but however, I've been helping in Northwest. The regional president of Northwest usually will call me to come and assist with matters which falls, it's say, for argument's sake, they need an independent presiding officer. Mm-hmm. So I've been helping in Northwest. Even recently, I have a case, depending on the outcome, that I have to go and deal with it at Lichtenberg.
Yeah, but you never acted in the Northwest High Court.
Never acted.
You were not invited. Yes. Then there's just some remark by the Law Society of South Africa, LSSA. Perhaps you are aware of it.
I'm aware of it.
Yeah, it refers to grammatical and typing errors in judgments.
That's correct.
Do you have any comment as far as that is concerned?
Like I've indicated the last time I was here, first of all, I apologize, and the said errors are really regrettable. And I have indicated that from now on, I will definitely invest on software that deals with grammar and spelling in that regard. And further that, I'll try my level best also to contact the JP to assist in this regard, and the senior judges. For argument's sake, like in Northwest, I know Judge Peterson. We were together in the same Johannesburg bar, and Judge Jaji, and yourself, JP, that I will definitely improve in that. And it's an error that I've made, and then I apologize for that. Further, I wish to state that on the same, if you look at the comments by JCB, particularly they say, if I add paragraph 9,
The candidate's linguistic and communication skills. The candidate seems to have a sufficient command of English language, and his judgments are reasoned. And further, I have made some little bit research, or as I was not doing research as such, but when I look at one of our previous candidates who appeared before before this commission, among others, it was my former colleague, Judge Dlamini, and the same JCB commented at paragraph 8 that linguistic skill indicates some minor shortcomings in English, spelling, and grammar identified in judgments referred to the above. So I believe that one can still does mistakes, but I do acknowledge them. And lastly, I wish to end by borrowing from what has been said by former Chief Justice Ngobo, wherein he was talking about or giving a lecture on writing that not all of us have the natural ability to communicate effectively. However, with study and practice, all of us can improve the quality of our judgment writing. So in that regard, I will say that I will do everything in my best not to repeat the same mistake again.
Yeah. Just the last question, Mr. Matsitse, why do you want to come back to the Northwest now, after being in Gauteng for 20 and more years?
It's not to say I'm coming back, JP. Yes. I've been at Northwest. I was fine. I was born in Gauteng, but my parental homes and everybody was in Northwest. My parents' home is in Northwest. I've built a house in Northwest. I know Northwest. I grew up in the whole area in Northwest. As you know, I've practiced there for some time. So it's not a question of saying I want to come back, just say I'm coming back. Both Gauteng and Northwest are relatively my home. And I believe that wherever the JSC says or the commissioner says he is suitable to can go and serve the people of South Africa, of our country, I will definitely do that. It's both how, if I may just put it that way, JP.
Yes. Thank you, DCJ. I'm covered.
Thank you, Judge President. Premier? No, thank you so much. Colleagues, unless you have a compelling question, I would propose that we excuse Mr. Machitse unless he wants to make some submissions.
That was the main one that JP asked me that I wanted to make a comment about it. All and right. Just to emphasize that JP will be getting, if I'm recommended, I will say not 3 in 1. I've the regional magistrate or as a former attorney, commercial, just a short one in Gauteng. I'm not saying Northwest does not have much cases. There are a lot now, but Gauteng is fast paced. You will have somebody who will be able to can run with anything, anywhere, whether it's Klerksdorp or Rustenburg. I have the skill, I have the knowledge, I have everything. Like as a regional magistrate, you do everything at once. So in that regard, I will say you won't be making any mistake in that regard. Thank you, Justice Maya.
Thank you very much, Mr. Machitse. You're
Thank
free
you.
to go.
Am I excused?
Yes, you are.
Thank you. Thank you, commissioners. Thanks, everyone.
Good morning, Ms. Mokwere.
Good morning, Justice Maya.
Did I pronounce your name correctly?
Yes, it's Mokwere.
Mokwere, I'm sorry. Yeah, I suspected I might be doing something wrong. Okay.
Motswana.
Ah. Well, I'm closer, so I
Yeah, I would,
pronounce names as I
would
see
expect
them.
that you'll say Mugwere.
You have 3 law degrees, a BUris, LLB, and LLM.
Yes, Justice Maya.
And I just found it very interesting that you've obtained each one of these qualifications 10 years apart. On the first one you obtained in 1990, then 10 years later it was the next one.
Yes,
and
in
another
fact,
10 years later.
It's a
it was
pity
another
that in
one.
2020 I did not get anything.
Indeed. You started your legal career in the Department of Justice. That's where you cut your teeth. And you had been a clerk and then became a legal administration officer. What did you do as the administration officer?
During that time, it was in the then Buputatswana. I was working in the company's office, deeds office. It was one office. And I worked with, in the office of checking the trademarks, the copyright, the registration thereof, checking compliance with legislation. I would also assist with, in the company's office, registration of companies and do some stints also in the deeds office.
And 5 years later, you became a prosecutor.
Yes, Justice Mai.
And after another 5 years, you became a magistrate.
That's correct.
And made your way up to regional magistracy, where you are now.
That's correct, Justice Mai.
Where are you stationed?
In Pietermaritzburg.
You have acting judicial experience in that division. That is where you have acted as a judge, not so?
That's correct, Justice Mai.
And when did you do that?
Hey, it's from time immemorial, since 2009. I was just having a discussion with one of the candidates saying, I'm so unfortunate because I would just get one stint here, one stint there. I have been doing that intermittently since 2009.
And how many acting stints have you had to date?
If I'm correct, it would be about 33 weeks or so.
And what kind of work have you done during those stints?
In the main criminal work. I think the last 2 stints, it's when I did some civil work. I was in the motion court.
Was that for the first time?
At high court level, yes.
Yes. All right. So would you consider yourself as experienced in the area, in that area?
Of civil work.
Yeah, in the High Court.
No, in the High Court, I would think that I would be able to cope. I coped very well when I was there. And since 2010, when the regional courts were given civil jurisdiction, I was there from that period until around, I think, the end of 2020. So I noticed that the work is very similar. It's just that the rules differ in there, and there are some things that some issues, legal issues that I only met for the first time in the High Court.
Yes. You have produced written judgments in the High Court.
Many criminal judgments, I can't count those. and about 6 or so civil judgments related to motion proceedings.
Any of those judgments reported?
Not that I'm aware of.
Okay. Have you been taken on appeal? In the High Court, that is?
Civil judgments. I know.
On any?
No, yeah, most of my judgments, the criminal judgments that go on appeal, let me say about 95% of them, they are confirmed on appeal, and 5% would be disturbed maybe when it comes to the issue of sentence. And the civil judgments, I'm aware that 2 of my civil judgments that were taken on appeal the appeal was dismissed.
Yes, you mentioned 2 that were upheld and the rest were dismissed. Okay. The partly heard matters you listed in your application form, what is their status? Has there been any movement?
I think about 3 of them have been finalized. 2 of them are at a very advanced stage, like closing argument stage, is the criminal matters. And the one reserved civil judgment, it's still reserved because when I had to give a judgment at, I think, mid-September, one of counsel was involved in an accident and he was in a coma, he couldn't come. So they were still going to make arrangements, I think for the plaintiff, to make arrangements for somebody to come and stand for him. So the judgment is ready, it's just waiting for him to be available.
The one reserved judgment you mentioned in your application form, has it been delivered?
That's the one I'm talking about.
Oh, all right. When last did you act as a judge, that is?
It was January this year.
Okay. The law bodies have, well, you have been through this process before, and you know that the law bodies send in comments on candidates, and in one of the comments on you, this record is just unraveled now. I think it's the GCB, yes, has raised concerns about your candidature. In fact, it's not fresh concerns, it's matters that were discussed with you when you were interviewed last year. The charges that you take too long to hand down judgments in the regional court where you are permanently stationed, and that you did not start court on time and would adjourn early, and that you absented yourself from work. And they do note that you actually addressed these concerns in 2021, but still felt the need that they should be put to you again. Would you like to respond?
My response, Justice Meyer, will be the same as last time, for the benefit of the commissioners who were not here. Let me just start by saying, I noted that it's only the GCB. Last time there was also Advocates for Transformation. I did not see anything from them this time around. The issue is, I explained about the 2 matters that they raised, the 2 judgments. I explained the issue of the challenge that I came across resulting from the files that went missing. That is what contributed to me taking too long to hand down those judgments. I still stand by the submissions that I made last time. The issue of not starting court early, punctually, like I said last time, when it does happen that the court doesn't start on time, there would be good reasons, which would be circumstances beyond my control, as I'm sure that we are all aware of the challenges that we come across in the lower courts. I specifically alluded to the fact of awaiting trial detainees who are brought to court late on what I can say, a very regular basis where I'm stationed. There are infrastructural challenges that we come across when the machine is not working in the morning due to load shedding. It's no use going to court at 9 o'clock only to come out and be told you have to adjourn because the machine is not working. Those are the factors that would contribute, and it's not even a regular thing, which I did indicate last time that I take it as unfair criticism. The one that hurts me the most is the one where it said that I absent myself from work, I adjourn early. There is absolutely no truth to those allegations. And like I mentioned last time, the advocates in the lower courts come occasionally. The only advocates who come frequently are those that we say are from the independent bar. Those are the ones that you'll see from time to time. And they do not belong to the GCB, I suppose, because I'm sure they would vouch for me. It hurts me because it gives a picture that one does not take his or her work seriously. And it is unfair criticism. My leave record is there, it can speak for me. I'm the type of person who would go to work feeling very sick, to an extent that my colleagues and my court staff would ask me, why did you come? Now to be told that I absent myself, to me going to work has gotten, I'm not being pushed, I love what I do. I go there, I'm looking forward every morning to going to work. On very regular basis, there are cameras where I'm working. I leave the office after all people have left because I want to keep myself busy with something, do my judgments or do something, do research. I love doing research. And I would sit in my chambers until around 6, 7. By the time I leave, it would be dark outside. Now to be told that you adjourn court early, you leave, it's really unfortunate. And there's absolutely no truth to those allegations, like I said. All the other bodies, the attorneys, people who I get to interact with on a daily basis, I'm sure they can vouch for me. They have also made submissions, and there is nothing to that effect in the submissions that they have made.
Do you know if these concerns were ever raised with your judge president? Were you reported to the judge president at the material time?
I have been in Pietermaritzburg since 2004. Not once was I ever called by any regional court president to be, and never once, even, you know, it's very surprising because from the time of Judge Vuka Chabalala, Judge President, he was the first Judge President to invite me to act in the High Court. I'm sure that if there were such concerns, because after him, all these judges president who came after him, they kept inviting me. I'm sure that if there was any legitimacy or validity to what is being said, I take it that they have a responsibility. They should have brought it to his attention and all these other judges president, that how you are inviting a person who doesn't have a work ethic at all, because that's how I am portrayed. And I have to say again, there's no truth to those allegations. And the other thing, when you don't have specifics, it's very difficult for you to even respond, because there's no one who said on a certain date I arrived, the court had not started because of the magistrate who had absented herself or who had decided that she would come to work very late.
Yes. No, thank you very much, Ms. Mkhwere. JP, do you have questions for the candidate?
Yes, thank you, DCJ. Morning, afternoon, Ms. Mutera. How are you?
Afternoon, Judge.
How
Judge
are you?
President, I'm very well, thanks. Thank you, Judge President. How are you?
I'm fine, thank you. Thanks for asking. I see you were born in Ghanesa.
Yes, Ghanesa is my home.
Yeah, but I don't know whether we have met.
We have met, but I was a litigant during my, I think, let me just say, during my divorce proceedings, you are the one who.
I
granted-
divorced you. That needs to be declared, DCJ. Yeah, but you never acted in the Northwest High Court.
Yes, I have never acted in the North. Actually, the last time I was in court in the Northwest is when I was a prosecutor. I left in 2000, and I went to PE, to work in PE in 2000.
Okay. So, why do you want to come back to the Northwest now? After 20 years.
Judge President, if you were Motswana, you'd understand. I was going to put it this way. I think it's time for me to go back home. But
Okay.
besides that, I think I have made my contribution wherever I have been. Like I indicated, I worked in the Eastern Cape in 2000. I was there. From 2000 to mid-2004, then I went to KwaZulu-Natal. At that time, I had it in mind that this is a new South Africa, I need to embrace it, and there's no need for me to be confined here. I need to spread my wings. That's why I decided to go there. And I think age has caught up with me. Not only that, the big thing, if really, my personal reasons, would be that my mother is now in her 80s, and my sister, I have a sister, in fact, let me just explain it. We are 4 at home. I have 2 brothers, they are unmarried. My sister is blind. She's staying in Mafikeng. I also have a house in Mafikeng. That's my own house. My home is in Ghanesa. And these 2 people need me the most. They have really appealed to me to consider coming back home. Because my sister doesn't have children. Let me say she has 1 child, a boy who stays in the streets, and if he's not in the streets, he's in prison. Yeah. And my mother, being an elderly lady in her 80s, they need me. My sister's husband died in 2018, the person who was looking after her. So every time they get sick, I have to drive from Pietermaritzburg to go to the Northwest, get them there, and take them to be with me, because so that I can be able to look after them while they get the necessary medical care. So that, to me, is the main reason. And I also want to work at home. I want at least the people of the Northwest, people of Mafikeng, must just get a bit of whatever is left in my skills to serve my people. I'm not by this, I'm not implying that the KwaZulu-Natal people and the Eastern Cape people are not my people, but I'm sure you understand what I mean.
Yes, thank you. The last question. I've listened to what you said about the exposure that you had in the High Court as far as civil work is concerned, especially motion court. It seems that you did 6 matters in the High Court.
Opposed motion, yes.
Opposed motion.
It's
Now,
not 6, I think about 2 matters I gave extempore judgments because I had prepared.
Yeah. But most of the role in the High Court Northwest consists of civil matters, mostly. Don't you think that you still need to get more exposure and more experience?
Judging from the 2 stints that I say I've had in the civil court, in the High Court in Pietermaritzburg, I believe that I can cope. Because I would say it's not only those civil cases, that was opposed motion, but when it comes to motion court, you have to prepare every file. And in Pietermaritzburg, you get about 30 files when you have to go to court, and you go through all the files.
Have you ever, have you ever done a civil trial in the High Court?
I haven't done a civil trial. I only did a divorce trial, which I've finalized.
Yes,
But I must, can I also indicate, JP, that I've done a lot of civil trials in the regional court, which are not very different from the trials that I've seen. The only area of the law where I would say I would have maybe some challenges are those matters that we do not deal with at all in the regional court. I believe that my competence to do civil trial, I think I am competent to be able to do a civil trial. As I say, for about 10 years, since 2010, I've been doing mainly civil work in the regional court.
Yes. Thank you, DCJ.
Thank you, Judge President. Premier, any questions?
Just one question from my side. Dumela mme Mogwera.
Dumela ra le kae re mape?
Ke a utlwa o tswa Phohung.
Ke a itse o tswa ko Phohung. Nna ke tswa ko Khuti.
Oh, wena o tswa ko Khuti.
Ko Chief Block.
Okay.
Ko ga Musiane.
Okay. The Northwest being a very vast province and being very rural, and sometimes there's a sense that the courts do not reach people in far-flung areas like Bray and so on. What do you think you would contribute to ensure that you make the court available to people in those far-flung rural areas?
Thank you for the question, Premier. I think it is a very valid thing. In fact, I was just thinking about it now. I was thinking about people coming as far as Bray. I even calculated, I checked, I Googled to see the distance is about 300 kilos. And I was thinking to myself, it's better when the court is taken there to the people. But the challenge, the big challenge that with the Northwest that I have picked up is that it's the criminal courts that go on circuit in the High Court. People, the court is taken to the people. But I'm thinking of a situation where a litigant has to travel for more than 300 kilometers to reach a court in Mafikeng, and I don't think that is right. So, as somebody who, if I happen to be considered, the only thing I can do is to appeal to the Judge President and maybe give some suggestions as to how this can be done. I do not understand why there has to be only one seat, because really it appears that the powers that be are not considerate to the rights of the people. So the only thing, because I think in my capacity, there isn't much really that I would be able to do, but just to appeal to the powers that be and plead with them to consider having maybe a second seat in that part of the province. I'm thinking also about the other part of the province, Taung and the areas surrounding Taung. As far as I'm concerned, it's also far for them to travel to Mafikeng. It really boggles mind why there would be only one seat. But with the criminal courts, I don't suppose there's a big problem, because I know that the judges do travel to these far-flung areas. But that's what I would do, and I would do my best to try and pursue it and persuade and make a lot of noise to the ears of, if I have an understanding JP who would be able to allow me to make noise to him. And perhaps knock your door every day and say, Premier, do something.
Thank you, Premier. Commissioner Nyambi?
Thank you, DCJ. Afternoon.
Good afternoon, Commissioner Nyambi.
One question from my side. The interviews that were held in April 2021, any other thing after hindsight, proper reflection that you might think you haven't done justice to yourself that you might want to correct today? Linked to that, probably some significant changes to the person that we interviewed then that you think you want to bring to our attention so that we can seriously consider this time around?
Yeah, I did a very serious reflection, Advocate Nyambi, after the last time. Okay, the first change that I would perhaps highlight, when I left here, the following day I was in court. The first thing I found my court staff waiting for me with, they had a book, because I had indicated in that interview that when the files got misplaced, my notes were in the file. I had that habit of writing notes in loose pages and putting them in the file. So I remember very well that Justice Maya suggested to me that I should consider buying myself my own books where I would keep my notes. So I found it very interesting that my court staff who were watching the interview, I'm sure even today they are watching, they had bought me a book. So now I'm keeping my notes very safe, and I'm very particular with knowing where my work is and not leaving it. I have done very serious reflection, as you have indicated, and I've told myself that, you know, whatever excuses that people can have, I know that you will never be able to please everyone at all times. But I want to do my, I told myself that I want to do my best to give people that impression, who have that impression about me, that in fact I'm not that type of person.
Thank you, Ms. Mukwera. Thank you, DCJ.
Thank you, Commissioner Nyambi. President Betze?
Thank you, DCJ. Good afternoon, Ms. Mukwera.
Good afternoon, Justice Betze.
I have only one question for you, and it relates to one of your judgment. It's an appeal judgment had in Pietermaritzburg. Mbongeni Sitole versus the state is at paginated page 38 of the bundle. Please let me know when you get there so that I can proceed and pose my question.
Yes, I have it, Justice Betze.
Okay, by all accounts, this is an appeal judgment from a judgment of the Pietermaritzburg Regional Court.
That is correct,
But
Justice Betze.
there's no indication from the face of that judgment who the second judge was. Did you sit alone in that appeal?
No, I did not. Might have omitted to put, I think I was sitting with, I think Judge Poyo.
But as I say, there's no indication that
Yeah,
you sat with
there were-
another judge and that whoever you sat with
There were some judgments
is aware of that judgment and co-signed it.
Yeah, no, I see, I see your point, but I think I was sitting with Judge Boyo. There were some judgments that I printed from my laptop because I had asked that, I went to the High Court to try and get some judgments. I could only get some, and others I did not get, so I got them from my laptop. But as far as I can remember, I was sitting with her.
And did you run through all the judgments that you wanted to attach to your questionnaire? Because if you had done so, you would have picked this up.
I would have, but seemingly I did not pick it up. But as far as I can remember, I think I was sitting with her. If this is the judgment of negligent driving, I think I was sitting with her.
I take it that you are aware, of course, that in terms of the law, appeals, be it civil or criminal, from judgments of the magistrates court must be heard by two judges. in the
Yes,
High
I'm
Court.
aware, Justice, but
Thank you.
Thank you.
I have no further question, DCJ. Thank you.
Thanks, Justice Spitz. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good afternoon, Mayor Mokwera.
good afternoon, Commissioner Mwimang.
Just one question from my side in relation to the matter between Hlala and Dlamini. I think it was on the it was brought in terms of the Prevention of Illegal Eviction from Unlawful Occupation of Land Act. Can you remember that judgment?
Yes, I remember it.
Yeah. I'm impressed in terms of how you dealt with the matter, particularly given the issue around the insecurity of tenure, particularly to the rural dwellers who found themselves trapped under the communal land ownership. What is your view in view of the fact that the Concord has also made a pronouncement in terms of the manner in which Ngonyama Trust has dealt with the matter of land occupation in that area? And do you feel vindicated by your judgment? Thank you.
I did not get the question clearly, Commissioner Mwimang.
I'm just saying that in view of the Concord pronouncement on the work of the Ngonyama Trust, do you feel vindicated by the judgment that you gave in this matter?
And I wouldn't want to say much about, I know it's a very sensitive issue in KZN and the issue of the Ngonyama Trust, but let me just say that at the end of the day, everything that we look at, we have to look at it through the prism of the Constitution. As much as the traditional authorities are very, it's a very good institution for us to have as South Africans. Even the way they conduct their business has to be in line with the Constitution. By this, I'm not saying that it is wrong for the traditional authorities to be the owners of land. But at times, there are some of our cultural practices that are still a little bit discriminatory. Like in this case, I observed that the only reason why this lady had to vacate, was required to vacate, because that was the application that was brought by the person who was claiming to be the lawful possessor of the land, is because she was no longer married, and there is that belief that because she is no longer going to be belonging to this family, she has no business continuing to reside there. So I'm just saying that I'm glad that the Constitutional Court has made that pronouncement that you are referring to.
But do you, in view of the dual ownership regime, or the dual property regime in South Africa, which secures property rights of those that live in urban jurisdiction, and the lack of security of tenure of those that live in areas under the traditional leadership, it's a matter that has to be given attention to, because it's unfair that after 27 years, people that are living under communal land ownership still do not enjoy the property rights as guaranteed in terms of our Constitution. Thank you.
I agree, Commissioner Mima.
TCJ, could I make a follow-up on this? My question was also related to the same judgment.
Yes.
Thank you. Good afternoon.
Good afternoon, Commissioner Ngogaito.
Ms. Mukheru. Could I just ask you, so the response you've now just given, that the basis for the eviction was the marital status, that she was no longer married to the person that she had been married to, and therefore the new possessor came and attempted to bring PI proceedings. Did I get that correctly?
In fact, what happened in that matter, Commissioner Ngogaito, the respondent was married to the son of the applicant, and that marriage came to an end by way of divorce. And what happened was after they got married, they built a house on the land. And upon the dissolution of the marriage, they came to the magistrate court, which granted the dissolution of the decree of divorce. And the issue of the house, immovable property, was not entertained. In fact, they had a settlement agreement whereby it was agreed that the issue relating to the house would be referred to the traditional authority where the house is situated, to be decided by the traditional authority. That was in terms of the agreement, the settlement agreement. And to cut the long story short, what happened was there was a meeting where the matter was not finalized. According to in fact, there's a dispute as to how the matter was finally resolved in that meeting. But the reason why they came before me is because now the person who was claiming that the land belonged to him, being the former father-in-law, said that she is in unlawful occupation, that is the lady now, because there was never an agreement that she would continue, she would remain being there. In fact, she never had permission to remain there because he had given the land to his son, and there was a condition that the respondent will reside there for as long as he's married to the son, something to that effect.
Yes, no, I understand those facts. I was just looking for the jurisprudential basis for the judgment. But nevertheless, let me ask you something else.
I might have misunderstood your question.
No, that's fine, no problem. I don't think you have. I want to ask you something else about the judgment. On whose name was the permission to occupy registered? Because I couldn't work that out from the judgment.
There was a permission to occupy, which was only given to the applicant in 2016.
Yes. So the respondent did not have a PTO in their name.
The respondent did not have a PTO, but the requirement of the requirement that there should be a PTO, according to the evidence that was led there, only came later. In other words, at the time when they took occupation, the husband and wife, there was no such requirement.
Yes. Yes, well, and then also what is confusing in the judgment is when you make reference to that dispute, there's a case, another case you referred to, which involved two separate church institutions, where you say, my understanding of the basis for the judgment is that a lease concluded under the authority of the Ingonyama Trust Board does not trump a permission to occupy. But the problem is that the facts do not show that she had a permission to occupy.
According to her, although she did not have a PTO, the land had been allocated to her. That's where I say there was a dispute. The land had
Yes.
been allocated to her and her husband.
Yes. No, I
That was
understand.
her case.
No, I understand. That's what really strikes me with it, is that it seems that there was in fact a different basis on which you could have reached the same outcome, which is either, as you say, a discrimination case under Section 9, alternatively a customary law case. But if you had gone the customary law route, then you would have had to assert her entitlement as a woman in customary law to occupy the land. But you went a different direction, which is not supported by the facts, because the direction you took was an ITB lease doesn't trump a PTO, but there are no facts upon that.
May you kindly refer me to?
What do you want me to refer you to?
Refer me to where you say I made that finding.
All right, let's do this now. Yes, so your judgment is at page 46. You've got it?
Yeah, I've got the judgment.
Yes, so
If
now
you can
let's...
just refer me to the relevant paragraph.
Yes, that's fine, I'll do that now. So the legal analysis starts at 55. Actually at 56. Yes, it's in paragraph 38 at page 60, where you refer to the 12th Apostles' Church decision, which you say enlightens you in the approach that you should follow. But that's a case where there is an existing PTO, and your case is not one where there is an existing PTO of the current occupier of the land.
I'm sure I approached it from the fact that he was asserting that he has a PTO, and I was saying what weight should be attached to the PTO. That's why I say in that court, in that case, the court held that the pre-existing rights of occupation held by the one church group which had the PTO. Can I just read the whole thing so that at least you can get the light of what I'm saying?
Yes.
In that case, there was a dispute between two church groups over the right to occupy land. The first group, having held the land in terms of the PTO, obtained prior to the second group. The two groups had the PTO. Then the court held that the PTOs of pre-existing rights of occupation held by one conclude, that is the first group, cannot be infringed upon or be overridden by the leases concluded later with the second group. Remember that in this case, the PTO that we are talking about was obtained after the respondent had been given whatever he said she got. Is not necessarily a PTO, but the permission to reside there.
Yes, no, I accept all of that. All I'm saying is that I think the outcome is probably correct, but I worry about its jurisprudential soundness. Because if you look at paragraph 40, there the respondent neither has a PTO nor a lease concluded with the ITB. But you then come to the conclusion that an ITB lease doesn't trump a PTO. So a reader is under the impression that you are talking about a holder of the PTO and a comparison between the relative strength of the rights of the two, whether it is an ITB lease or a PTO. But you are in fact dealing with a respondent who has neither. And that is where I wonder whether a better, jurisprudentially stronger basis for coming to her rescue wouldn't have been customary law rights under IPILRA, which you cite at the beginning of the judgment but never follow through. Alternatively, a discrimination claim, and that's the only point I want to put to you.
The last portion of the judgment, considerations of justice and equity, that's where I dealt with the latter, what you have referred to, the equality. That's where I dealt with
Yes, but that was on justice and equity. You were here dealing with the analysis of the respective rights of the parties, and that's what I'm asking you about, where you ultimately concluded based on this 12 apostles church. But anyway, I've already asked you enough about that. You've given your answers. There's a second question I want to ask you about. Why did PI apply to this land? Because PI ordinarily applies to urban and peri-urban land, and this looks like it's rural land.
That's something that I raised with both counsel, and let me just indicate that they were both represented by advocates. I raised this just from the very onset before we started. That's the query I raised. They said the counsel for the applicant said he could not rely on PI or on Esther because the whole basis, the whole case of the applicant is premised on the fact that the respondent is in unlawful occupation. And Esther does not cover unlawful occupiers. It would mean that he's got, that's what, I was convinced, and they both agreed, let me say both counsel agreed that is, the remedy can only be found in PI, where Esther does not apply.
Sorry, I'm really struggling to follow that. The statute defines the category of property it applies to. Two advocates come to you, they say, even though the statute says X, we agree on Y, and then the judge goes with the advocates, not with the statute.
The main reason why Esther was not applied here is because this case is premised on the fact that the respondent is in unlawful occupation. Is an unlawful occupier, which is not covered by Esther. And not only that, where this house is situated, where the land in question, it is under the authority of the chief, yes, but it is land that was previously a farm area, which had been rezoned. I'm sure you can see somewhere where they say it's in the location of So it's neither a rural area or an urban area, as you put it, maybe peri-urban. But my dealing with the matter on the basis of PI is because this was the respondent was said to be in unlawful occupation. The case of the applicant was premised on the fact that she is an unlawful occupier.
Sorry, this is my last point on this. The Act, as I say, tells you that it applies to urban and peri-urban. They then bring an application in respect of rural land. Are you saying that you found that PI would be applied because the lawyers were not disputing it?
I'm not saying it's because the lawyers are not disputing it. I'm saying that I was convinced at the time that because of the unlawful occupation, the respondent was said to be in unlawful occupation, ESTA could not be applied. Not because they were saying so.
She's given her answer, Mr. Ngwenya.
Ye-
We
yes,
do not
indeed,
like
Mr.
it.
Chair. I'm quiet
It is
from
what
now
it
on.
is.
Follow-up, Deputy Chief Justice.
Sorry, where's that coming from? Oh, I'm sorry, Prof.
No, I'm also troubled by the reasoning. And perhaps maybe the judge may assist that. Good afternoon, Judge.
Good afternoon.
I just want to understand. Are you saying that when two legal practitioners appear before you and they argue on clearly incorrect basis legally, and they seem to be in agreement that whatever it is that they are agreeing on can be dispositive of the matter, you listen to them and you continue to dispose of the matter on that particular issue? Is that your response to Advocate Ngatobi?
I'm saying I was convinced when I was informed that, because I also saw that ESTA would not be applicable where the eviction is sought on the basis that the respondent is in unlawful occupation. And on that basis, I decided the case using, that's all I'm saying.
Okay, no, it's fine. I will leave it there. But I'm just wondering as to why you then did not look at the common law as well. But anyway, I will leave it there. The Deputy Chief Justice.
Thank you, Commissioner Merumahai. Commissioners on the virtual platform, do you have questions for this candidate?
I have a question.
Please ask away, Commissioner Bernard.
Thank you. Ma'am, in your, the same case, Leila versus Lamini, my question is this, you referred the matter to oral evidence. So I've got two questions in that regard. The one question is, how did you find that experience? And I ask that as a result of your statement earlier that you haven't dealt with opposed trials yet. So obviously there was some oral evidence being presented in a civil matter. That's the one side aspect of it. But the second aspect of it is the dispute of fact that you saw there. Why could that not have been sorted out with the Plascon-Evans rule? You know, the way one deals with in applications.
The first part of your question, Commissioner Barnard, it was not the very first time for me to sit in a civil trial. As I indicated earlier, I have dealt with civil trials before, not in the High Court, but in the Regional Court. The dispute of fact here was whether the respondent, which version was acceptable, and I could not come to a conclusion that this one is so far-fetched or untenable that I can reject, being the respondent's version that in fact the land was allocated to the husband and herself. On the other hand, the applicant was saying the land was allocated to him and he gave it to the son to build the house there. That is what influenced me to say, because this is a very serious dispute that I cannot resolve on the papers. I should refer the matter for oral evidence. So the experience, how did I find it? It was just like an ordinary civil trial.
Thank you very much.
I
Thank you,
don't know
Dean.
whether I answered. Is there anything that I left out?
Now you've answered. Thank you very much.
Anyone else on the virtual platform? All right, Ms. Mukwara, thank you for making yourself available for this vacancy. You are excused.
Thank you so much, Justice Maya.
Are you comfortable, Ms. Divet?
Yes, thank you.
Good afternoon.
Good afternoon, Acting Chief Justice.
Are you well?
I'm well, thank you.
Good, good. You hold 2 law degrees from the University of Stellenbosch, a BA degree and an LLB degree,
That's
which
correct.
you obtained in 1995.
Yes,
And then you became a junior lecturer there at your alma mater.
yes, I did for a year.
But just for a year, was it?
Yes, I was doing my LLM at the time in labor law and in arbitration. And as I indicated in my application, I completed the 4 subjects for the LLM, but then I started working as a labor consultant in Worcester, and then I joined the bar, and then I guess as a result of the new practice and so forth, I did not complete the mini thesis, as we called it in those days. So that's why I was appointed for a year period.
Yes. And you never completed that master's degree?
Yes, no, I'm very sorry about that, and I must still do something about it, but I think life and the practice
Life
and
caught
my
up
family,
with you.
yes.
Well, I see that you had 4 children in the interim, and I think I understand exactly what happened to you.
Thank you.
You joined the Cape Bar in 1997,
That's correct.
and that's where you are at the moment.
Yes, I have been practicing there ever since.
All right, it's been a long while. What kind of work do you do? What kind of cases engage your practice?
I initially, because I came straight from university to the bar, most of my work consisted of pro bono criminal work and legal aid work, and I really had to work hard in order to establish myself at the bar. I didn't really know any attorneys, or I didn't have any connections in order to rise in my practice. And I would say after about 8 to 9 years in practice, I did a little bit of civil work in the beginning as well, divorces and unopposed motions. But I would say after I was at the bar for about 10 years, my practice started developing into more serious matter, and I started doing different matters, a bit of commercial law. But in general, my practice has really been focusing on labor law and on matrimonial matters in the context of children.
And I see that you have been serving as a commissioner of the Small Claims Court since 2004.
Yes, I have been. I'm still a commissioner. Obviously, when I'm acting, I can't sit as a commissioner, but during recess and the times I did not act, I would do double duty. But I think that the Small Claims Court is such an important institution to make sure that everyone has got access to justice, that I'm very proud that I've been involved there for so long. And it feels good to be able to give that facility to everyone in the country.
Yeah. Do you believe that the experience you would have gained there would assist a career in the job you seek today?
Yes, I think so. Obviously, it happens in a court context, and it's over the years it's become a bit more complex, seeing that there's the limit for amounts you can claim in the Small Claims Court has increased. But definitely, it has given me a lot of experience. None of my judgments there has ever been taken on review, and I also, in that context, I've also always tried to see if the litigants can't resolve their differences when they arrive at the Small Claims Court, because often people that arrive there really want an opportunity to state their case and to be heard. And when the other party, without any lawyers being present, there's often the parties reach some or other resolution with regards to their dispute. And I think that's also extremely important that parties get that opportunity to try and resolve their differences prior to a court or a commissioner giving a judgment.
You have had a number of acting stints in the Western Cape Division
Yes.
of the High Court, starting in 2017 already.
Yes.
And are you acting there now?
I'm acting at the moment. In 2017, I just did half a term, and then during 2020, I think it was during the hard lockdown and COVID, I also just did half a term in 2020. And then in 2021, last year, I was privileged and was invited to sit for a full term, and then I think I did the second, third, and last term in 2021.
Mm-hmm.
And then in this term, this year, I acted the first term, and then I acted last term, and I'm acting now as well.
Yeah. So you have had ample opportunity to sink your teeth into the work.
Yes.
And I see that you've been exposed to a whole range of cases during those stints. You listed 5 reserve judgments when you submitted your application. Have they been delivered yet?
Yes, all of them.
All of them?
Yes.
All right. And the part-head matters you mentioned?
I've still got quite a few part-heard matters. I started, I think, in the last term last year. I was allocated a human trafficking criminal matter. It involves over 40 charges, and it started November, and we've been, depending on availability of various factors, we've not been able to finish the matter yet. We're hopeful that the state would close their case at the end of this term. So we're making progress, and as I said, the main reason really why it's taking so long is that we need 2 interpreters. A lot of the complainants only speak Afrikaans, so we need an Afrikaans interpreter, and 2 of the accused is from a different country, and we need to, I don't want to say too much about the matter,
Yes.
but so we need to translate it into 2 different languages, and that really makes it difficult to deal with the evidence quickly. And then obviously we're also dealing with young complainants, and they come from all over. They make arrangements to bring them from whichever province they live in order to come and testify. And we must obviously also have the necessary support systems in place. Some of the witnesses had little babies and they were still breastfeeding.
Mm-hmm.
Other still had some lingering other problems that we had to deal with we're still dealing with that during the trial.
Yeah. How many written judgments have you been able to produce during your acting stints?
I attached, I think, 8 judgments to the application, as it was requested that we attach at least 5.
Yeah, we limit the number.
I see from the comments from the Bar Council that they could only find 9 written judgments that I've delivered, and I made the effort to actually go and look at how many written judgments I've delivered, and I have delivered, besides these 9, at least 30 written judgments. I have them here, or I have a list of them. And then, of course, especially in 2021, I was allocated 3rd Division duty, as we call it in the Western Cape, where you deal with the role, the motion court role, as well as all the urgent applications. So in that court, and dealing with urgent matters, I mostly dealt with the matters extempore, or I would, in very few of them, I would write judgments, unless the circumstances required it. So I've dealt with a substantial number of matters. I think just in 2021, with third division stints, I dealt with more than 600 matters that I could find whilst I was looking now. But they're, of course, undefended matters that we deal with on the opposed motion roll.
All right. On average, how long did it take you to produce these judgments?
On average, I would say about 2 months. If the matters are more complicated, or I need to, I do believe that people is entitled to proper reasons and why, especially the litigant who was not successful expects reasons as to why a court made a certain decision. But on average, I would say 2 months.
Mm-hmm. Have any of them been reported?
I have, in the meantime, since my application, I've issued 2 judgments which I think they've been published on SAFLI, and I don't know if they'll be reported, but one of my judgments was reported. I think it was also the criminal case I dealt with against the Minister of Police.
Mm. Okay. The professional bodies have sent us comments on your suitability as a judge, and says they are not aware of any role that you may have played in transferring skills to junior practitioners from the historically disadvantaged section of our society during your entire career. And they go on to say you have not demonstrated any affinity to play a role in advancing the ideal of transformation,
Yes.
to justify your appointment in this division that still requires representativity and diversity on the bench.
Yes.
I don't know if you want to respond to this comment.
Yes, if I may, I don't think that comment is correct, and I don't think it's fair. Even to my application, I've attached a very well substantiated letter. It's on pages 26 and 27. This is now in my bundle, of Advocate Davis, who was one of 2 pupils I had. They were both women, and they both previously disadvantaged women. And you would see from that letter, written by my former pupil, which made me feel very proud, as to what I did just for her and other young practitioners as an advocate at the Cape Bar. I have always informally mentored all female advocates at the bar. My door's always open. I've had fee-sharing arrangements with Advocate Davis, for example, but also other practitioners within the labor field. The state attorney, even though I am not a silk, I do a lot of labor matters for the state attorney, for the Department of Education, Department of Social Development over the years. And I have often there worked with juniors on a fee-sharing basis. And as Advocate Davis has stated here, this has assisted her to build on her labor law practice over the years. So I don't think that comment is true. I most definitely have assisted in my practice and in my personal life in order to transfer skills and make sure that everyone has an opportunity to practice law if that is their passion and what they want to do.
All right. The GCB has made a strange comment. I'm not sure I even know what it means, but I'm going to put it to you so long so that you can defend your honor, because it's in the public domain.
Yes.
And you can tell us what you think of it. They say some members, while viewing her performance as an acting judge favorably, expressed reservations about the candidate as a practitioner in private practice concerning her ethical standards, moral compass, independent-mindedness, and judgment, and it ends there. Do you want to say something to that?
Yes, I would like to say something about that, Acting Chief Justice. I was initially, when I saw this comment, I was extremely disappointed and upset. But having considered it and looking at the rest of the report, as you correctly mentioned, it is actually quite a strange statement to include in this, because if you just look at the very next page of that comment, they carry on, whoever the reviewer was of this report, and I'll get to that now, which says then, on the very next line, paragraph 2.2, that considerable but not unanimous support was expressed by members for the candidate's appointment to the bench. And further on, in the same report, with regards to, I think it is on page, dealing with the candidate's independent-mindedness, it is commented that nothing in the candidate's judgment suggests that she is not independent-minded, and I am still recommended. I just do want to point out that when the JSC sent out a letter or the General Bar Council sent out a letter to all the advocates and the different bars asking for comments, and to that, they attached a template in the form of what the JSC wanted them, how they wanted them to complete it, and they also gave guidelines as to how to, for reviewers, how to deal with comments and in drafting this report. And very importantly in those guidelines, it says in paragraph 24 that any comments pertaining to character carries a significant risk, because people make comments at the bar. We in a litigious environment where we have litigated against each other on various occasions, and that one must always be mindful about the fact that comments may be made to settle old scores. And therefore, further on in paragraph 29, it specifically says that character comments, favorable or not favorable, should not be included in any such report without there being a full statement of the facts and the circumstances giving rise to such a comment. And there's absolutely nothing.
Yeah, speaking for myself, I'd like to think that any lawyer worth their salt would not submit input of this nature. It's gibberish. I mean, in essence, and it does not assist this body at all. But that said, they also mentioned that you once applied for silk and was not recommended. May I ask what happened with that application?
Yes, that was in 2019. I can't remember how many applicants we were. I was not, we were, in fact, quite a few women applied at the time, and only men were appointed as silk at the time, and we were not afforded any reasons as to why, still not, as to why, any of us for that matter, why our applications were not successful. So unfortunately, I think that that's a problem, one of the problems with the whole silk application system, but it's impossible for me to know or improve, or if I don't know why I was not appointed as silk when I applied.
You have not applied again?
No, I've not applied again.
Why not?
I think my life just took a bit of a different route. Firstly, in 2020, when I acted for that 4 weeks during the COVID period, I realized that I would really like to, if I could, pursue becoming a judge more actively. And with the good graces of our JP, I was invited in 2021 to act more regularly, and it was a good break for me from my practice, which was dearly needed. And further, I really enjoyed acting. I felt, and I feel I make a difference on the bench, more so than what I do in my practice. So I didn't pursue it again. It's not something I...
Okay. Well, before I leave the GCB submission, there is a comment they make which does what one would expect. It provides particularity, and it's in respect of something that is quite important. They say you delayed judgments, and they mention 3. One, no, it's 2 actually. Rust against Kutsie, which they say you delivered 5 months late. And the other one is AVW against SVW, which they say you delivered 6 months after the hearing.
Yes, I saw that. And yes, they were not the second one, but the first one, I admit that it took quite a period of time, and I would like to, unlike most of the other matters I deal with, that particular matter, I attached the judgment. The history of that matter is that it was allocated to me already, I think, in June, July, and the matter could not commence because one of the expert witnesses was not available. We then started the trial. I think if you look at the judgment, it looks like it was that it only was in court for 1 day. But we, in fact, sat in court with very extensive evidence for a long period of time. We were in court on the 23rd and the 24th of August. We were in court on the 16th and 17th of September. We were again in court on the 25th of November and on the 30th of November. And then I got further submissions on the legal aspects raised, and dealt with experts, a joint minute that one of the experts said he's not bound to anymore. And then that brought us to the finalization of the matter only at in middle December of 2021, after hearing the matter for a long period. And obviously in the interim, I dealt with various other matters. So I could only properly apply my mind, look at the video footage again, consider the expert evidence properly, and then give, I thought, a well-reasoned judgment. In the beginning of May, there has been an application for leave to appeal in that matter, and I have granted leave to appeal. It's one of only 2 matters that I have granted now. In the interim, in another matter, I've also granted leave to appeal. So it took a little bit longer than it should have, but I think in the circumstances, I did justice to the parties by properly considering everything that was placed before me. In the other matter, the matter came before me as an urgent. In retrospect, I probably should have postponed the matter to the semi-urgent role, which would have meant that it probably would have been heard in February. But I listened to the matter in the urgent court, and I was convinced that seeing that a settlement agreement had been signed between the parties, and it's a divorce matter, that it should be dealt with expeditiously. So I then afforded both parties a chance after the 21st of October to submit comprehensive heads of argument on the issue that they raised in that matter, which they did. And I then gave an order, it was an interlocutory order, saying that I am granting the one party leave to defend. I gave that order in January. Then I tried to find it, but I couldn't. Then there was a request for reasons shortly thereafter, and I gave those reasons in the beginning of April. So it's a little bit unfair. As I said, it was an interlocutory order, and I gave an order, and I gave substantial reasons for that order in April. So it's a little bit unfair to say it took me 6 months. If all the circumstances were known, that is not the case.
Well, they do say that you generally deliver your judgments promptly.
I see. Yes.
Okay.
I did.
No, thank you very much, Mr. Vet. I'll hand over to the rest of the commissioners, starting with your JP, Judge President Klobe. Do you have questions for this candidate?
Good afternoon. Thank you very much, Deputy Chief Justice. Good afternoon, Mrs. DeVet.
Good afternoon, Judge.
A lot of questions that I wanted to ask you have already been asked by the Deputy Chief Justice. May I start off by confirming that you have acted altogether for a period of 6 months in my division. On each of those occasions, I invited you to act.
Yes, Judge.
I can also confirm that I sat with you in a criminal matter many years ago as an assessor. I think that's about 20 years or so when we met. Right. Now, the first question I would like to ask you is this. In the period of about 6 terms during which you have acted,
Yes.
how many judgments were in fact reported? I'm not talking about the reportable judgments. I'm talking about judgments that have in fact been delivered by you, which have in fact been reported.
Thank you, JP. So as far as I could see before today, it's only the one judgment dealing with the police matter, the Hala matter.
Right, so it's one judgment.
Yes.
Thank you very much.
I do just want to point out, JP, if I may, during last year in 2021, as you would know, I did a lot of third division work, and this year, this term and last term, I mostly sat with my criminal matters. So I wasn't allocated civil work unless, of course, something happened and I was and advised you that I was available. But I've been part of the backlog program for the criminal trials, and I have done my best in that division. Obviously, you don't write reportable judgments there, but in order to get that matters dealt with.
Thank you. Let's talk about crime. How many criminal trials have you in fact finished?
I'm still busy with the human trafficking trial, and I have also started another one last week on the criminal backlog role. So since I've been acting, I've not finished a criminal trial.
Not finished. Thank you very much.
I have, however, dealt with quite a few bail appeals. I've dealt with many 304 reviews with other judges, where even with you, I think, where I've gone through the process of the review from the magistrate court to the high court, and all the difficulties that's with delays and so forth in order to get that going.
No, I accept that. Of course, the skills are different. When we
Yes,
talk
no, of
about the
course, Judge.
trial, it's not like reviews. The skills are totally different.
Yes.
Thank you very much. What's your understanding of the word transformation, Ms. David? What does transformation mean to you?
I always think these questions are so difficult to answer, but for me, transformation means that in a country such as ours, we need to, and I think it's in the that's the aim of the Constitution, we need to address previous discrimination which resulted in imbalances in people of color, women not getting the opportunities and being in positions where they should be. And for me, that is transformation, to get to a situation where everyone have equal opportunities, where everyone, regardless of their gender or color, can be, and that's the transformation process to get to that point. I think we are still in the transformation process, and I'm very glad to see that so many more women and previously disadvantaged individuals get the opportunity to sit as judges or magistrates or positions of importance. I think it sends a very important message also to the community at large. You know, JP, when I started at the bar 25 years ago, when I applied to become an advocate, we were the biggest group of women who ever applied to become advocates. We were 18 women, and that got admitted, who passed the bar exam. And within 4 years, only 4 of us were left at the bar, and a year later, only 2 of us were still left at the bar. And today, it's still the same 2 women, myself and another female advocate at the bar.
Right. Is that your complete answer to transformation? What it means? There is a second level of transformation, which is the mind and the mindset.
Yes.
That's why you have certain values enshrined in our Constitution. What do you say to the second level of transformation?
Of course, Chief Justice, there must be a change in the mindset of people and the way people are dealing with each other. I don't know how to take it any further than that, but the transformation needs to get us to a point where we are all equal and where everyone has the same opportunities. Eventually, and that's why we need transformation.
Well, I think it's fair to ask you this follow-up question. There were degrees of oppression in South Africa in the days of apartheid, with whites having more privileges, followed by Indians, colors, and the Africans were right at the bottom of the human race. Now, what would transformation mean in those circumstances, where, for example, there is a white woman who was privileged, and that white woman is up against an African woman or an Indian woman or a colored woman? What do you understand transformation to mean in those circumstances?
Yes, Judge President, I hear what you're saying, and I say that I believe that in those circumstances, and I assume we're dealing with my particular position as well, that a black female candidate who's qualified and the correct person to be appointed in the position should, in terms of transformation, probably have a better opportunity than me. I do, however, think that that's not the only thing that counts. I think that you must also look at the demographics. Yes, I am a white female, but yes, I have also struggled to get where I am today, and I think one must also look at the bench as it is in the Western Cape, definitely as a result of your efforts, I would say, by giving a lot of women the opportunity to act in the High Court. We see that in the High Court of the Western Cape, there's quite a few female judges, and obviously with later appointments, black judges and women of color. So I hear your question, but I think one must look at demographics as well. And in the Western Cape specifically, there's only 3 white female judges. The one is retiring, Judge Steyn is retiring in December. And then there's 2 other judges, and one of the other judges often also act in the Labour Appeal Court. Not that, the point being, I don't think that must be the only criteria.
Thank you. I have one last more question, Deputy Chief Justice.
Yes, go ahead, David.
I would like you, there is one position, Ms. Devet, in the Western Cape, and there are 4 candidates. All of them are known to me, and all of you were invited by me to act. I would like to give you an opportunity to market yourself. Why should we appoint you and not the other 3 candidates?
Thank you, JP. I thought about that question, and it's a difficult question. And my answer why I think I should be appointed is through my practice and also through my experience as a mediator, I think that I have something that the other candidates do not have. I have worked for 25 years as an advocate in the High Court in matters that's very highly conflictual, a lot of family law and labor matters, and through my mediation skills, I have been able to deal with that, be comfortable with that, assist people to approach litigation maybe in a less adversarial manner, which I believe is the move going forward. I've also, and I'm very proud of that, with the allocation of the Scalabrini Trust matter against the Minister of Home Affairs, you would have seen that that's one of the matters that is part heard. It is part heard because I am case managing that matter in terms of Rule 37 with your blessing. And it's worked, it's really a success story in the sense that the Minister of Home Affairs, in terms of a SEA order, had to reopen the Cape Town Refugee Centre already in 2018. The matter came before me for the appointment of the Special Master and to find the Department of Home Affairs or the Minister in contempt of court. After hearing argument, I did give an order saying that there's a breach of the SEA's order, but in line with the move towards case management and resolving matters in order to get a positive outcome, I suggested case management to the parties, and who immediately took me up on the offer, and we have since then, by way of monthly case management meetings, they would submit a report. We agreed on a very detailed order of how it will happen, because it doesn't help we meet every month and we don't know what to discuss. So we have monthly meetings, and the refugee center will probably be reopened in November this year. We've gone for inspections, and it's resulted, I believe, in a huge cost-saving exercise. It has resulted in all role players working together in order to reopen the refugee center, which will have the result of there being a more efficient system. People who qualify will get their status. People who do not qualify or meet the requirements, they will be deported without all the delays that we see now. So I think, to answer your question, my case management skills, my mediation skills, my years of experience at the bar in all kinds of matters, I think that in those circumstances, I am the best candidate for this position.
In other words, if this commission is with you, you would like us to recommend you for appointment, notwithstanding that you have acted for 6 terms and you only have 1 reported judgment, and other candidates have far more than that.
Yes.
Secondly, notwithstanding that you have not finalized a single criminal trial. And thirdly, notwithstanding the obvious delays which have been highlighted in terms of you handing down your judgments. Notwithstanding your experience as an advocate for 25 years, you still delay in handing down the judgments. And I can tell you from my experience as a judge president, candidates who delay in handing down judgments when they are still acting only become worse after the permanent appointment. So if it takes you 6 months to produce a judgment, the moment you are appointed, it will take you 6 years.
Yes.
So notwithstanding all of that, we must recommend you for appointment.
Yes, JP, I've explained the matters that was
Thank
highlighted.
you. No further questions.
Yes, carry on, Mr. Vet. Or have you finished, Mr. Vet?
Yes.
You finished? Okay, thank you. Mr. Boshoff, do you have questions for the candidate?
Thank you, Justice Meyer. Afternoon, Mr. Vet. Most of the questions that I wanted to ask have been covered, so I just have a technical question that I intend asking the candidates. Could you perhaps explain to us your understanding of the appealability of interim orders and what the test or what approach the court would take in determining whether or not to consider an appeal of an interim order, such as an interim interdict?
Yes, well, the normal approach is that interim orders would not be appealable because the matter had not been finally determined. Obviously, if there is some aspect in terms of the interim order that was granted that's got a final effect, that would in some circumstances be susceptible for an appeal.
All right, and then just to follow up on that, are you then familiar with the fairly recent judgment of UDM and another V. Lebashe Investment Group and others? It's a constitutional court judgment.
As I sit here, I can't
Yeah,
tell what
so
it's about.
in that judgment, the court found that the old so-called Zweni test of finality is not the be-all and end-all anymore, and that under the constitutional democracy that we now live, the question is more one of the interests of justice.
Mm-hmm.
And the reason I want to point that out is I want to ask, it's firstly a constitutional court judgment, and it's a constitutional court judgment that deals with a position that was previously assumed to be fairly trite, as you've pointed out. So as an aspirant judge, where do you stand on familiarizing yourself with latest developments in law and being certain that you are up to date with such developments? Because one can unfortunately not always rely on the parties before you to point these matters out.
Yes.
And take the court into its confidence, so to speak.
Well, as Matt, I think in today's, with the technology we have today, everyone has the ability now to have, to know what's happening with regards to new judgments much quicker as before. It's all out there, it gets published. We are on mailing lists or groups where all new judgments are circulated, so everyone would know if something interesting happened. You obviously can't know everything whilst it's basically impossible. We have the tools in order to, if you deal with the matter, to immediately know what has happened and what the latest authority. Things change. What was law today can change tomorrow. So I would say I do keep abreast of matters as they happen, but sometimes I would need to catch up a week or what later or a month later, or if I deal with a matter that pertains to a specific question, then that is the kind of research that you will do in order to know what's happening.
Thank you very much. I don't have any further questions.
Thank you, Mr. Boshoff. Commissioner Barumafai.
Thank you very much, Deputy Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Did I hear you correctly that one of the areas that you specialize in is children's rights generally, and you have dealt with the Hague kind of cases?
Yes.
I want to ask you a question in relation to the Hague Convention on the several aspects of international child abduction, and especially how it is applicable in this country, or how it should be applicable, or how you conceive it. Especially, I want to ask you about the adoption of children in the context where the parents are involved. And the matter, on the one hand, seems like child relocation, but on the other hand, it is clear that the child has been adopted by one of the parents. Under those circumstances, what role, if any, should the views of the children play, especially when one has regard to the Convention on the Rights of the Child and various sections of the Children's Act, especially Section 9 and Section 10. Because when I look at some of the judgments that are coming up in this country, they don't deal with the aspects of the views of the children. And that aspect becomes to be very big in the children's jurisprudence. Yes. I'm not sure, what is your view in relation to that?
Well, Commissioner, I believe that the view of the child is extremely important, and I think it's not heard enough, and I think it's often not heard in the correct manner. And obviously, it depends also greatly what the age of the child is, how mature the child is, the circumstances the child find him or her in. So, for example, in this, the Hague matter that I've attached the judgment, in that particular matter, the legal representative that was appointed to interview this little girl, I think she was 4 or 5 at the time, spent not even half an hour with her, and then what he recommended did not correspond with what he said she told him during their very brief interview. And that made me very concerned, because how do you hear the child's voice if you don't have someone that's trained and familiar to hear what a child is really saying? Because a child can tell you one thing, but actually mean something else. So for me, that's extremely important, and I think it would be I've heard in some other jurisdictions, there's a move towards social workers or people who's trained in dealing with children, assisting judges to hear their voice. So it's not a situation where a child has now got to come and tell the judge or what he or she wants, because that puts them right there in the middle. And I think if we can have systems in place to hear children's voices properly, because I think it's extremely important, we will go a long way in protecting children everywhere in the world.
You are raising an important fact.
What's that? Is it me? But it's always been on.
You are raising an important, I'm not really sure what's going on. Okay, you are raising an important issue, right? In relation to facilitating the voices of children to be heard. And most of the judgments in South Africa have actually tried to grapple with that. There is a case, Ford versus Ford, and it was written by the Deputy Chief Justice at the time when she was an acting judge in the Supreme Court of Appeal. And to some extent, it tries to deal with that. But what I want to understand from you is from a practical point of view, because judges always say, but we are not psychologists, right? Yes. And we can have all these professionals who are, how can that be? Should it be in camera, in the chambers, in open court? How can we facilitate, assuming that the child is at the stage where they can express their views, and that issue is not in contention? Yes. Practically, how can we facilitate a process that can enable the children to be able to air their views?
Well, firstly, Commissioner, in our division, the JP, for example, which I think is the first very important step, has issued new directives that's in operation from June this year, where he encourages judges who deals with children's matters to case manage those matters. In other words, so that matter does not go to a different judge every time when because they all normally have a history, so that they don't go to a different judge every time, so the same judge deals with the matter. The second important thing that happened is in terms of those very same directives, it is recommended that even with Hague matters, the Office of the Family Advocate, they've always been involved there, but in all matters, previously it was only if it's a divorce matter. Now, any matter pertaining to the best interest of a child must also be referred to the Office of the Family Advocate. And I found during my acting periods at the Western Cape High Court that the Office of the Family Advocate has been extremely helpful when I have a matter and the child is very young. I would call upon the Office of the Family Advocate, who would know the matters on the roll, and ask a social worker to assist me, to meet with the child and ascertain whether the child is in a position to give a view, or what recommendations he or she can give me in that regard, or whether every situation is different. But I think the presence of the family advocate with their family counselors and social workers, and maybe if private practitioners can assist and make themselves available to help the courts in that regard, it would go a very long way.
Thank you very much, Advocate. Thank you very much, DCJ.
Thank you.
Thank you, Commissioner. Any questions from the virtual platform?
None, thank you, Deputy Chief Justice.
I have a question, DCJ.
Yes, go ahead, Commissioner Bernard.
Thank you. Advocate, regarding your technical competence to act as a judge, what are your strengths and what are your weaknesses?
I believe that I possess humaneness. I really care about people and their well-being. I also believe that if you care about everyone in that sense, and you sit in a position as a judge or a commissioner, then, and someone has the chance to have their dispute heard, that I provide a forum where litigants and counsel feel that they, or experience that they are heard and understood. And I try then, when I give a judgment, to be true to the oath that I've given, that I will consider all the information in front of me carefully, and that I then deliberate and decide on that matter without fear, favor, or prejudice, obviously subject to the Constitution. I think that that is my strongest characteristic as a judge, and I would say that I have to, if we must talk about weaknesses, it's probably the same. I have to I believe that because I care, I always need to be mindful of that fact, especially if you look at issues pertaining to sentencing, and be mindful that you must never be too harsh or too lenient. You must find a middle way and a balance in order to deal with any matter before you. Doesn't matter in whether it's civil, children, or criminal matters.
Thank you. Thank you, DCJ.
Thank you, Commissioner Bernard. JP Mlambo.
Thank you very much, DCJ. Good afternoon, Ms. DeVette. I'm sitting here.
Straight ahead.
Hello. Good afternoon, Commissioner.
I just want to raise one thing that has been raised by the GCB. It's in paragraph 10.2 of the GCB report.
Yes.
That relates to the case of AVW versus SVW and 4 others. You know that matter?
Yes.
They say you had the matter in reserve judgment in October and then gave an order in January. And then the reasons for that order were given in April.
Yes.
Are these facts correct?
That is the matter I referred to earlier on. in this matter came before me I think it was on the 21st of October on the urgent roll. And the matter concerned whether a party should be granted leave to defend or not in a divorce action after signing a settlement agreement. And I then, as I said earlier on, I probably should have postponed the matter to the semi-urgent roll, but I thought I had the capacity and to deal with the matter. And after I heard argument, I realized that it's quite a contentious issue, and various points were raised pertaining to the best interest of the child if I grant a final order of divorce, whether they will survive financially if I grant an order of divorce. So I called upon the parties to file comprehensive heads of argument on that issue, whether they should be given leave to defend.
Could I just please
yes.
stop you there? Because I just wanted you to confirm if the factual matrix I gave you was correct. You confirm it was correct?
It is correct.
That you had the matter in October, you gave an order in January, and you gave reasons in April.
Yes, but I want to just add that they filed heads after I heard the matter in October, and then I decided the matter on the papers. So all the papers were only before me in November, and yes, I only gave the order in January. Then they called on me to give reasons, and I gave them in April.
I see. Yeah. Thanks for the explanation, because I think one factor you've confirmed that you were in the urgent court, because judicial policy frowns upon the handing down of an order without reasons, especially if a matter has been fully argued.
Yes.
Do you agree with that?
Yes, I do.
And, well, that policy is relaxed somewhat if you are sitting in the urgent court, but even then, what I know is, if the matter is very urgent, you would hand down the order, but don't wait for the parties to ask for the reasons. You tell them
Yes.
that I'll give you the order this week, I'll give you reasons in 5 days' time.
Yes.
Do you agree that that's how it's done?
I agree completely, and that's why I started off to say that I probably should have postponed the matter to the semi-urgent role rather than to deal with the matter on the urgent role. I guess so you live and learn, because it was most definitely not that urgent that I had to deal with it immediately.
Okay. But I think the last question is, when you gave reasons, this is what, after they asked for the reasons.
It was at all times my intention to give reasons. I also advised the parties
Yes.
that I will be giving reasons, and I was then advised that they were considering taking my order on appeal, and can I please give the reasons, and I then delivered the reasons. So I obviously would have given reasons.
Yeah. Thank you very much, Ms. DeWitt. Thanks,
Thank you.
DCJ.
Thank you, Judge President Mlambo. Commissioner Pillay?
Thank you, DCJ. Good afternoon, Mr. Bed.
Good afternoon.
In response to a question by J.P. Slope around what makes your application stand out as compared to the other candidates,
Yes.
Did I hear you correctly that you indicated the nature of your practice at the bar is such that it renders your application to be more attractive than the other applicants?
What I'm trying to say is that I have practiced at the bar and appeared in the High Court for very many years in very many different kinds of matters. I did a lot of criminal trials and matters when I started practicing, but I have experience going to court, appearing in front of judges, dealing with complicated matters for many years. And what I was trying to say is that on top of that, I believe I have the necessary skills through the mediation courses I've done and that I'm an accredited facilitator, to also help with the case management aspect of being a judge, which I think can assist with the flow of cases, with the speedy resolution of matters, and I think that helps. That is the benefit I see in my experience.
Now, in dealing with these complicated matters over many, many years, as you've just indicated, can you tell me how many juniors have you led at the bar?
Well, I'm obviously not a silk, but I have led, at least that I can immediately think of, 4 juniors and females of color that I have been on mostly on a fee sharing basis for state attorney work.
Can I just understand what that means? You've led 4 juniors?
Yes.
Throughout your practice?
Yes, and mostly in labor court matters.
And
yes.
In the complex matters that you've dealt with, were these juniors also involved on a fee sharing basis?
In the more complicated matters, I was normally, I would say more generally, I was the junior in those matters, even though I have been practicing for a long time, but I guess in that capacity, I was mostly the junior. So in the situation where I get the opportunity to do state attorney work, then I am in a position to pull in a junior on a fee sharing basis. So I give a portion of my fee and I reduce my fee accordingly. So that's what I could do in that regard.
All right, I just want to be sure that I understand what you're saying. So you're saying in complicated matters you were being led, and then in the smaller matters you were able to bring on juniors but purely on a fee sharing arrangement?
Yes.
Right, and of the juniors that you brought on 2 black women.
No, I've worked with 4 black women in fee sharing arrangements over the time that I've done, as I said, mostly labor work in that context.
Let's use Ms. Davis as an example, because
Yes.
she put up a letter of support.
Yes.
I noted that she did pupillage in 2012,
Yes.
Which means she started practicing in 2013.
Yes.
When was the last time you led her?
Sure, I can't remember that. It must be probably 2015 or 2016. I don't think subsequent to that.
All right. And the other 3 black women that you've led?
I worked with someone, but I can't, I don't want to...
You don't have to mention
the
her
name.
name.
I can't remember her name now, but I think that was recently in 2019.
Right.
In a labor matter for the Department of Social Development, I think. I worked on a fee sharing agreement.
And you don't remember her name?
I can't remember her name now.
All right.
At the moment, I'm sorry.
All right. Thank you, DCG.
Thank you, Commissioner Pillay. Commissioner Club.
Thank you very much. Good morning, good day, Advocate.
Good afternoon, Commissioner.
Thank you very much. After 21 years of practice as an advocate, you applied to the Cape Bar.
Yes.
To be recommended for silk. The recommendation was refused. Is there a duty on the part of the bar to give reasons for their decision?
Not as far as I know, Commissioner, but it would definitely assist, I think, all people applying for silk to know what the Bar Council at least saw as your shortcomings, that you don't have enough experience in this field, or you, whatever the reason may be, because that will give you the ability to consider and put in a better application should you want to apply for silk again. So in that context, I think it would be good if reasons, even if it's just on an informal basis, be provided to applicants.
They are not duty bound.
I don't know, I've not been on the Bar Council, but I don't think they ever give reasons.
My second question to you, in your application or your questionnaire, you claim to have contributed to gender transformation. Is that correct?
Yes, I've tried to assist.
Yes. It's not clear to me how you went about it. Would you want to comment on that?
Well, I guess, as I've pointed out before, I have had pupils that I've mentored and I've assisted in practice. I have, over the years, also mentored informally many young female and females of color who started at the bar, and I've always been assisting them. I've assisted with FAMAC, with the transfer of skills. By doing training, I have assisted in the training of pupils. Recently, on an occasion, I was requested to do that. As I sit here, obviously, I can't practice. I am making my chambers available to also a very junior counsel, female counsel of color, who just got appointed, and I've given her and another young female advocate my chambers with the leave of the Bar Council, to help them to establish themselves as advocates.
No, thank you very much, Advocate.
Thank you, Commissioner.
Thank you, Commissioner Klob. We have finished. Thank you so much for coming.
Thank
Your
you very
excuse.
much for the opportunity.
Afternoon, Ms. Nziweni.
Good afternoon, DCJ.
How are you?
I'm fine, thank you.
All right. You are a regional court magistrate.
That's correct, that's correct.
Since 2013?
Yes, yes, DCJ.
And I see that before that you were in the district court.
Yes, at Somerset West Court.
For 10 years.
Yes, that's correct.
Sure, you have a lot of judicial experience. And before that, you were with the NPA.
Yes.
You became a public prosecutor in 1999, then became a state advocate in 2001. So how long did you spend in prosecution?
4 years.
4 years.
Yes.
All right. And you had taught for a brief spell at your alma mater for TER before that?
Yes.
What did you teach?
Commercial law, tutor commercial law.
You would have just finished your LLB, which you obtained after the BPROC, when you took up that position, not because I see it's the same year.
Yes, that's correct.
Why did you not stay?
Sorry?
Why did you not stay? You were there for only 6 months. Did you not like teaching?
No, what happened, I went for internships. I did an internship with Nedbank here in Johannesburg. Another one I did with a law firm in Cape Town. Yes.
All right. I see you were also a maintenance clerk at the Department of Justice at some stage.
Yes, and that was a brilliant learning curve, and it also exposed me to the justice system. Yes.
Yeah. All right. You have had a few, well, not a few, a number of acting stints in the Cape, well, they used to call it the Cape High Court back in my time. Western Cape Division of the High Court, starting last year.
Yes, 2021, January.
Are you still there now?
Yes, I'm still there. I've got now 7 terms under my wing.
So you've been there throughout?
Continuously, yes.
Okay. How have you found the experience?
A remarkable experience. I learned a lot. Immediately, I got to learn that you have to be effective. You have to manage time very well. And I was fortunate because I was well received. I learned a lot.
And well, it's been almost 2 years, so that's a long time.
Yes.
I imagine that you would have been exposed to the wider spread of the work that is done in that court.
I've grown immensely, and immediately when I started there, I think within a matter of months, I had a reported case which contributed in bail jurisprudence.
Some people have all the luck. There are colleagues who produce routine judgments for years and they just don't get reported, and others start writing and immediately they are reported. How did you achieve that?
I've got an infinite capacity for research. I take my work very seriously. I put on extra work, and I've got a methodology where I'm faced with a matter, I look at the facts, I apply the law, so I think it helps a lot.
And so how many judgments have you been able to produce in that court?
In excess of 30.
I mean, written, that is.
Yeah, in excess of 30, and I've got total 7 reported cases.
Wow, all right. I see that you did a lot of civil work in your 10 years in the district court.
Yes, yes.
What kind of work was that?
All sorts of work. I did delict trials, I did motion courts, I did contracts, The advantage which I had, I was at a station which is very busy. I think I mentioned this also in my last interview, and where people do litigate. So I was fortunate, and the motion court is very busy there, opposed and unopposed. And when I was in the regional court, I have a case which went up to the Supreme Court of Appeal, and it was confirmed.
Okay. You have no reserve judgments, I see.
No, I don't.
But you do have a longish list of partly heard matters.
Unfortunately so, yes. One is in the High Court, and then 3, if I'm correct, in the regional court.
And what is the status of those in the regional court? When do you intend finalizing them if you're still at the High Court?
If I may look at them.
It's page 24 of your bundle.
Yes. Thank you, DSAJ. The one in the High Court, it's continuing. I'm going to continue with it tomorrow still. And as versus Peter, the state case is closed. One accused was discharged in terms of Section 174 of the Criminal Procedure Act. As versus Paleka was still busy with the state's case. Unfortunately, the accused is experiencing some problems with her attorney currently. And then the matter of Ndini, it has been postponed for judgment. So it's almost done. As versus Harting, we're still busy with the state's case.
Okay. I see that you did some civil work in the regional court as well, and I was surprised. I didn't know that regional court magistrates deal with tax matters, for example.
Yes, we do tax matters, but in the criminal branch.
Yes. Well, you list a number of interesting cases in the specialized commercial crimes court, in which you also preside.
Yes. I was fortunate that the regional court president seconded me to do that specialized court, simultaneously, of course, with my normal criminal court. And yeah, it is a very interesting.
Yeah, cases involving cybercrime.
Yes.
Public sector fraud, tender fraud, which is a menace in this country, as we know. Corruption matters, bank fraud, and money laundering. How long did you do that kind of work? Have you been doing that kind of work?
If my memory serves me well, I think the regional court president, approached me. It should be 2 years. It can't be 2 years. It should be 4 years ago now. It should be 4 years ago.
All right. You are a member of AMSA, which nominated you.
Yes.
And they have mentioned all sorts of good things you do for the association and your community. Can you just tell us a little bit about various projects they say you are involved in?
Normally, we do reach out projects. We look at the previously disadvantaged. And then we go to children and elderly, and then we try and lift their spirits up. And I'm one who believes that transformation does not start in adulthood. I also believe transformation starts with the children. If you open the doors for the children, you may achieve something. So we focus mainly on children, and then we do projects. For example, we help them with sports. We'll help them with various aspects of life.
Well, they mentioned that you educate communities such as Kaelicha about their legal rights on various issues, including obtaining protection orders in cases of domestic violence and
Yes.
drawing up wills and such cases.
Yes, we mainly focus also on wills because our communities tend to neglect that aspect, that it's very important that you should make a will so that if you die, things can be taken care of.
And you train magistrates under the auspices of the SAJE.
Yes, yes. I am involved in transfer skills as I'm very passionate about education. And this started whilst I was still a prosecutor, where I mentored aspirant prosecutors, and I never stopped when I was a magistrate. I continued on that trajectory.
Well, the BLA and Nadel, I think you could do with more acting stints before you, well, Nadel says, whilst they have no doubt that you'd make a formidable judge, they think you should still act for a little bit longer. And then the BLA says the same thing, but then say they support your nomination and appointment, which is a bit confusing. Do you think you are ready for permanent appointment?
I am absolutely ready, DCJ, and I think my work also speaks for itself. The mere fact that I have 7 reported judgments and the feedback which I also received from senior judges who have told me that I am ready for the task.
Thank you very much, Ms. Nsiweni. Judge President Lope, do you have questions for your candidate?
Thank you very much. Excuse me. Thank you very much, Deputy Chief Justice. Ms. Nziweni, I can confirm that you have acted for 7 terms in the division and you're invited by me. Tell us a little bit more about the last time you appeared before the JSC was in October last year. Tell us a little bit more about what has happened to your life in terms of exposure to different kinds of work in the division.
I think the only thing which I have not done in terms of procedure in the High Court is pre-trials. I have the opportunity of being involved in full bench appeals with panel of 3 judges. At one instance, I was roped in to come and break a deadlock in a matter which was of national interest, the Mafe matter. And I think I was instrumental to the decision which was recently confirmed by the Supreme Court of Appeal. I've done several matters. I've been exposed to different matters. I've done, for instance, business rescue, liquidations. I've got more exposure now, JP, since then.
Tell us a little bit more about the Mafe matter. Which one is the Mafe matter?
Mafe matter is a matter which involved the banning of parliament. What happened there, 2 judges were allocated to do the matter. And then they had a deadlock. And then I was brought in to resolve that deadlock.
Let's move on to transfer of skills. Have you assisted African women in particular who are aspiring to become judges or aspiring to become magistrates? Is there anything that you remember that you have done to transfer skills to African women in particular?
One thing about me, JP, when I reach where I'm going, I always turn back and give a hand to the next one. I've got an open door policy. There are sisters who are coming along in the High Court currently. I'm going to start there where I am currently. I've given them help. I've always asked them, do you need help? And then I do give help. As I said also to DCJ, that I started with this trend whilst I was still a prosecutor, mentored aspirant prosecutors. Again, when I was invited by the regional court president to help in the training of regional court magistrates, I did that.
Right. Two more last questions. There are other candidates, Ms. Nzweni, who have applied for one position in the Western Cape. I'm going to give you an opportunity now to market yourself. Why should we recommend you for appointment, but not the other three candidates?
Fortunately, I know the candidates, and I know that they are good candidates. What I would say, JP, is, as I've already indicated, that I've got considerable experience, which spans for 23 years in different fields of the justice system, and not only the criminal justice system, but the justice system. And this exposure has given me diverse and requisite skills that makes me suitable for the vacancy. As a prosecutor, as I intimated earlier on, within 4 years as a prosecutor, I managed to progress from a district court prosecutor to a regional court prosecutor up to the High Court as a state advocate. When I was a state advocate, I received merit award. I came to preside in the lower courts. There, I think also I acquitted myself very well. When I was leaving Somerset West, going to the regional court, my chambers or office was full of attorneys across racial lines, saying what a loss to us. You've taught us a great deal. I moved to the regional court. There again, I acquitted myself very well. I'm currently in the High Court. Again, I'm receiving positive feedback.
Right, thank you very much, Ms. Nzweni. I'm glad Ms. Ngwaitobi is here now. I'm going to turn the heat. Let's talk about the land. Section 25, your views on Section 25 of the Constitution. There are differing views. There are certain politicians or political parties that believe that Section 25 should be amended. There are those who believe that, no, there is no need to amend Section 25. Let me hear your views in that regard.
This is a very topical topic currently in our country, and it's a very contentious topic. Yes.
Sorry, I forgot to turn on my mic. No, I was just saying, I'm wondering what will happen when a case involving this very question comes before your court, if it ever does. Does that, I mean, you're answering this question now, does it not mean that you would have to recuse yourself from sitting in that case?
If I give a view,
If you state a view today on
Yes.
what you think on this question, which may well turn out to be a legal question raised in a court of law in due course.
Absolutely.
Well, I'm just throwing it out there for you to consider before you answer, if you do.
Thank you.
What is the position now? I would like to hear the view of the judge in a pending case.
I haven't answered, Deputy Chief Justice. I was not going to allocate any matter to do with land to her, irrespective of her answer. All right, but I take the point raised by the Deputy Chief Justice, and I will withdraw that question.
Thank you.
Finally, from me, what would you say to those who say to you, your experience in other fields of law is limited, and by your own admission, the bulk of your work has been in the field of criminal law, and you need more time to act? What would you say to those? That's my last question.
I would say that it's an unfortunate position. Then I don't know what I need to do to equip myself further. I think I've been exposed to most matters, most variety of matters. I've done commercial matters in the High Court. I've done commercial matters in the regional court. I've done commercial matters also in the district court. What more can I do? What should I do more to prove myself?
Thank you, Deputy Chief Justice. I have no further questions for this candidate. Thank you
Thank
very
you,
much.
Judge President. Is it a follow-up, Commissioner? Oh, all right, I will note you. Mr. Boshoff, do you have questions for the candidate?
Yes, thank you, DCJ. Afternoon, Ms. Nzweni.
Good afternoon, Commissioner.
DCJ, I would just like to ask the Commission's kind indulgence that I ask 3 questions. I think it at least keeps my average to 2, as I'd only asked 1 in the previous interview.
Oh, is that how we're playing it? No, it's fine. Ask your 3 questions.
All right, and with regards to the first question, please just bear with me, and DCJ, if you think that it's unfair, please protect the candidate accordingly. But the JP asked you a question about your efforts and assistance of African women who may be aspiring magistrates or judges. Now, in preparing for today, and reading the other candidates' submissions, etc., I came across a letter of support in respect of another candidate, but in that letter of support, the following is stated. All right. I am currently an acting magistrate, Ms. Nzweni an acting judge. I have no doubt that her colleagues in the magistracy will give positive inputs as they worked with her for a long time. Ours is a continuous relationship. Briefly, I am required to send certain matters for automatic review. As a norm, a judge will send magistrate queries, inputs and comments or points of clarity on an issue in that case. The case I sent on automatic review was allocated to Justice Nzweni, and she sent me queries. My concern on queries was language used and or selection of words used. I was shocked. The language used was strong. As a result, I felt that there was an element of undermining, pettiness, and accusatory. I responded to the queries, however, pointed out my concerns about language used. I hope going forward that language used in her queries will be considerate and empathetic. Now, the person that raised this comment is, to my knowledge, a young African woman who's acting as a magistrate, and she's also a member of the bar. So I just want to find out how you reconcile, without making any assertions. I'm just asking the question.
It's so unfortunate that I'm working from the dark. I do not have insight to that comment.
Yes.
Be that as it may, I feel bad that something which I wrote induced such strong language or sentiments from the magistrate. I will never do that. I am a very humble person. I'm not sure what language. It's such a pity that I don't have that comment in front of me. I will never do such a thing deliberately. And as I say, it's unfortunate that she feels that way. Can you perhaps jog my memory and say which matter was that?
It's not mentioned, and again, I do apologize for, I don't want to ambush you or anything. It's just I came across it in preparation for this meeting. But no reference is made to the matter in specific. It's just stated in those terms.
The only thing which I can say, I'm really sorry that she felt that way. I will never do something like that to a person, demeaning another woman. I will never do that. Particularly someone who's acting, someone who's trying to find her feet. I will never push that person down.
Mr. Boshoff, I've been scratching my head. I don't recall coming across such a comment. Is it part of the bundle that was made available by the JSC? Because do you have it?
It's part of the bundle that I received
I'm sorry, I missed it.
in respect of one of the other candidates that we are interviewing. ECJ.
Oh, I see. All right, all right.
Yes, yes.
Okay.
That's why I said I apologize. I don't know whether it's fair to ask this question without the candidate having had sight of this, but
No,
yeah.
it's fine to well, she's answered anyway.
Yes.
Yeah.
All right, Ms. Nzweni, thank you. And then the next question is last year. Well, let me preface the question as follows. You stated in your response to the JP that you have, and I hope I'm quoting you correctly, an infinite capacity for research.
Yes, yes.
No, yes. Now, so in last year's interview, you were asked by one of the commissioners to explain how you understand, what you understand under the difference between a so-called PAJA review and a review in terms of the principle of legality. And with the utmost respect, I would submit that the answer was not necessarily as illuminating as it could have been. So I just wanted to know whether or not you've revisited that issue or question to try and and research it further, and how would you respond this time around?
Thank you, Commissioner, for affording me that opportunity. I fully agree with you. Last year, I flunked that question. Having done that, I went back and looked at it. And if I may show how I understand it currently.
Yes, please.
PAJA gives effect to the provisions of Section 33 of the Constitution. And then PAJA deals with administrative actions. In terms of the Constitution, every administrative action should be lawful, reasonable, and procedurally fair. PAJA then, it's a statute. It's a statute. And then we go to the doctrine of legality. The doctrine of legality, it's a common law concept. Essentially what it says, every decision has to be lawful. And then it's also an aspect of the doctrine of the rule of law. And then we know that an application in terms of PAJA can be brought if an administrative action is challenged. However, the legality concept is overarching. It's overarching. An executive decision can be reviewed in terms of the doctrine of legality. I'm not sure whether you're of the view that I did acquit myself.
No, I think you get an A this time. Thank you very much. Then just my final question, and it's a question that I'm asking all the candidates, and it relates, so it relates to the issue of the appealability of interim orders or interim interdicts. How do you understand the approach that a court should take in respect of when confronted with the question of appealing an interim order of another court, or a leave to appeal application of its own interim order, which is probably more relevant to this interview?
I hope I understand the question correctly, Commissioner. The way I understand it, I will answer it as follows. Generally, interlocutory orders are not appealable. However, if they have final effect and they dispose of some of the issues in the main application, then they are appealable. I'm not sure whether I understood your question correctly.
Yes. Yes, if you'll just bear with me, the reason I ask is because about a month ago, the Constitutional Court handed down judgment in a matter of UDM v. Lebashe Investment Group. And I don't know if you're familiar with that judgment.
Not really familiar, but I came across it when it was publicized.
All right. Okay, because that judgment has essentially moved away from the so-called traditional test of appealability of interim interdicts and has now applied a different test. Are you familiar with that? The approach that the Constitutional Court took?
I think so. I think what was significant in that matter, it was said that if it's in the interest of justice, then it should be appealable, notwithstanding that it's an interlocutory order.
Thank you very much. I have no further questions. Thank you for your time.
Thank you, Commissioner.
Thank you, DCJ.
Thank you, Mr. Boshoff. JP Mlambo.
Thank you, DCJ. Good afternoon, Ms. Nziwendi.
Good afternoon, JP.
Just one or two questions about the regional court. You've not been in your court since the beginning of last year, am I correct?
That's correct, JP.
A question I always ask candidates who come from the regional court is the part head situation in that court. I can tell you that in Gauteng, if a regional magistrate has more than 10 part head trials, they are not invited to come and act. As you sit here, or when you started acting last year, did you have any part heads?
I certainly do, JP, and it pains me because justice delayed is justice denied. And partly, I am the cause of the delay.
No, carry on, Ms. Nziwendi.
All right.
Ignore the...
Sorry. But in my instance, in those cases, what mitigates the prejudice to the accused persons is the fact that...
Could I ask you to speak close to the mic?
Sorry,
Thank you.
Is the fact that most of them, all of them, they are out on bail. And what I did is to also give time to them during recess. When there is recess in the High Court, I go back and do those cases. And I don't only set them down for one session, I set them down for various sessions.
Let's see. How many do you still have that apartheid?
Regional Court, 3.
3.
3.
Yeah, that means you've used your recesses very productively.
Thank you, Jay.
But probably you'll have a discussion with the JP about how to resolve this because it's a national problem. When I look at as of August, there are a number of matters in the Western Cape Regional Court where the part heads are running into 7 years.
Yeah, that's really unfortunate.
Well, Gauteng is worse because some of them go to 10 years. That's why I'm saying it's a national problem. Probably you will help us. You'll help the DJP, the JP, about how to address this. The system in the regional court, because it can be that the High Court runs a running roll system. And we do not accumulate this. Granted, our workload is not comparable to that of the regional court. But I want to believe that if we have a different system in terms of which these trials are run, we will not have this situation. Do you agree with me?
Fully. I also thought of a system perhaps where a judge president intends to invite a candidate. Perhaps the judge president will say, okay, I intend to invite you at such and such a time, and then please clear your partly held matters. Something which I can think of now as I'm sitting here.
Well, I'll tell you that the strange thing is those who really want to come and act, they actually finalize those matters, and they have less than 10, and they come.
So it's an incentive.
I don't know. Thank you very much, Ms. Nziwendi. Thanks, DCJ.
Thank you.
Commissioner Marumafai.
Thank you very much, DCJ. Good here. Good afternoon.
Good afternoon, Commissioner.
I came across a very interesting case that I believe you penned, but you'll correct me if I'm wrong. I'm not sure how to spell this, how to pronounce this. Zwigas versus Dutwait, it was a business rescue matter. It was delivered on the 4th. I beg your pardon?
Yes, yes.
You remember it?
Yes.
This is an application where employees brought an application to be allowed to sue business rescue for salaries.
Yes.
And I see that you dismissed that particular application.
Yeah.
I'm not really concerned about the reasons thereof, but I just want to pick your brain generally on these kinds of matters, because there is currently, I call it a war between the Labor Court and the High Court, where the jurisdiction of business rescue proceedings in relation to employees who wants to sue business rescue practitioners during the 3 months period of business rescue is concerned, right? I just want to understand which court between the two is better suited to deal with the core labor issues, you know, your salaries, your retrenchments, and all those things that arise within the period of business rescue. Is the High Court the appropriate, because there is a provision, I think it's section 210 in the Labor Relations Act, that says the Labor Court is the final arbiter in all the labor matters. So I just want to understand which court should be the court that deals with labor issues that arise within the business rescue proceedings.
It's a tricky one, Commissioner. Thank you for the question. It also pricks my brain. It's a tricky one, but the procedure pertaining to business rescue, it's categorically stated in the Companies Act. And the Companies Act also deals with a situation which involves workers. So the workers are also catered for, and the legislation stipulates what should happen when a company is placed under business rescue. So I wouldn't say it's a matter of choosing between the courts.
Yes, I mean, when you look at section 136, which you referred to, and section 158 of the Companies Act, without a doubt, because the question is, there is a moratorium placed, right? And that moratorium gives the business rescue practitioners a breathing space.
Yes.
Right? That means no one should be able to bring any legal proceedings against them. But there are constitutional implications in relation to retrenchments on the one hand, and the right to fair labor practices, and of course, on the other hand, the issue of salaries, because a salary is an immediate thing. If you don't get your salary, you are going to go hungry, right? Those are the considerations. And and you'll correct me if I'm wrong, my understanding of the Companies Act is that it does not necessarily state where, because the thing is, it prevents legal proceedings. So in other words, but you'll correct me if I'm wrong, my understanding is it does not tell employees that you can go to that court as opposed to that court. But we see current cases that are emerging from the labor court where this particular jurisdictional question actually arises. And I'm just trying to pick your brain in relation to, perhaps maybe from an academic point of view, right? As to how do we resolve this? Should it be? Yes.
Well, I really didn't think about it that deep when I was dealing with it. It's actually a very interesting point. Basically, if a business rescue practitioner acts unlawfully, the employee still has other avenues to follow. It's not the end of the road. I'm not sure whether I answer you or not.
One of those questions, but I can leave it there for the sake of time.
Thank you.
Thank you very much, DCJ.
Thank you, Deputy Chief Justice. Good afternoon, Acting Judge.
Good afternoon, Commissioner.
Just two questions from me. I think the first one is the point that you raised earlier on, that in response to what the JP was asking about the MAFA matter.
Yes, MAFA.
Yes, where there was a dispute, where there was a deadlock You indicated that you roped in and the matter was resolved, but you didn't elaborate how did your, you being part of the team resolve the matter. Is that clear?
I'm not sure whether I follow you, Commissioner.
Yeah, the JP posed a question about the MAFA matter and the deadlock.
Yes.
And your response was, you were brought in and then the deadlock was resolved, but you did not elaborate.
Oh, I did not elaborate.
Yeah, if you can just elaborate on that. Then the second one relates to what happens when judges are found to have handed down judgments that are influenced by the executive or the legislature, and what is your understanding of the core principles of the independence of the judiciary? Is it meant to protect judges themselves, or is it meant to protect the judiciary? Thank you.
Thank you. I'll start with the last one, Commissioner. Thank you for the questions. When a judge is influenced by the executive, I think it's phrased in a hypothetical fashion. Basically, our law has created a system which tries to avoid interference from one arm of the government to the other. What we commonly term as separation of powers. Obviously, if it's found that a judge has been influenced, there are processes which need to be followed. For instance, that aspect may be taken to the JSC. It's totally unacceptable if that happens, if there is that break in the separation of powers. It's not supposed to happen. It's something which is unconstitutional if it happens. Independence of the judiciary. Well, Section 165 of the Constitution speaks to independence of the judiciary. And it says that the courts are only subject to the law and the Constitution. Therefore, they cannot be influenced by an organ of state or another person. I'm not sure whether I answered that one.
Yes.
And then moving to the MAFE matter, what happened in that matter, two judges sat and heard the bail appeal on urgent basis. And then they reached the deadlock. After having reached the deadlock, then the JP needed someone to come in order to break the deadlock. Then that was my role. I was called in to break the deadlock. How do I break that deadlock? We sat again as a full bench of 3 judges. And then we heard, once again, the bail appeal. And then we went to deliberate, and then I broke the deadlock because my input made a majority decision. I'm not sure whether I'm answering you, Commissioner.
Thank you. No, you did, Acting Judge.
Thank you.
Thank you, DCJ.
Thank you very much, DCJ. Good afternoon, Ms. Nziweni.
Good afternoon, Commissioner.
No, I only have one question for you. What is the difference between in consultation and after consultation in the legislative drafting?
In consultation and after consultation.
Yes, ma'am.
I'm going to venture an answer here. And in doing so, I'm led by the wording, looking at the wording. I would say in consultation by the legislature, obviously we have a system which encourages public to participate, for instance, in the passing of legislation. So in consultation, I assume is to say you consulted within, that's all. And then after consultation, it's to consult afterwards. I said it's a venture.
Could I just follow up on this point, Madam DCJ? Yes, thank you. I just wanted to ask you a broad question. The short answer to the in versus after is that in consultation means that the person who is entrusted with the power to make the decision may not make the decision without consulting with the identified party, and after consultation means that they may make it provided that they consult. But I think that the real issue is that this question coincides with my larger concern about your application. I've read the 7 judgments you highlighted. It's admittedly only 3 that I've read with some detail because I wanted to just get a sense of your skill set. They are competently written. There's one that you've done on universal partnership, which is a competently written judgment.
Thank you.
But what's manifest is that you lack skills on pure constitutional law and public law in general. So I just wonder how that can be sorted out, because this was the same problem you confronted in the last interview, where you couldn't describe the distinction between constitutional supremacy and constitutional democracy. I think you tripped yourself up on those concepts, just like the in versus after consultation concept that you've tripped yourself up. So I wonder whether there's anything you're planning to do, if you are recommended, to show up because clearly you've got the ability, judging from what you've produced, but it may be that the answer maybe is that you add some more, or maybe the answer is that you just read yourself up into the area. But there's clearly a need for you to balance the public law knowledge.
Thank you, Commissioner. I take the point. To work on the bench, you always learn. It's always a learning day, learning curve rather. Lack in public administration, I take the point. I won't argue with it, Commissioner, but yeah, I take your comments to heart. Thank you.
No, I think the question is, what are you planning to do about it? I think it's manifest that there is a problem there, but it may be that that's something you have a clear idea what to do with it, so that we are confident when we recommend you that it's something you know is a problem and you've got a plan to deal with it.
As I said, I've got infinite capacity for research. If a matter is placed before me, I'll make it my point that I do a thorough research.
Can I follow up? No, I share this concern, and I was a bit disconcerted by one of your answers earlier. When one of the law bodies had said, maybe you need a bit more acting experience, etc. And you said, well, what more am I supposed to do? And I think it links to the previous question. Isn't there more you can do other than wait for public and constitutional law judgments, matters to arrive on your table before researching them? Given that being a judge of the Cape High Court involves administrative and constitutional matters on a weekly basis, I would imagine.
Thank you, Commissioner. I don't mean to say that I will sit around and not do something to empower myself. I always have the appetite to empower myself. I'm sorry if I created an impression that I would simply sit around and wait for the work. That's not how I do things. As I've indicated previously with the other commissioner, immediately when I tripped on that question on the previous occasion with the interviews, I went to look into that. So I do empower myself. I'm here today because I've empowered myself. I don't have a reputation of being lazy. I'm not saying the commissioner is saying that I'm a lazy person, but I'm not a lazy person.
But what specifically would you do?
Read more, read more. Obviously, it appears I did not read more, but I'll read more. I'll make it a point that I'm going to read more where I lack in.
But then perhaps maybe it's better that you read first and carry on acting before it's a permanent appointment.
Okay, I take the point, Commissioner. Thank you very much.
Thank you, DCJ. It's just a follow-up on these two questions. We are aware that there is a continuous judicial training. Will you be attending those?
Certainly.
And secondly, like as judges often get involved in some of these training programs that are organized by your bodies, would you be assisting, are prepared to assist on that?
100%, Commissioner.
And they are aware of this SAJ, and you would be availing yourself as one of the judges. Thank you very much. In fact, lastly, do you agree with me that judges that or past candidates that are appointed, they've not in their practice done every aspect of the law?
I agree 100%, Commissioner.
Thank you very much.
Thank you.
Virtual platform commissioners, do you have questions?
I have no questions.
Okay.
I have a question, DC.
Do you have a question, Commissioner Bernard? Oh.
Yes, I have a question.
Oh.
Ms. Nzweni, Acting Judge Nzweni, as far as potential is concerned, one of the criteria is appropriate potential. We've heard of some of your shortcomings, we've heard of some of your strengths. Could you address the Commission on what potential you have and that should be considered as far as this application is concerned?
Potential. Of course, I'm not trying to be immodest here. I think I've acquitted myself, and I'm not being arrogant, Commissioner, and I'm sorry if you understand me to be saying that. I think I've acquainted myself very well. I've got potential to grow. I've got a potential for growth. And I think most of the bodies say I am ready to serve on the bench.
Thank you. No, it's not that there's any doubt about that. In fact, the practitioners in the areas where you've acted as magistrates speak very highly of you and your work ethic and your temperament. The question is this, it's just an opportunity to persuade, because obviously there's been some points raised. So the question is, as far as the potential, the actual ability to grow, just convincing the Commission of that. And if you want to say something about that, then that's fine. So it's not meant to, in any event, any way undermine you. It's just a question to give you that opportunity.
No, I didn't understand it that way, Commissioner. I take the point. We always grow. We always grow, particularly in the field of the law. When I got to the High Court, some of the things I last heard whilst I was a student, we always grow on the bench.
Thank you, DCJ. Thank you.
Thank you.
Thank you, Commissioner Bernard. We have no further questions for you, Ms. Nzweni. Your interview has come to an end. Thank you, thank you.
Thank you, DCJ,
You're
and
excused.
thank you to the commissioners.
Are you ready?
Yes, good afternoon, Deputy Chief Justice and Commissioners.
Good
Thank you.
afternoon to you too. I would like you to tell us briefly, in your own words, what qualifies you for this job.
I have firstly more than 27 years experience in the legal profession. The last 20 and a half years has been spent as magistrate and regional court magistrate in the Western Cape. And I have a very strong background in civil, particularly civil work and civil procedure. But I'm also well-rounded in that I've appeared as an attorney in criminal matters, and insofar as my judicial experience is concerned, I've presided in criminal matters. And I bring to the bench, if I am fortunate enough to be recommended, good work ethic. I am independent, I'm impartial, I strive to be extremely fair to all litigants, and I've played a huge role in judicial education in the Western Cape, particularly in the Western Cape Regional Division. And that experience has assisted me in contributing to transformation in the lower court judiciary. So I do bring a lot of experience, and I have the necessary integrity for a position to be elevated to the Western Cape High Court bench. And I also have to point out that one of the important aspects for me in the course of my career as a judicial officer especially has been access to justice. And in my role, particularly in the Western Cape Regional Division, together with two colleagues at the time, being called upon by the Regional Court President in 2010, when civil and divorce jurisdiction was conferred on the regional courts in the country really. I, along with two colleagues, spearheaded and assisted the Regional Court President in bringing the regional courts to the various areas in the Western Cape. So I'm a fit and proper person, and I took a decision to apply for this position, and I believe and I hope that I am ready for a position elevated to the Western Cape High Court bench. I have also served 3 full terms during the course of last year.
You were an attorney for 5 years before becoming a magistrate.
Almost 5 years. I think it's 4 years and
Close to 5.
Yeah,
just under
close to
5.
5 years. That's correct.
And you were according to my arithmetic, you were a district court magistrate for 8 years before you went to the regional court in 2010.
Yes, I was appointed Deputy Chief Justice on the 6th of May 2002 as District Court Magistrate at the Wynberg Magistrates Court.
And you mentioned a wide range of civil work during your stint in the District Court.
Yes.
So you've been a regional court magistrate for 12 years?
If you count my acting period, and I took my acting stint from the date of the Minister of Justice appointment, which was 1 August 2016, that is from the permanent appointment, but I started acting in August 2010, so you are correct. It's, I think, slightly over 12 years now.
All right.
In total.
Okay. You're an alumnus of UCT and UWC.
That's correct. Because I did BA with law subjects, I therefore was only required to do the 2-year LLB at UWC.
When did you start acting in the High Court?
I acted from January, the first term of 2021, first, second, and third terms, the full.
So January until September.
Yes, I think the last day was the 17th of September.
And how many written judgments were you able to produce during that time?
I produced 40 written judgments of my own. I recall, and when I did my statistics for purposes of my questionnaire as well as the upcoming interview, there are 2 judgments. I can't take credit for that. Those are 2 judgments written together with 2 of the senior judges in appeals, so I've not counted that in the 40 written judgments.
But you should, because I would imagine that you participated fully in those proceedings and the writing of the judgment.
All right, thank you for enlightening me, because I wasn't sure if I should add those 2 as well. And I've checked, and my understanding is that in the 3 terms, I have 5 reported judgments.
You know, it has been a bit of a challenge for me to follow your trajectory on the papers, because most of the things are set out in a CV at the back, and the application form, which should actually be where we find all the material stuff, is a bit thin. Now, you have listed 4 judgments which you delivered outside.
Yes.
The 3-month period, but on my count, it was just a period of about 4 months, which is still within, well, not within the norms, but it's still acceptable. But why did you exceed the 3 months?
I'm going to, if I could just be given an opportunity. Deputy Chief Justice, I type all my own judgments, so I use the Dragon the Dragon software. And so I do the typing and the editing all myself. I was fortunate to have two registrars last year, the one registrar for the first 2 terms and then another registrar for the other term. But when it came to my judgments, they didn't type my judgments and edit it. I would type it, edit it, and I would send it to them to do the headings. And with particularly the matter of REDISA, it's the Recycling and Economic Development Initiative versus Tubestone. That was the longest, that was 25 days after the 3 months. And the trustees for the time being of the Birmingham Trust. Those are 2 reported judgments. So I found those, I needed to do quite a lot of research, even though I had very good heads of argument in the matter. They were challenging aspects that I needed to deal with. And the JVE Civils matter, the record was in Afrikaans, it was engineering. So I needed to actually, I sat with Google Translate in certain circumstances. So it has been I suppose, an administrative together with a research aspect. That's why those were delayed. I can also inform you, Deputy Chief Justice, as I've indicated, I think in the one judgment, I indicated in the judgment the reason for the delay right at the end. And in respect of the others, the communication was sent to the respective legal practitioners that there is a delay. So that is the reason. I must also add that I believe in taking responsibility, so I have disclosed all of this in my questionnaire.
You mentioned one reserved judgment in your application form. That would be in the regional court.
No, that was my last High Court matter, and...
Were you still at the High Court in May of 2022? I thought you were there until September 2021.
No, it was a parted.
Oh,
Yeah, it was
yeah.
aparted. I had to go back to the regional court. I think it was the end of last year. And then they filed the heads in, I can't recall, I think it was in April. No, they filed the heads on the 23rd of May. And I was already back in the regional court. So I worked on the matter, typing, researching, etc., while I was in the regional court. And that was delivered. That was also a delayed judgment by, I think, in my letter that I sent this weekend, that was 16 days. It was sorry, not 16 days. It was a 16-day trial.
Yes. You submitted a memo responding to the misgivings some of the
Yes.
law bodies who sent their submissions on your suitability as a candidate.
Yes,
Expressed. Do you want to, well, in the main, being that you still need more acting experience, you don't have nearly enough experience as yet, and the other concerns related to, well, an allegation that you had not shown any affinity, as they call it, to develop
Yes.
young practitioners, and you were accused of not advancing transformation in the judiciary, making controversial judgments against the judiciary, and having a knack for recommending disciplinary actions against practitioners instead of adopting a fair-minded and nurturing approach. Well, you know what they are.
Yes.
Do you want to just take us through your
Sure.
response, but briefly?
Briefly, very
Yes,
well.
please.
So, to start, that I've explained in this letter, which I addressed this weekend, that I'd only received these letters on Monday, the 3rd of October. So the main, I think the main one is the one from, I think there are two letters from the Black Lawyers Association. The first one, they say that I acted for 3 full terms, and at the end of their letter, which is the first one in this bundle, they then come to the conclusion, or they conclude that they are of the opinion that I'm just short of the minimum 3 terms, and that I should be given an opportunity to act, and so they don't support my nomination.
At this stage?
Yes, at this point, they say. So in my letter, I have dealt with it at paragraph A1, where I indicate that I can confirm that I acted for 3 full terms, and I also indicate that, of course, one is invited by the judge president to act. I deal with a variety of cases that I heard, and at the end or conclusion of the second paragraph on A1, I indicate that I delivered 40 written judgments, of which 5 were reported. To the best of my knowledge, none has been overturned on appeal yet, and I indicate there that I am more than ready for elevation to the High Court bench. The second one, which, with the greatest of respect, I found a bit, I don't know, concerning. It's the second letter dated the 29th of August, and that's the second letter in this bundle, and that I have dealt with step by step. So I was very concerned to read that, according to the BLA, they say, according to their observations, I have not demonstrated any affinity to develop young practitioners and advance, advance the agenda of transformation. So on the issue, on their observations, so firstly, I'm a bit unclear because that's not clarified in the letter, and I mean that with the greatest of respect to the BLA. I deal with my experience over 20 and a half years, and I say very specifically that as previously a practitioner from the Cape Flats, so specifically the Athlone area, I did my articles at Legal Aid, so I was a public defender. And I set out, in my view, how I have provided feedback over the years to attorneys. I share law updates. I send amendments of legislation. I provide comment on any relevant cases. And I continue this. This is a continuous practice that I do still to this day. And quite importantly, that I do not need any prompting in expressing encouragement to practitioners. And I've on more than one occasion informed practitioners who I've been particularly impressed with to consider joining the Cape Bar. And some have in fact taken my advice. So years later, people inform me, you know, I used to appear before you in motion court. I would inform them that I'm particularly impressed by their pleadings, whatever, and it's a continuous thing. And when I came to the High Court, I just need to say this. I had in fact received telephone calls from young advocates who had phoned me to welcome me to the High Court. One had reminded me that he used to be an attorney who used to practice, and I had encouraged him to consider going to the bar. And what I then set out is, if I were asked, and you have asked me to be quick about it, but I would be prepared to give very recent examples of where I've done this in the regional court a few weeks ago. So I must...
Well, sorry, when you say encourage, what do you mean? How do you encourage
I mean,
them?
Deputy Chief Justice, I'll need to give you examples. So I preside currently in a civil regional court in the Bellville Regional Court. If I see people who have drafted really good pleadings, who've done an application and have really shown me that they are motivated, they are encouraged to work, and I'm speaking about relatively young practitioners, I feel, and I've always had this view, that they need if I could put it very colloquially, a thumbs up. They're doing a good job, in my view. Whether they ultimately, the matter is, whatever the outcome, I'm not going to tell them on the day. So that is how I have expressed encouragement. I think the BLA uses the word nurture. I prefer to use the word encouragement, because I believe if you have an attorney or candidate attorney, because it's not limited to attorneys, I would inform them.
I suspect the real concern is that you have not mentored anyone.
Well, as a
You have not transferred the experience, the skills you have to the upcoming generation.
Well, I am a magistrate. I'm not sure if I could actually mentor an attorney. What I have done, and I think that comes to the next point, is my involvement in legal education, informally and with SARJ. And where I give back to magistrates, aspirant regional magistrates, my experience, civil, matrimonial law, and this also is a continuous, it's a continuous thing that I do. And I remark at paragraph 3, for example, on my comment page, that I have as recently as I think it's the 22nd of May, I assisted with training in PAL of aspirant regional magistrates. Present at that was in the new Chief Magistrate of Cape Town and the acting regional court president. I think she's currently acting in the High Court. And they had participated in the sense that they were part of the people that I trained on that day in civil and matrimonial matters. So I'm not entirely sure if I can, as a magistrate or regional court magistrate, take attorneys essentially under my wing and mentor them in that way. I have suggested to practitioners sometime that I would contact the Legal Practice Council to maybe hold a workshop or particularly with matters involving, with matrimonial matters. I find sometimes that's a bit of a problem for some practitioners. But this is how I have given back in my own way, and because I was also an attorney.
Well, the concerns raised about judgments you've written against the judiciary and the disciplinary inquiries that you are alleged to have recommended against practitioners, you do not have to address us on those because there are no details. One does not know what they refer to.
Thank you.
And I think that the references to your delayed judgments were covered when I asked you about the 4 you had listed. Well, I think those are the ones to which they refer.
Yes, yes. I had to, of course, in this letter, because the LSSA spoke about 2 outstanding judgments, and I had to, at paragraph B on page 5 of my letter, I indicated that I only had the one. That is the matter of Heinrich versus de Surf, and that is a judgment I delivered in September. I think it's a 52-page judgment on a civil trial. I've just received an application for leave to appeal in that matter, but I have no outstanding High Court judgments, no parties.
And in some, you say you have acted long enough to be permanently appointed.
I would say yes, Deputy
Well, you
Chief.
have sufficient experience.
Yes, I don't know if you wish me to expand but I would say yes, I do.
All right. I'm going to hand over to the rest of the commissioners.
Sure.
Judge President Lope.
Thank you very much, Deputy Chief Justice. I have no questions for this candidate. Thank you.
Thank you, Judge President. Mr. Boshoff?
Thank you, Deputy Chief Justice, and afternoon, Ms. Pangoka.
Good afternoon.
I just have 2 questions. The one relates to the Botha matter.
Yes.
In which that went all the way to the SCA.
Yes.
And involved you personally as magistrate. Would you mind just briefly explaining to the court how it ended up in the SCA and...
Not the court.
Oh,
To the commission.
I'm
Mr.
sorry,
Boshoff.
I'm late in the day. Apologies, everybody. Just to the commission, you know, about the matter and how it ended up in the SCA, and you know, ultimately how your conduct as magistrate was considered and treated.
Very well. Mr. Boso, sorry, Commissioner, it's a long story, so I am going to condense it. Yes. So I was an acting regional court magistrate in Cape Town when this matter came before me. It was a defended divorce. It was a divorce trial. I'm going to call Mrs. Botha was the defendant. Parties were married out of community or property. Mr. Botha was the plaintiff. And the matter, by the time it came to me, if I'm not mistaken, was already a 2008 case. It came to me in 2011. And several postponements had already been granted to Mr. Botha for legal representation. The unfortunate thing was that by that time, every time he has a new legal practitioner. The matter was then postponed. Mrs. Botha was represented by an attorney and an advocate who's a few years ago, an SC. And what then transpired was the matter was postponed several months in advance, about 3 months in advance, and it was postponed final for trial for a period of 2 days. It would run over 2 days. In that time, Mr. Botha had then complained about me to the Department of Justice, I had to address a letter to my regional court president addressing the complaint, and I was vindicated in that complaint. And the attorney in this matter then phoned me and telephonically requested a postponement. I informed the attorney, you need to communicate with the legal representatives on the other side. That was not done. And an email was then sent, which is referred to by the Supreme Court of Appeal. What eventually happened is something I think I wouldn't wish on any magistrate or judicial officer. At that stage, I was already a magistrate for 10 years, and Mr. Botha was advised by his attorney to come to court to read a recusal application into the record and to then leave without participating in the trial. There was no request for a postponement. I explained, I think on 5 occasions, the consequences. I had practically begged Mr. Botha to stay in the courtroom. He was persistent that he's going to follow on his attorney's instructions. I explained all the consequences to him as is set out in the SCA, and eventually he read it into the record, confirming he knows the consequences, and he left the courtroom. I proceeded to hear the recusal, which I eventually, in a longish judgment, I then refused the recusal application. The trial then proceeded in the absence of Mr. Botha, and it followed on to the next day, and still Mr. Botha and his attorney failed to come to court. I gave an extempore judgment. I granted partial forfeiture, and I actually did not grant a cost order against Mr. Botha. The next thing, I was taken on review. There were very scurrilous allegations made against me. My integrity was attacked. My conduct in the court as a magistrate was attacked. And that without the practitioner having regard to the actual proceedings in the court. I made a decision then to oppose the review as a magistrate in light of that. And the matter went to the High Court. And eventually, I think it was 2013, I can't remember when, the review was argued, and the review was upheld, and as you can see, the High Court then granted an order in terms of which Mr. Botha and I were to pay the costs. I then had a cost order against me as a magistrate, and after taking some time to consider it, and during the period of the appeal, I decided that I could not continue with the cost order. I got advice, and the only thing that was left was to petition the Supreme Court of Appeal, which I did, and that was the judgment. So both as litigant and as magistrate, the Supreme Court of Appeal then vindicated me, not only insofar as my conduct in the divorce proceedings, but also in opposing a review, and opposing a review in circumstances where it was reasonable to do so, and I had acted objectively in opposing the review. And that's, this is a reported judgment.
Thank you very much. Then just a final question, a technical question that I ask all the candidates. Could you please just explain to the Commission how you understand what you understand under the appealability of interim orders, and what approach a court should take when either considering an application for leave to appeal of its own interim order or considering an appeal as such?
Am I allowed to look at a judgment where I dealt with this?
You may remind yourself. If you have it right there.
Okay, I have it in the other file.
So we can assume that you don't have the answer off the
Well,
top of your head.
very well.
While you
Strictly-
while you look up the case.
Apologies. Strictly speaking, the interim order can't be appealed. It has to have, an order which is to be appealed has to have a final effect. That would be my answer. I can't at this stage refer to the judgment.
Okay.
Yes. And then just following up on that then, are you familiar with a fairly recent, it's about a month old now, judgment of the Constitutional Court, which dealt with that very question? It's the matter of UDM and another v. Lebashe Investment Group. Are you familiar with that judgment?
No, I must be very honest with you, I'm not familiar with the judgment.
All right, and where the court then essentially moved away from the tests, the strict test of finality, and emphasized the question of interest of justice as being determinative of whether or not an interim order is indeed appealable.
Thank you, Mr. Boshoff. I have to admit, I'm not aware of the judgment.
All right. I have no further questions, DCJ. Thank you for your time.
Thank you,
Mr. Bishop.
Commissioner.
J.P. Mlambo.
Thank you very much, DCJ. Good afternoon, Ms. Pangakar.
Good afternoon, Judge President.
You are still a regional court magistrate, am I correct?
I am a regional court magistrate, correct?
And are you back there? Are you still acting in the High Court?
No, I only acted for the 3 terms from January to 17 September last year, and I wasn't invited to act again.
Okay.
So I am back in my permanent post in the regional.
As we speak, do you have part-head trials in the regional court?
I do have parted trials. I have 5 civil parted trials. I know 2 are coming close to an end, and I have 4 or 5 criminal parteds. 3 of them are coming to an end.
I see. 3 of them are coming to an
Yeah,
end.
in the sense that we are almost done with the defense case. I think the one is actually already postponed for closing argument.
And the other 2?
The other 2, there's one where
How long are they part-head, those 2?
the one is actually a matter where the defense obtained a medical report very late. That I can't speak much about it, but it relates to the accused defense in the matter. And then they had applied to recall a particular witness. I think the accused is in custody for quite some time, but that matter, as well as the other one, wherever I have a gap, I place that matter on my court roll. Even if it's after my civil roll and it's 11 o'clock or 2 o'clock. So Judge President, I can't give you specific times. I'd be lying if I told you, but both accused are in custody.
Why is it at any given point in time, regional magistrates have these part-heads that are long outstanding?
May I just inquire, Judge President, are you speaking about a criminal particularly?
Criminal.
Because I think, particularly in the 2 that I have, the one where there was an application to reopen, that...
I'm not seeking for details of the cases. I'm just trying to explore why we have this situation.
I think because, unlike civil, there are a lot of role players in a criminal court matter. Besides the magistrate, you have the prosecutor, you have the defense attorney, you have, and in both matters, interpreters. The one had a foreign interpreter, and then the witnesses. And specifically with regard to those 2, I get the matters, I find space on my civil role to do it so that we are continuously trying to get to a point where we are going to finalize. And I've recently, in fact, when I come back now, there's a civil trial of mine that has fallen flat. They are settling. And I've requested the prosecutor and the advocate that we heard that parted early in the morning as opposed to 2 o'clock when we would have heard it.
So you say one of the major reasons is because of the number of role players, but even high court judges run criminal trials. But you won't find a high court judge straddling so many part-head criminal trials.
I think what transpired was that I had swapped courts. So I was in a criminal court. I swapped courts with a colleague of mine, and I'm in the civil court. And so it works in the following way, where each regional court has 2 prosecutors. So I can only use the prosecutors when they're not, for example, in the other court. But we have made inroads, and we're trying to squeeze things in, and like I said, we're getting near the end.
Okay.
As far as we possibly can.
Okay, thank you. Thank you, DCJ.
Thank you, Judge
May
President.
I ask for a follow-up on this question?
Yes, Commissioner Matthews.
Look, I'm troubled by your response here.
Sure.
How many criminal cases that are outstanding as part-head matters?
I have, on my last stats, before I went on leave last week, I have 5 criminal parts.
So there are 5.
5.
Out of these 5 outstanding criminal matters, how many of them are the accused still in custody where bail has been refused?
Three. On my recollection, sitting here, 3 are in custody. Bail was refused. In fact, the one did not apply for bail in the district court.
And how long has these matters been outstanding?
Commissioner, may I ask a question of clarity from you?
Yes, I mean, when did you start trial and how long these accused persons have been in jail whilst the matter is not finalized? That's the essence of my question.
I can't give you exact dates when I started each of these trials. That's my first response on that.
Yeah, but that is important to me to determine, to understand exactly. Could it have been 4 years?
No.
3 years, a year?
No.
How old are these
The
matters?
longest one, I would say, started not last year, the year before, so that would make us 2020. And that was because we had started the trial, and there was a change of legal representation more than once.
Yeah.
That was the longest of them.
And whilst we have these matters, pending matters, I mean partly heard matters, in
Yes.
which the accused are in custody, they have been denied bail, you take up an acting appointment out of, since 20, you spend time, was it 6 weeks, where you are acting. What was your plan in respect of these matters when you were acting?
Firstly, every time a term was concluded, I go back to the regional courts for my parterds. And that happened throughout the 3 terms that I acted. So the magistrate who acted in my space while I was acting in the High Court, so that was a district court magistrate, that magistrate went back to her district court. I come back to my regional court. I had no other matters on my regional court roll but my parterds and any new matters and any warrants which came in. So I did not stay in the High Court. That is why I think earlier I mentioned I would work in the regional court and I'd be working on. So I came back every recess period to do my parterds.
CJ, it was with your permission because that to me is very important.
Yeah, please go ahead.
My point is this: you take up an acting appointment, of which you could have just declined because we have matters where accused are in custody. What is your sense of justice and the accused right to a speedy finalization of their matters in circumstances where their bail admittedly has been denied. What is your sense of justice and fairness?
Very well. I'm very cognizant of the accused's rights in terms of the Constitution, the right to speedy trial, the Section 35 rights. And I did what I could do in order to expedite matters, and I'm still doing what I can do in order to expedite matters insofar as these accused are concerned. One of the accused, I think the one who was longest, I had almost insisted, because there was a question about, and I think those are 9 charges, there was a question about whether there would be a new application or an application for bail. And every time, I think on 2 or 3 occasions, when the matter's before me, I'd asked the particular advocate, because he had an attorney and then he changed legal representation, are you bringing a bail application? And they did not do that. So, Commissioner, I am cognizant and I have taken the steps to expedite these matters, have it heard while I was acting, and as I've indicated earlier, so every recess I come back and these things are continuously heard. But it's not only the magistrate. There are other role players as well involved in the matter.
Yeah, I mean, I think this is my last. You see, my difficulty with you, first when JP Mlambo asks you a question, how many criminal matters are outstanding? You don't know. You simply say about 4 or 5. When you ask a question, at what stages are these matters? You don't know. And now you go and take an acting appointment, no clear, when the accused person is in custody, you don't tell us what was happening. I will argue at the end of this, during deliberation, that you have no sense of justice. Everything is all about you. People are in jail, you don't proceed with their matter. All what you do, you go and act. Thank you, Sir.
All right, I hear what you say. I think I have explained myself and expressed myself. I respect your view on it.
Thank you, Commissioner Nokies. Commissioner Marumahai.
Thank you very much, DCG. I'm here, ma'am.
Oh, sorry,
Good afternoon.
Afternoon.
The fact that you are a magistrate leads me to ask a question which I think it is a problem across South Africa. But I've read certain judgments specifically from the Western Cape where judges lament the fact that the reviews, special reviews and automatic reviews, section 304, 305, those kind of sections of the Criminal Procedure Act, when they are brought to the High Court, and then the 2 judges of the High Court refer the matter back to the magistrates with a query for them to clarify certain aspects. And you find that magistrates sometimes they take their time to respond to those queries. And at that time, you find that some of the accused might actually be in custody. But secondly, and most concerning, the responses that are provided back are not satisfactory. In your experience as a magistrate, have you encountered this? First of all, is this a problem at all? And if it is, in your experience as a magistrate, have you encountered this thing? What causes it in line with or having regard to the constitutional rights that are implicated?
So if I understand the question, is it a problem? Firstly, when I acted in the High Court, I myself addressed 3 queries to magistrates in 3 review matters. I did not receive a satisfactory explanation back in respect of 1 matter. And I think sometimes one of the problems is that, and I'm speaking generally, sometimes the question is not properly read within the context of the judgment that is being sent on review, because the judge's query is very specific, and the magistrate is requested to respond to that. So, yes, it is a problem. I encountered it while I acted, that I received something back and it was not actually a response to the question I had asked. Insofar as have I encountered it, if that question is, have I encountered it as a magistrate being queried by a judge? No, I have not encountered it. If the question is, have I encountered it as an acting judge, then with regard to my previous answer, yes, I have as an acting judge queried magistrates insofar as those reviews are concerned. And I agree with you, because you have the accused constitutional rights in the time, and I think there have been quite a number of judgments which indicate that there has to be a speedy response to those judgments. So it is a problem, and I think the problem should be addressed in the sense of this very specific question should be answered.
I guess, let me just crystallize my question. Do you, as magistrates at that level, either at the regional court or district court, in your meetings, discuss this thing? Because if you are having judgments, especially in your province, where judges identify this as a problem, and they express their misgivings about this particular issue, do you, at the magistrate level, have meetings about this and try to make sure that at least you do better, so that the rights of the accused can actually be protected?
I can only at this stage, Commissioner, address you insofar as the regional court is concerned. So I have never been part of a meeting where that is discussed. My understanding, particularly with regard to those automatic reviews, those are matters for the district court. I can't, as I sit here, and I think it would be wrong of me to say the district court has meetings, or they do not have meetings, because I'm not a district court magistrate, so I can't address that.
No, I accept that. It's fine. Thank you very much, DCJ.
Thank you.
Thank you, Commissioner. Commissioner Makonish.
No, thank you very much, Deputy Chief Justice. Good afternoon, ma'am.
Good afternoon.
This side.
Oh, thank you. Oh, sorry.
No, I have only one question for you, because I think I have to repeat it, because I've asked it to other members. What is the difference between in consultation and after consultation?
Sorry, I didn't hear you.
What is the difference between in consultation and after consultation?
In consultation and after consultation.
Yes.
I'm not sure. If it's with reference to legal practitioners, then I think, no, I think if I'm going to respond, I'll probably be wrong.
Can I also follow up, DCJ, on this point?
Yes, Commissioner.
Thank you. I think the point that is really being asked is where a statute says, as an example, the president may take a decision to dissolve the JSC after consultation with the Minister of Justice. Or it says the president may dissolve the JSC in consultation with the Minister of Justice, whether you appreciate any distinction there.
I think it's
all right.
do you mind if I?
Yeah, please, yes.
If it's, the president may take a decision after consultation, I'll start there, then it means that before a decision is taken by the president, that consultation must have happened.
Yes, correct. And then the same statute says the president may take a decision to dissolve the JSC in consultation with the Minister of Justice. How does that differ to the first answer?
I think, and I speak under correction, that would mean that the actual decision has to almost happen jointly.
So in other words, the Minister of Justice must consent. He has a veto.
I don't know if it's a consent. I don't know if I'd go as far as consent, but I would have to say an agreement.
Yes.
I would rather say an agreement, because a consent, in my understanding, would mean, let's say X is saying something and Y is here. X has already made his mind up about whatever it is.
Yes.
Y then consent. So that for me would be, the in consultation would be together or simultaneously, if I could put it that way.
Yes. In almost like in concurrence.
Yes.
Yes, or with the concurrence.
Yes.
All right, well, that's the correct answer, but it's taken us a while to get there, which takes me to another question about your grasp of constitutional law principles. You know, this judgment that you've referred to here in your response, which you said you think the BLA is talking about the Ulu judgment. You remember that?
Yes.
Yes. Now, I'm not particularly interested in the complaint that you referred a practitioner to the disciplinary proceedings. I think a judge is entitled to make that call. So the criticism against you there, I personally think, is a bit unfair. What I do want to ask you, though, about is the jurisprudential logic of the judgment. My understanding of the basic facts there is that you had a BXI, which is the law firm, a corporate entity, and you had Barnabas Xulu, the person. BXI was the first respondent, and Xulu himself was the fifth respondent.
Yes.
That's correct.
Yes.
Now, in respect of BXI, you convicted them of contempt, correct?
Yes.
Yes. Now, in your judgment, you say that even though the order that was imposed by Judge Rogers was an order for the payment of money, a contempt was still appropriate.
If I, without going to the specific paragraphs, there were 6 orders.
Yes.
I made a distinction also about, and
Now let's just focus on the one order
Okay.
for now. That's the order that said they shouldn't allow the trust account to fall below a certain amount.
Yes.
They should keep 3.4 million rands in the account. Your judgment says that's an order sounding in money. But you say that even in respect of an order sounding in money, a contempt is still competent.
do you mind if I get to the page?
Yes, I can take you to the
Thank
page
you.
if you want. It is at paragraph 43, page 107.
Paragraph 43. All right, so that is where I dealt with the law insofar as the orders ad pecuniam solvendam.
Yes, that's an order for payment of money.
yes.
Now, that's the conclusion. Sorry, you want to say something else?
No, go ahead, sorry.
Now, that's the conclusion I want to ask you about.
Yes.
Now, were you at that stage aware of the Kutsia judgment of 1995 of the Constitutional Court, which made it clear that under the common law there is a distinction between an order for the performance of an act and an order for the payment of money? In an order for the payment of money, contempt is inappropriate.
I did not refer to I did refer to, is it Kutsia government versus government of the Republic of South Africa?
Yes. Well, let's forget about Kutsia, that's long ago. Let's take Machabeng, which is a 2017 judgment.
Yes.
The local municipality, where at paragraph 56, it's made clear that the common law draws a sharp distinction between an order ad solvendam pecuniam, which related to the payment of money, and an order ad factum praestandum, which calls upon a person to perform a duty or refrain from an action. And then it says, a failure to comply with the order to pay money is not regarded as contempt in our law, whereas the disobedience of the latter order is. My problem is that you seem to have mixed these principles up.
At paragraph 43, Commissioner, and
Yes,
I'm not sure if
that's
this
where
is,
I am.
I'm not sure if this is responding to your question.
Yes, that's the paragraph I'm saying. It
Yes.
seems to me that it mixes the principles and doesn't refer to the correct authorities.
All right, and where I say I do not understand the common law rule to exclude a declaration of contempt, in brackets I say the civil remedy, where there is willful and mala fide non-compliance with an order for the payment of money.
Yes, exactly, and there's no footnote there. There's no authority at all. And the authority is in fact the opposite.
I refer to the Cape Times Limited versus Union Trades.
Yes, that's at footnote 64. And the actual correct authority is Machabeng, which is the Constitutional Court judgment of 2017. And Kutsie, Constitutional Court judgment of 1995.
Very well. I can only respond as follows. I take your point, firstly, and I've referred to Kutsia and Machabeng at footnote 61.
Yes.
I am aware, when I completed the application, I'm aware that I think leave to appeal was granted to the first respondent, the incorporation. I'm not sure what happened thereafter.
Yes, no, I'm only concerned about the contempt as against the company. I'm not interested in the contempt against the person. That's where these principles are being discussed.
I take your point, Commissioner. I can also say that, because I don't know what the petition was all about, I'm aware that there was a petition to the SCA, and the SCA granted leave to the company, to the incorporation.
Well, yes, sounds sensible.
Yes, further than that, I can't, but I hear what you say. Thank you.
Can I ask you a second question about your grasp of the law of contempt? You see, the problem is that it's foundational to the constitutional system, as the Constitutional Court pointed out in the Zondo versus Zuma case, that you need to grasp the principles of the constitutional law. The other problem I have is paragraph 44, where you find on the preponderance of probabilities that the company is guilty of contempt, whereas it seems that the law is that you must find beyond a reasonable doubt.
All right, then I'm going to, if I can go back in the judgment, where I deal with the legal principles, and I want to find that paragraph.
I'm at 44,
Yes.
It's page 107.
Yes, I'm going to the law which I set out from from paragraphs 18 on. And I just want to find the place so that I can respond to, here we go. So I'm not sure if this is going to be of assistance. If I go to paragraph 21 of my judgment, and that's part of that's the section that deals with the legal principles. I then deal with, I deal with considerations of the judgments Farkey, Feko, Birchall, and then I indicate there that the Constitutional Court in Machabeng clarified the position as follows. The standard of proof must be applied in accordance with the consequences of the remedies sought. If the relief applied for is a declaratory order, mandamus, structural interdict, or similar civil remedy, where the contemnor's right to freedom and security is not deprived, then the civil standard of proof on a balance of probabilities applies. And I refer there to, at footnote 30, Birchall versus Birchall. It's a 2005, I think it's Eastern Cape Division. And in the footnote I said, relief sought was committal to prison for failure to comply with a maintenance order. At paragraph 21, I go further and I say, with the civil contempt remedies of committal to prison or the imposition of a fine are sought which impact on the contemptor's freedom and security of person, then the criminal standard beyond reasonable doubt applies.
Yes, no, I understand that. That's why I also went to look at your order to see if it was a mere declarator. And I found that your order actually imposes a fine on the company, which is a criminal sanction.
Then, and I'm going to stand corrected by you, Commissioner. I have no qualm being corrected because you've referred me to the cases, and then it must be that. Well, let me rather not jump to conclusions. My understanding is that the SCA then granted leave to the company.
No, I understand. I don't want to get into the leave
Sure.
issue. I just want to get your grasp of the principles of constitutional law. Because the distinction you seek, which is where declarator is sought, applying the standard of balance of probabilities may be appropriate, which is correct. But the problem with your judgment is that you actually imposed a criminal fine applying a civil standard. That's again the confusion I'm pointing to.
I can't argue then with you, Commissioner, on that. Yeah, I can't comment further. I will accept what you say.
Thank you, Tisha.
Commissioner,
Thank you very much. Good day, Magistrate.
Good afternoon,
Good afternoon.
Commissioner.
Thank you so much.
it is actually evening.
Almost evening.
my word.
Thanks. I'm going to be brief. You were a member of the Muslim Personal Law Working Group. Is that correct?
Yes, yes.
Do you still get consulted by the group, the Muslim Personal Law Working Group?
No, Commissioner, that was, if you go to the questionnaire, that was only in 2001.
Yes.
It was before I became a magistrate, and it was community work, if I could put it so. So the answer is no, because it was only for that period.
Let me refer to the period when you were a magistrate. Now, as a magistrate, have you ever been involved in a matter that implicates the Muslim personal law in the context of the strong human rights culture embodied in our Constitution?
I'm trying to think now. I don't think so.
You don't think so?
I don't think so. We get Muslim litigants daily, like we get litigants of all races and cultures and religions, but I have not myself been involved in a matter as a magistrate or regional magistrate where the question of Muslim personal law has been involved or has come before me.
Given that, how have our courts been able to manage the tension that exists between the human rights culture I've referred to and the Muslim personal law? Thanks.
I think if I can say the following in response. There's recently been a judgment, I think it was the end of June, by the Constitutional Court, and that judgment is the Women's Legal Center versus, I think, the President of South Africa, and that had to do with the Muslim marriages. So a Muslim marriage does not occur, how can I put this? A Muslim marriage occurs, there is a religious ceremony that happens. And up until that judgment, or at least until the SCA now, the Constitutional Court has confirmed, the Divorce Act and the Marriages Act, insofar as the definition of marriage is concerned, did not recognize a Muslim marriage in that definition. So we now have a judgment which, it doesn't open the doors for every Muslim husband or wife married in terms of Sharia law whose marriage is broken down to come to either the regional court or the high court for a divorce. It has very specific limitations. But what is important about that judgment, as far as constitutional rights and the recognition of Muslim marriages, is that we now have a judgment in terms of which certain sections of the Divorce Act and the Marriages Act has been declared unconstitutional because it excludes a Muslim marriage. And there is a period, I think it's 24 months, for the legislature to make the necessary amendments. But there is, at this stage, a limitation in that judgment, the orders in that judgment allows only specific categories of if I can call it Muslim litigants, to approach the courts. So for me, as a Muslim person, I think we've come a far way, because we now have a situation where hopefully soon we can have people who are married in terms of Sharia who can actually approach the High Court for a divorce and the regional court, because only the High Court and the regional court that can do divorces. And I think it's going to take a while yet, because we have at this stage that limitation in terms of those orders. And I look forward to actually hearing a matter like that, because I do a lot of divorces, and we get parties married by customary marriages. But Muslim people married in terms of Sharia, not in a court, not a civil marriage, have not been able to avail themselves. But now we have this, and I'm very happy.
No, thank you very much for that comment. Thanks, TCJ.
You did very well on the last question, Ms. Pangaka. For a textbook question that just came randomly. I sat in that matter at the SCA, so you got it.
Thank you.
Yeah, very right. Commissioners on the virtual platform?
I'm covered, Deputy Chief Justice. Thank you.
Thank you, Ms. Breitenbach.
Nothing from me, DCJ.
Commissioner Bernard?
No, I say nothing from me, DCJ.
Oh, thank you. Well, that brings us to the end of your interview, Ms. Pangaka. You're excused.
Thank you very much, Deputy Chief Justice and Judges, President, and Commissioners. Thank you for your time.
Are you ready, Mr. Salu? Okay. You hold 2 degrees from the University of the Western Cape, a BA and a BA, well, a BA and an LLB.
Indeed, Deputy Chief Justice.
Which
It's a
was-
BA law degree and then, of course, the LLB degree.
Oh, I see. Well, your application form doesn't say that. It just says BA. Followed by a 2-year term serving articles of clerkship,
Yes, Deputy Chief Justice.
and then you became an attorney.
I served as an attorney for approximately, I think, 13 years, Deputy Chief.
And then you joined the bar, the Cape Bar.
In 1999, Deputy Chief Justice, I joined the Cape Bar.
And that's where you've been until now.
Ever since.
All right. When did you start acting at the Cape High Court?
I sat half term in 2017, 2 terms in 2020, and 1 full term in 2021.
You have not acted this year?
No, Deputy Chief Justice.
All right. How many judgments did you manage to produce during those acting stints?
Deputy Chief Justice, I didn't count them, but there were a number of these judgments of written in
An
trials.
estimate is fine.
Thank you.
You said 12?
No, I said many, but I can't recall how
Oh.
many I'd handed down.
Not even a ballpark figure?
It could be in the region of 20 judgments, Deputy Chief Justice.
And have any of them been reported?
Deputy Chief Justice, I know many have been slotted into SAFLI, but I didn't take it per se to have it reported. I could have, especially with the ones that I quoted, the marine inquiry matter, the inheritance matter, the will testament matter, but I didn't think of reporting them. Yeah.
You mean you did not mark them reportable?
No.
Oh, okay.
I should have, Deputy Chief Justice, but once you have a matter and the allocation is there, you start working on the other matter and you're preoccupied with your role. So, yeah, I should have in hindsight.
Well, the publishers have a knack for finding reportable judgments, even if you have not marked them. So
I take note.
Yeah, if you'd written one that's reportable, they probably would have found it.
Yes.
On average, how long did it take you to produce a judgment after the hearing of a matter?
Deputy Chief Justice, I promptly work on my judgments all the time. I'm a hard worker. I would have gone in, if the need had arisen, to go in weekends. And I didn't delay with judgments because, as a practitioner, I know the outcome is important to the parties. And I think the best and the longest I think I took was about 2 months to hand down judgments.
Okay. What is the JHES, the Janjira, that society, and what does it do?
JHES S1.
Yes.
Deputy Chief Justice, that's a community-based organization that serves humanity in essence. It alleviates, the aims are to alleviate poverty, to assist with needy students, to grant bursaries to them, and that's across the color line. It's not only confined to a specific group. I am heading that society for the past probably 10 years with eminent members of a society. Women are involved in that society. You'd have noticed that there are orphanage committees, There are destitute committees, school, we uplift. We're looking at a multitude of prescripts that we alleviate. If that's in a nutshell, there are monthly meetings. There's obviously also a trust involved. I'm not a trustee of that society, which owns property where there's an income. But by and large, it's a community-based organization, Deputy Chief Justice.
Okay. You are competing with 3 women for this vacancy.
I know.
And you know what...
I know.
Why should we appoint a man? And,
can somebody pour some
one
water
of
for
them.
me, Deputy Chief Justice, before I answer that question?
Well,
Deputy Chief
I
Justice.
see that one of the many people who've written testimonials for you have done a blow-by-blow, memo on why you are better than each of these women. But I want to, I don't know if you align yourself with what she says.
I don't consider myself better than anybody else, Deputy Chief Justice. My application, I believe, should be premised and adjudicated within the esteemed group and commission sitting here on merit, taking into account the transformation imperatives that I embarked upon all my years as a practitioner. Just to answer your question then, I bring about a wealth of experience, practical experience, and that to the bench, no doubt, will be an advantage. The second issue is that I punted women, and this commission would know, to the bench, and I'm heartened to say that many of the nominees that I punted in my personal capacity, not whilst I served on the CBC, on my own, had been appointed to the bench. And thirdly, Deputy Chief Justice, if I look at the GCB's comments, for example, there's a ratio now, and I'm heartened by that fact too, that there are 13 women and 12 men serving the Cape High Court. So the women are on a stronger leg. So in short, I'm of the view that I can bring about the wealth of experience, and if one looks at the constitutional imperative, the bench must reflect gender and the background and racial components of the past. And if I look at the GCB's comments too, there's only one Indian male person on the bench. If you were to appoint and consider me above the women, I'll probably be the second one that will represent the community at large. That's in short. I can elaborate, but I hope I answered your question, Deputy Chief Justice.
No, you have, thanks. I'm just thinking that that court has come far if the women are in the majority now, because when I acted there many years ago, Judge Jeanette Traverso was the only woman in a sea of men. But that still does not absolve us of making sure that women who are in the majority, after all, do get their rightful place under the sun, if it means all the judges in that division must be women. No, maybe I'm taking it too far, I'm just pulling your leg. You were interviewed by this body exactly a year ago, and you did not make the cut. What would you say to us in addition to what you've already said to make sure that this time things go your way?
Yeah.
What magic, what have you done that has enhanced your CV such that we are suitably impressed by your candidature?
Deputy Chief Justice, since the last interview, I've looked at the script and et cetera, et cetera. I remain steadfast to my principles, advancing human rights, dignity, equality, freedom. If you have noticed the beg your pardon, the Swanepoel judgment against the minister, where, for example, a woman had been sexually assaulted, we took that matter on. Woman was my junior counsel. The attorney was was a woman. The second attorney was a woman. So I preserve what I've done up to now, and again I leave it in the hands of this eminent commission to consider whether I am the right person above women. I've given my reasons why I said that the bench will not be impoverished if you were to consider me.
Okay. Well, this is a question that was put to you last time. You are no relation to Judge Salihlothe, are you?
Deputy Chief Justice, the Sali surname is quite prominent in the Western Cape. In the north of our country, this spelling is S-A-L-E-H. In the Western Cape, it comes from S-A-L-I-E. In short, there is no relationship between myself and Judge Sali Shlope. Safe to state that I met her at the sidebar. Then I was a senior attorney, and she started off. And other than that, I have no relationship whatsoever or nexus with Judge Sali Shlope.
Thank you, Mr. Sali.
Thank you, Deputy Chief Justice.
Judge President Shlope, do you have questions for this candidate?
Thank you very much, Deputy Chief Justice. Mr. Sali, just one question. It relates to reported judgments. We as judges, and I'm sure there is no exception, we like to have our judgments reported because they develop the law, and if a judgment develops the law, it is important to have it reported. Now, you gave an answer, and your answer was you moved on to the next work that was allocated to you. Did you not think about getting your judgments reported? If at all they develop the law, because a judgment will not be reported if it just restates the facts and there is no new law.
Yeah. Judge President, you're absolutely correct. For example, the Swanepoel matter, I'm of the view it should have been, and I should have put it up, because that developed the law to the extent that a child was raped. There is the loco parentis relation between the deputy principal of a school and the education department. And I got calls from the north because the education department resisted that claim up to the end. And I'm of the view perhaps that I should have applied my mind to report that judgment too.
Thank you, Deputy Chief Justice. I have no further questions. Thank you.
Oh, my mic was off. Mr. Boshoff?
Thank you, Deputy Chief Justice. I'm just, there we go. Thank you, Deputy Chief Justice. Just before we start, just a declaration. I know Advocate Sali SC from a past life. As an attorney, I briefed him at times, and as a member of the bar, we were both members of the same suite of chambers. But so I just wanted to just declare that.
No, thanks for that disclosure.
Sorry, Commissioner, which chambers? I didn't get that.
No, we shared a suite of chambers when I was still at the bar.
Okay.
Yes.
Do you dispute that, Mr. Sali?
I can't.
You seem unsure.
There's many years ago. Oh, yes, no.
Okay.
I'm very forgettable. It's fine.
I recognize the face now, Commissioner. You're absolutely right. Gosh, I've gone old, or you've become younger. I don't know.
Yeah.
Any questions for the candidates, Mr. Boshoff?
Yes. Well, Advocate Solly, there's a comment made by Nadal in the bundle in the bundle accompanying your application, and I just want to read it to you, and I would just like to hear your response to it because the comment is there. Being 64 years of age, we believe that he is too senior in age for appointment to the bench and would be more valuable as a mentor to younger and incoming professionals. Yeah, I would just like to hear your response to that.
Commissioner, perhaps I should respond. There are two issues to my response. One is, age, of course, brings about experience. I've known the founding father, one of the founding fathers of Nadal. I'm not going to, I can script it down, Deputy Chief Justice, and forward the name to you, who was appointed at the age of either 63 or 64. That's the first response. The second one is, in addition to that, I think this commission, eminent commission, appointed a member of the Cape Bar, again, I shall not disclose the name, I think when he was 63 or 64, as of last year or the year before. So I don't think an age, if the criticism had come, you're 67, 68, then I could understand, because you work up to another 7 years to become 75. The second response is that I think I've got close to 11 years left in my life to make a contribution to the bench, and perhaps to reportable judgments, as the JP has stated. I hope
yes, well,
I answered.
Not just your life, but to the bench at least.
On the bench.
You're
absolutely right. I think.
Yeah, no, thank you very much. Then just a second question that I've asked all the candidates. It's a technical question. Could you please give the Commission your understanding of the appealability of interim orders and what test or consideration you would apply in considering whether or not an interim order is in fact appealable?
Commissioner, immediately comes to mind Section 18 of the Superior Court Act, I think 18.2. I'm of the view, and again, I speak of practice, if it's an interim order, you're going to be blasted by a judge while you're appealing the order. It's an interim, as it states, interim in nature, unless you want to bring that interim order as a matter of course to bring to fruition, to implement it in terms of 18.3. But then there are strict criteria. For example, irreparable harm to the applicant and no irreparable harm to the respondent. And, of course, the test for prejudice. But by and large, the answer would be no. It would not be appealable.
All right.
I hope I answered that question.
Yeah, there's just a follow-on to that, which I've also asked all the candidates, is whether or not you are then familiar with a fairly recent Constitutional Court judgment of UDM v. Lebashe Investment Group, which dealt with the test to apply in respect of the appealability of interim orders.
No, I haven't read. I didn't read that judgment yet, Commissioner.
All right. No, that's it for me.
If I've read it, I would tell you what. But by and large, it seems to me that it's not appealable in terms of my practical experience and pursuant to the provisions of Section 18.2 of the Superior Court Act.
Okay, thank you. I have no further questions, DCJ, and thank you for your time, Advocate Sali.
Thank you, Commissioner.
Commissioner, Professor.
Thank you very much, DCJ. Good evening.
Good evening, Professor.
I'm always fascinated when I hear particularly experienced practitioners, when they speak about human rights and how passionate they are with human rights generally. In South Africa, there is one sort of, and I think also it qualifies to be a human right of some sort, which I think has been neglected. The assistance of black practitioners, especially females, at various bars, for them to be able to get the opportunities that white men in particular and other black men also find, where they are able to, at an early age, and I'm talking about white men and some of the black men, at an early age, they are able to be dragged as juniors to the Supreme Court of Appeal, to the High Court, to the Constitutional Court. They are exposed to opportunities. But we see that there is a constant struggle in relation to black women generally, but black women in particular, that when they have to come and compete for positions like this, most of them cannot rise and say, I have all the experience in the world that makes me stand out. I just want to ask you, in your practice, what have you done, if at all, to ensure that you assist black women in particular in the matters that you have actually been briefed on? And I'm not only saying you guiding them or training them or whatever, I'm talking about getting a junior, relying on your junior to ensure that you can actually trust the junior to do the work and you guide strategically the litigation. What is it that you have done in that regard to solve what I think is a human rights issue in South Africa?
Professor, you are absolutely correct. It is a human rights issue because women in the past had been discriminated against. There's no doubt, particularly black women. It is so. Now, as I'm sitting here, Professor, be rest assured, in advancing the basic tenets of dignity, equality, and empowerment, I have handpicked, I have sourced them, and to the extent that I even paid to the George High Court, I would pay their air tickets and hotel expenses. You would have noticed S versus Parker, the VAT fraud matter, which I dealt with before 5 judges in the SCA, where, for example, the NPA decided to prosecute, and where the person pleaded guilty to fraud, and 113 was applied. I went back to the match court, I applied for 113, I got it, I got leave to appeal. It went to the, before JP's jurisdiction, from there to the SCA. We got leave. In fact, the NPA got leave because we won before the 2 judges on appeal. There I took a black male. I'm not talking about a female, but I took a black male. I paid his expenses. And it wasn't, I need not tell you this, really. I mean, what my right hand does, I don't want my left hand, but the question has been posed, and I want to let you know that I have done it in the past. Paid the expenses, air tickets, accommodation. I was just fortunate that I won on a point of law and I recovered all this cost. So yes, to answer you, there's not only this woman or this male, generally, they would walk into my practice, last since 2 weeks. They walk in, particularly an issue was discussed in court between this black female and the judge, and I gave her advice. I sat with her an hour. It's not only getting and tagging them around and appear in court and later say, I've appeared. There are other issues how you can empower black women. And I can assure you, I say it with any fear of contradiction, with an open heart that I have done my level best as I'm sitting here up to now, Professor.
Thank you very much. Thank you very much, DCJ.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, DCJ. Evening, Advocate Saliasi.
Yes. Good evening, Commissioner.
I'll just ask one question. I'm happy already we have touched what you have done since the last time you were interviewed up to now. Mine is in relation to the last interview. probably now, if you can look back, I think you've done your homework fairly well about the last interview.
I hope I did, Commissioner.
Yes. Anything that you think you might not have done yourself some good justice in terms of responses, then that you might want to do some different reflection about it?
Yes. Deputy Chief Justice, there was an issue raised that I became annoyed, and that you probably referred into that, and openly and frankly I'm raising this, because as in courts we raise this issue up front. So yes, I raised the issue last time, and I said, I made the point that in the absence of factual basis, like when women and men apply for silk, there's an opportunity been given, there's an adverse comment, please respond to that cogently, rationally, and reasonably in the circumstances. And that wasn't done, but I took to heart. Upon deep introspection, I can assure you, since then, I'm even concerned to raise a frown for that matter. So yeah, I'm here, and although it's not been raised by the GCB in the current application, I'm heartened by that point. They are of the view that I'm suitable, and it seems to me that given at the end they say, having served humanity, it should get some recognition. But that's in the eminent decision of yourself. I hope I answered the question, Commissioner.
Even though I was not referring specifically to that, but to the entire interview. You remember Commissioner Todovu asking you about issues of transformation?
Yes, I recall that.
You think you have done yourself?
Yes, Commissioner, I've got a revolving door, and all the black practitioners know that, and disadvantaged ones know that. They can come in anytime. If there are disciplinary issues, I've headed the bar's disciplinary portfolio many years. I've written an abundance of reports on ethics, clearing certain, and I'm talking about eminent members of the bar, and they come in with no problem. If I'm sitting with the matter, I put it one side, because I know I can rise 2 o'clock in the morning and draft heads of argument. So that practitioner who comes in there, the disadvantaged one, they are close to us. We must empower them. We must make the contribution to empower them so they can become the 27th, 28th, 29th member on the bench of the Western Cape High Court. I hope I answered you, Commissioner.
Thank you, Advocate Salesi.
Thank
you,
you.
DCJ.
Thank you, Commissioner. Commissioners Bredenbach and Bernard, do you have questions?
Nothing from me, DCJ.
Well, I'll take Commissioner Bredenbach's silence to mean no. Mr. Sali, we don't have any more questions for you. This is the end of your interview. Thank you so much for joining us this
I can only thank you, Deputy Chief Justice, and all justices and presidents and all commissioners for having granted me this opportunity. And I'm not going to waste another breath here, because I would catch my flight. I've just been heard that boarding pass has been given to me. I hope I'm not going to miss it. Thank you so much, each and everyone, for their contributions here.
Safe trip back to Cape Town.
Thank you.